What urgency? So, intimated, correct. Give it Monday. Urgency anilla kodi. Monday it will come according to seniority. Give it. So what? Bail ತಗೊಂಡಿಲ್ವಾ? Bail ತಗೊಂಡಿಲ್ವಾ? ಬಿಡಿ. Good. Yes. Next. Monday ಕೊಡಿ. Monday ಬರುತ್ತೆ ಅಂತಿಲ್ಲ. ಯಾವತ್ತು ಬೇಕಾದ್ ಬರ್ದು ಕೊಡಿ.
Monday ಅಂತಿತ್ತಲ್ಲ ಕೊಡಿ.
Okay, give it on Monday. Bail ತಗೊಂಡಿಲ್ವಾ? Framing charges ವರ್ಗೂ ಹೋಗಿದ್ಯಾ? Give it, ತೊಂದರೆ ಇಲ್ಲ. Give it, yes. ತಗೊಳ್ಳಿ. So? No, 2:30 ಏನು urgency ಇಲ್ಲ ಬಿಡಿ ಕೊಡಿ. No. So what? Give it, yes. 2:30 ತಗೊಳ್ಳಿ ಇರಲಿ. Fresh matter. Give it, yes. Then senior citizen bail ಅಲ್ಲ ಇದು, bail court ಅಲ್ಲ. Okay, give it. No, not 2:30. Give it, yes. No, it will come, sir. Monday ನಿಮ್ಮ ಮುಂಚೆ ಕೊಟ್ಟರೋರು ಇದಾರಲ್ಲ. Yes. No problem. ಏನು ಚಿಂತೆ ಇಲ್ಲ ಕೊಡಿ. Very good, sir. Sub-registrar should appear before the police. ಏನು ಚಿಂತೆ. No problem. Nothing. Your egos are hurt. Nothing will happen. ಏನ್ ನಿಮ್ನ ಅರೆಸ್ಟ್ ಮಾಡ್ತಾರಾ? ಸಬ್-ರಿಜಿಸ್ಟ್ರಾರ್ ಅರೆಸ್ಟ್ ಮಾಡ್ತಾರಾ? ಮಾಡ್ಲಿ. We'll take it on Tuesday, sir. ಪರವಾಗಿಲ್ಲ ಕೊಡಿ. Tuesday ಕೊಡಿ. No. Wait. We're not coming? Yes. Pending matter. Tuesday ತಗೊಳ್ಳಿ. ಥ್ರೆಟ್ ಆಫ್ ಅರೆಸ್ಟ್ ಏನಕ್ಕೆ? ಬೇಲ್ ತಗೊಂಡಿಲ್ವಾ? ತಗೊಳ್ಳಿ. ಬೇಲ್ ತಗೊಳ್ಳಿ ಸರ್. ಬೇಲ್ ಆರಾಮಾಗಿ ಸಿಗುತ್ತದೆ, ತಗೊಳ್ಳಿ. No problem, sir. Take secure bail. Secure bail, sir. Monday ಕೊಡಂಗಿದ್ರೆ ಕೊಡಿ. I can't assure you because ನಿಮ್ಮ ಮುಂಚೆ ಕೊಟ್ಟರೋರು ಇದಾರಲ್ಲ, ಕೊಡಿ. Yes. ಯಾವತ್ತು ಬೇಕಾದ್ ಬರ್ದು ಕೊಡಿ. Why warrant issued? Why warrant issued? Why warrant issued? How second or third? Why warrant issued? Not gone to the court. ಕೊಡಿ ತೊಂದರೆ. Yes. Not 2:30 ಕೊಡಿ. So what, sir? Violation of law will not, sir. No, sir. Yes. It will come Monday. Seniority ಪ್ರಕಾರ ಬರುತ್ತೆ. ನೋಡೋಣ ಕೊಡಿ. ಕರೆಕ್ಷನ್ ಯಾಕೆ ಏನಾಗಿದೆ? ಅಲೋಡ್ ಅಂತ ಆಗಿದೆಯಾ? All right, give it. Being spoken to Monday. Give it. Fresh matter ಎಲ್ಲ ಕೊಡಿ. ಇವತ್ತು ಅಂದು ತಗೊಳಕ್ಕಾಗಲ್ಲ. ಕೊಡಿ ತೊಂದರೆ. No problem, sir. Give it, sir. 19th ಯಾವತ್ತು? 19th is long. 19th is we'll see. ಕೊಡಿ. It will come. Fresh matter seniority ಪ್ರಕಾರ ಬರುತ್ತೆ. ಸರ್, ಈಗ ನಿಮ್ ಮುಂಚೆ ಕೊಟ್ಟಿರೋದು ತಗೋಬೇಕೋ ಬೇಡ ಸರ್? ಅಲ್ಲ, ನಿಮ್ ಮುಂಚೆ ಕೊಟ್ಟಿರೋ ಮೆಮೋಸ್ ಪೆಂಡಿಂಗ್ ಇರೋದು ತಗೋಬೇಕೋ ಬೇಡ ಸರ್? ಏನ್ ಮಾಡೋದು? Yes. Give it, sir. Give it, sir. Even if it is large urgency, I will not, sir. 498 is urgency. Surgery where? Petitioner yaru? Mother-in-law na? ಆಯ್ತು, ತಗೊಳ್ಳಿ ಮೇಡಮ್. ಸರ್ಜರಿ ಇದೆ ಅಂತ ಹೇಳಿ 2:30 ತಗೊಳ್ಳಿ. ಟೇಕ್ ದಟ್ at 2:30. Yes. Fresh matter. Why?
The executive of the NT company. Police are going with the warrant and it's a hit by 155.
Why?
In violation of that, the FIR and the charge sheet has been filed. You were never given it. They are-
Good.
police told
ಏನ್
you-
ಅರ್ಜೆನ್ಸಿ ಏನಿದೆ? ಪರವಾಗಿಲ್ಲ, ಮಂಡೇ ಕೊಡಿ. ಮಂಡೇ ಕೊಡಿ.
22 madam. Vacating interim order. I have moved.
ವೆಕೇಟಿಂಗ್ 22 ನನ್ನ ಮುಂದೆ ಬರಲ್ಲ ಸರ್. ಬೇರೆ ಕೋರ್ಟ್ಗೆ ಹೋಗ್ಬೇಕು.
Your lordship would recollect.
ಅದು 13th ಹಾಕಿದ್ದೀನಿ. Please, I was about to tell the court officer to inform you that Mukul Rohatgi ಸರ್ಗೆ 13th ಅಂತ ಹೇಳಿ.
Your lordship, in that matter, your lordship would recollect, I had made an interim application that the son of the nephew of the
ಗೊತ್ತು,
and asked for 10 days interim. Your
ಗೊತ್ತಾಯ್ತು.
lordship may consider it today afternoon.
ಟುಡೇ ಎಲ್ಲಿಂದ ಬಂತು? ಅವತ್ತೇ 12th ಹಾಕಿದ್ದೀನಿ ತಾನೆ.
But that is now getting to 13th. The entire
Next
thing will
day.
become frustrated.
Next day.
The marriage will be over, my lord, and it's very embarrassing scenario in the family.
No.
The lordship may only to that limited extent may consider it on Monday.
ಮಂಡೇ ಇಲ್ಲ ಸರ್, ಟ್ಯೂಸ್ಡೇ. ನಿಮ್ 12th ತಾನೇ ಇದ್ದಿದ್ದು. ಆ 12th ಇಂದ 24 hours ಲೇಟ್ ಆದ್ರೆ ಏನಾಗ್ಬಿಡುತ್ತೆ?
Now the point is then the whole thing is marriage would be, because I was
ಆಯ್ತು, ಲೆಟ್ ಇಟ್ ಬಿ ಆನ್ 12th only. It will anyway appear on 12th. 12th ನಾನು ಅದನ್ನೇನು ಅಡ್ಜಸ್ಟ್ ಮಾಡಿಲ್ಲ. ಅದರ್ ಮ್ಯಾಟರ್ಸ್ ಆರ್ ಆನ್ 12th, 13th. This will come on 12th.
that limited extent I went over the.
No, let it come on 12th. 12th ಕೊಟ್ಟಾಗಿದೆಯಲ್ಲ ಡೇಟ್. You are satisfied with 12th that day? Yes.
From Chandigarh.
Fresh pending. ಏನ್ ಅರ್ಜೆನ್ಸಿ ಏನು?
420 had put it. It's a invoice escorting case. Although the police have gone to Chandigarh to arrest. Unfortunately for us,
230.
Madam, 498 years. Said, my lord, there could for charges. My lord, I request you should not accept charges. Quotas for Monday, kindly 230 lakhs.
ತಗೊಳ್ಳಿ. 230 ತಗೊಳ್ಳಿ ಶಂಕರ್.
That's the end of the list, my lords.
Wait, pending matter. Give the memo. No date. Yes.
That's the end of the list. That's the urgency is that, my lords, learned sessions judge, after taking cognizance, that's without issuing summons. directly
ವಾರಂಟ್
issued
ಇಶ್ಯೂ ಮಾಡಿದಾರಾ?
Warrant issue.
ಕೊಡಿ 230. Yes.
230 minutes.
Wait. Yes.
Lots of memo lordship.
Give it, madam.
Listing lordship. It's
If I give a date, in one case for pending matter, every pending matter I have to give a date. No.
lordship, it's basically
We'll
a
post it by on seniority. Interim order ಇಲ್ವಾ?
lordship,
Ah,
11/9 ಗೆ ಬಂದಿತ್ತು, but
Interim
we
order ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ, ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ? Yes.
find a date may be given lordship.
Madam,
lord-
interim order ಇಲ್ಲದೆ ಇರೋದು seniority ಮೇಲೆ get it posted on all other days, not Monday.
My lords, it's a fresh matter. Under section 528, the FIR has been registered 4 years post facto. The basis on which the FIR has been registered, the documents were uploaded on a public website being the MCA portal. Now there's
Now, what's the problem?
your lordship, there's an inherent looming threat over the arrest threat
Why
over
you
the
not take
petitioner. my
secured
lords.
bail?
No, my lords, there's no arrest that's happened yet. We've received a notice the next day after the FIR has been registered. We've duly complied. My lords, just 2:30 if you.
No,
can
no,
hear
no.
us.
Monday or Tuesday it will come. Yes.
My lords,
no
Monday at
urgency.
the latest.
Give it. Yes. Settlement ಕೊಡಿ. Settlement memos ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. ಯಾವತ್ ಬೇಕು ಅದೆಲ್ಲ settlement memos ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. Yes.
Society matter, not a criminal case has been filed only for the reason that, my lord, the membership has been taken contrary to the bylaw. And
So what?
what has happened, my lord, the anticipatory bail also got rejected.
No problem. Give it, no urgency. Yes.
My lord.
No, sir. Give it, you give it. Yes.
My lord,
Yes.
Matter was posted on 30th, my lord.
ಏನಾಯ್ತು?
It has not come, my lord.
You are not there.
No sitting was there.
We have ಎಲ್ಲ ಬರ್ಲಿಲ್ವಾ ಮೇಡಮ್? ಎಲ್ಲ ಪೋಸ್ಟ್ ಆಗಿದೆ 30th ಇಲ್ಲದೆ ಇರೋದು. We'll see. Yes, next. Give it Monday. ಏನ್ ಮಾಡಿದ್ದೀರಾ? ಏನ್ ಮಾಡಿದ್ದೀರಾ?
Case of
Criminal appeal filed by the.
Your colleague.
Filed by the accused came to be dismissed for non-prosecution. On the memo filed by the.
Good. 230. Yes.
Two matters were connected.
230 ಕೊಡಿ. Yes. ತಗೊಳ್ಳಿ. Being spoken to ಹಾಕಿ ಮೇಡಮ್. Being spoken to ಹಾಕಿ. ಅದು ತಗೊಳ್ಳಿ ಮೇಡಮ್, ಯಾವ್ದು ಟೈಪೋಗ್ರಾಫಿಕಲ್ ಎರರ್. ಮಂಡೇನೆ ಇಟ್ ವಿಲ್ ಕಮ್. ಎಸ್.
These summons which is being issued. the petition.
Despite a stay granted, you tell the government advocate, stay yavralide anta. And don't move it, you tell the HCGP, yes. Vacating stay, give the memo. Give the memo, yes. Should I take it today? Then we'll fix it, wait. Monday agala, sir. Tuesday or Wednesday it will come. It will come, yes.
Date ಕೊಟ್ಟಿದ್ದ.
Nim mistake. Monday. Monday, yes. Being spoken to God. Memo ಕೊಡಿ sir. Memo ಕೊಡಿ sir. ಏನಲ್ಲ ತೊಂದರೆ ಇಲ್ಲ, so what? ಕೊಡಿ. Give it, take the memo. Post it on some day, madam. Friday or Saturday ಹಾಕಿ 23rd. ತೊಂದರೆ ಇಲ್ಲ ಸರ್, ಕೊಡಿ. We'll see, sir. Don't. 79, 80 ಯಾರು ನಿಮ್ 10 years imprisonment ಕೊಡಲ್ಲ. So wait, don't project pseudo urgency. Yes. ಎಲ್ಲದರಲ್ಲೂ ಒಂದೇ ರಾಗ. Yes. Extension. Why extension? Why extension? Till that date. ಅದು ತಗೊಳ್ಳಿ ಮೇಡಮ್, ಯಾವ್ದು? Yes. 2:30 ತಗೊಳ್ಳಿ. ಬರುತ್ತೆ, ಕೊಡಿ. Give it, yes. ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಇದ್ರೆ ತಗೊಳ್ಳಿ ಮೇಡಮ್. Give it. Give it, no problem. ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ, ಕೊಡಿ ಮೇಡಮ್. I can't take 200 matters every day, madam. Give it, yes. Vacating stay memos, please give. No problem, give it. Proclamation issue ಆಗೋರ್ಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? No problem, sir, give it. No problem, give it, sir. ತೊಂದರೆ ಇಲ್ಲ, ಕೊಡಿ sir. Monday or Tuesday it will come, yes. Give it, pending matters. Give the memo, madam. Give the memo. No date in pending matters. Give the memo. No date, madam. So what? Withdraw ಮಾಡ್ತಾ ಇದ್ದೀರಾ? Then give the memo. No date, sir. Give it. Pending matters ಎಲ್ಲ ಕೊಡಿ. No date, sir. Give it. No date. Give it. Yes. Give all the memos. Give. ಕೊಡಿ ಸರ್. ಮಂಡೇಲಿ ನಂಬರ್ ಆಗಿದೆಯಾ? ಬರುತ್ತೆ, ಮಂಡೇ ಬರುತ್ತೆ. ಡೇಟ್ ಇಲ್ಲ, ಬರುತ್ತೆ, ಕೊಡಿ. FLW ಇಶ್ಯೂ ಆಗೋರ್ಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಸರ್? ಏನ್ 20% ಕೊಟ್ಟಿಲ್ಲ ಅಂತನಾ? ವೇರ್ ಇಸ್ ಇಟ್? ಮೆಮೊ ಎಲ್ಲಿ? ನೀವೆಲ್ಲ ಆನ್ಸರ್ ಪೇಪರ್ ಒಟ್ಟಿಗೆ ಕೊಟ್ರೆ ಗೊತ್ತಾಗಲ್ಲ. ನಂಬರ್ ಕೊಡಿ. 2:30 ಹಾಕಿ ಅದು. ವೈ? What were you doing for all these years? No, all these years you knew part payment was made when the proceedings were initiated. All these years ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? You yielded, sorry sir. What were you doing for 2 years, 3 years? ಏನಿಲ್ಲ. Now the moment client comes to you, grave urgency. So I should accommodate. Well, there is total laxity on the part of the litigant. Why should you? Give it, ತೊಂದರೆ ಇಲ್ಲ, ಮಂಡೆಗೆ ಕೊಡಿ. Not of that. So what, sir? So what? Give it, yes. Yeah, ತೊಂದರೆ ಇಲ್ಲ, ಕೊಡಿ. ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? Let him complete his problem, madam. ಆಯ್ತು, ಕೊಡಿ. Give it, sir. 2:30 ಕೊಡಿ.
The offense is 304A. Charge is taken for 302. My charge sheet, my discharge application is rejected on the ground that.
When was it rejected?
In August or October, I filed.
Monday.
The interim order has been passed. The stay of FIR is there.
You are for the respondent.
Yeah.
Huh? What do you want?
We want date next week. We're engaged.
Huh?
We want date next week. Because
Pending or fresh matter, madam? Pending, give it, yes, no date.
my lord,
No interim order cases will be posted according to seniority, give it. No, madam, I'm not giving date in pending matters.
Your Lordship,
Madam, all pending
Lordship.
matters were in, 1 minute, interim order is not there. According to seniority, 30 matters hakta hogu.
fresh matter, 22nd, I've moved a memo.
No problem, give it, sir.
Kindly on. Day,
It will come, sir, number ಆಗಿದ್ರೆ ಬರುತ್ತೆ.
number ಆಗಿದೆ.
ತೊಂದ್ರೆ ಇಲ್ಲ, ನಿಮ್ ಮುಂಚೆ ಮೂವ್ ಮಾಡಿದಾರಲ್ಲ ಬೇಕಾದಷ್ಟು ಜನ, ಅವ್ರದ್ದು ಬರೋದ್ ಬೇಡವಾ? ಬರ್ಬೇಕು ತಾನೆ? Wait,
This is pending matter.
withdrawal ತಗೊಳ್ಳಿ,
Pending matter.
give sir, ಕೊಡಿ.
Seeking the transfer of the case to JJ petitioner in the custody.
ಅದು ಪೆಂಡಿಂಗ್ ಟ್ಯೂಸ್ಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ ಹಾಕಿ ಅದು ಬಿಕಾಸ್ ಈಸ್ ಇನ್ ಕಸ್ಟಡಿ. ಎಸ್, ಅಡ್ಜನ್ಮೆಂಟ್ ಇಲ್ಲ, ಒಂದು ಮ್ಯಾಟರ್ ಇಸ್ ಕಾಲ್ಡ್. ವಿಡ್ರಾಲ್ ಹೇಳ್ಬಿಡಿ ಯಾವ ಸೀರಿಯಲ್ ನಂಬರ್ ಅದು.
Lordship recollects, confirmation order date is not mentioned in the entire petition also, my lordship is referred as provisional order. They were to find the best.
ವಾಟ್ ಎವರ್ ಮೆಮೋ ಹಾಕಿದ್ದೀರಾ, ಮೆಮೋ ಪ್ರಕಾರ ಮಾಡಿ, ಅದು ರೀಚ್ ಆದಾಗ ವಿಲ್ ಡೂ ಇಟ್, ಯು ನೀಡ್ ನಾಟ್ ಬಿ ಪ್ರೆಸೆಂಟ್. ಹಾ ಕೊಡಿ, ಅದು ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ತಗೊಳ್ಳಿ. ಗೆಟ್ ದ ಡಿ. ಎಸ್
Serial number 55.
wait sir,
Lord.
wait. All complaints are false, tell me what is it. Give it, no problem. So by whom, by police, you have not taken bail. Then what is the urgency? Good. Monday or Tuesday it will come, give it. Yes, call the cases now.
No, serial number 55. Lord.
No adjournment in the morning, sir.
For the petitioner in this case, my lordship.
That too, sitting in the office, never seek adjournment, yes.
For the petitioner in this case, my lordship, the offense is 498 AM, my lordship. Except the husband, all
ಅಲ್ಲ,
other.
ಏನ್ being spoken to ಯಾಕೆ? Being spoken to?
ಅದೇ ಸ್ವಾಮಿ, ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಎಕ್ಸೆಪ್ಟ್ ಹಸ್ಬೆಂಡ್ ಮಿದ್ದೋಗೆಲ್ಲ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ವಿ ಸ್ವಾಮಿ. ಬಟ್ ಆರ್ಡರ್ ಮಾಡುವಾಗ ಓನ್ಲಿ ಫಾರ್ ದ petition number 2 and 3 ಮಾತ್ರ ಸ್ಟೇ ಇದಾಗಿದೆ.
Oh, 4, 5, ಇಷ್ಟೊಂದು, all of them are there. ಎಲ್ಲರಿಗೂ ಆಗ್ಬೇಕು. This court on 28/10/2024 had passed the following order. In fact, this court had directed an interim order to be granted qua all other accused except the husband. Therefore, the interim order so granted on 28/10/2024 stands modified by grant of an interim order to all the accused except the husband till the next date of hearing. Yes.
Next matter, still number 2.
Petitioner, my lords.
For the respondent, my lords, I'm seeking some time to file my objections.
3 occasions they have sought time. That
My-
they will file objections.
I'll file my
I'm relying on
objections,
the
my lord.
citation of this honorable court. Very directly, Somya, Aditya Kankaria.
I am instructed that there are some settlement talks also ongoing, therefore,
Seriously.
please, my lords, I'm
The suit
requesting.
filed by
to
them has been dismissed. The civil suit has been dismissed.
ಆಯ್ತು, ಅಬ್ಜೆಕ್ಷನ್
Nothing
ಹಾಕಿ,
is-
ಒಂದ್ ಡೇಟ್ ಕೊಡ್ತೀನಿ. ವರ್ಡ್ ಜಡ್ಮೆಂಟ್ ಯಾವ್ದು ಕವರ್ಡ್ ಕೊಡಿ.
Aditya Kankaria ಮತ್ತೆ A. Mohan, my lord's judgment. Civil dispute. Ashish Tiwari. And moreover, that Priyanka case, my lord,
ಪ್ರಿಯಾಂಕಾ,
where Priyanka Srivastava,
Ah.
where
not
one
complete.
year has not been taken. Straight away, your PCR file ಮಾಡಿದ್ರು. Straight away issue notice. No sworn statement, nothing has been recorded, even otherwise.
Let her file her objections. Heard the learned counsel appearing for the petitioner. The learned counsel representing the respondent seeks 10 days time,
2 weeks, my lords.
2 weeks time to file statement of objections. Objections, if any, by 5th of December, 4th of December 2024. List the matter at 3:30 PM for further hearing.
Same,
Interim order ilva?
it is
Interim order extended, yes.
2.2.
Yes, 3.
Number 3.
In this matter, I'm filing IO papers, investigation office. sorry,
Ah.
paper,
Make that
That
page 212.
Kodi, I have papers. Yes, madam.
Page 212.
212.
please.
You are the father. Husband?
No, this is, your
Pokso
lordship,
ಇದೆ ಇದರಲ್ಲಿ?
correct.
Ah.
This is a family dispute.
No, allegation is,
Allegation of, is also of POCSO, but there are other sections too. This is entirely a family dispute, which I'll take your lordship to the family tree. This is to show how this is a counterblast which I'm coming before your lordship. Page 212 is our FIR.
212.
12.
All right. You have filed a synopsis or something?
I
Nothing?
can do that, your lordship.
All right, yes. No. Tell me. Vacating stay there.
Please, 212, your lordship.
Yes.
The lordship may kindly see the date and the time. Time is 7:10 PM.
7 PM.
7:10, your lordship. 7 they say.
ಠಾಣೆಯಲ್ಲಿ
7:10.
ಠಾಣೆಯಲ್ಲಿ ವರ್ತಮಾನ ಸ್ವೀಕರಿಸಿದ ದಿನಾಂಕ 7 ಗಂಟೆ 22:05. 20:05 7:10 incident.
So this is our complaint which we have given. As against, at next page, your lordship. The first accused, who's Narayana. These are all interstate brothers and all of their disputes. So this is the person who has handwritten the complaint which is before your lordship.
All right.
Your
So what?
lordship may kindly see the next page.
So what?
Lordship may come to. Page 216
ಯಾರ್ದು?
and 218. 218 on 21/5, lordship will see. Santosh, who's also from our side, part of the family, has given this complaint on 21/5 in the first half of the morning, which they given NCR at 218.
Your complaint.
Please. What happens is that they barge into the house, they push down one of the brother's wife. That lady at page 216, your lordship may kindly see. Later in the evening, the very same day on 21/5, she gives her complaint. On the top, it is same 21/5. But your lordship may kindly turn the page below. Kindly see.
22:05 7 PM.
It's been turned, the 22, you'll kindly see that is 21, which has been changed to 22.
All right.
This is to suit and bring their complaint in.
All right.
Now, your lordship at page 212 demonstrated it's 7:10 PM, which is our FIR finally. Lordship may kindly turn to page 14. 16. This is the complaint given by them, which is what the FIR, which is before your lordship. This is at 7:30 PM. 20 minutes after our FIR is registered, this FIR came to be registered.
All right.
Now I'll come to the main facts of the case. Your lordship, in her FIR, kindly read her complaint, page 18.
Page 18.
18 and 22, your lordship, her main complaint is at 22. The last line in the first, at page 22, Nanna Tandaya from there, your lordship. Lordship may kindly see page 23. First line lists out all the names. And that they attempted to kill them. There is no allegation of rape or any of those things.
ನನ್ನ ಮಗಳನ್ನು ಎಳೆದಾಡಿ ಮಾನಭಂಗ ಮಾಡಲು ಪ್ರಯತ್ನಿಸಿದ್ದಾರೆ.
That is one line that is there.
All right.
Then they say that they ran away in an auto, all of that. Now your lordship had called for the 164 statement. I don't know if they got it today.
It's here.
Please.
Yeah.
Your lordship, the 160, this complaint, your lordship may kindly see the previous page at 22. This page 20 is written by that same Narayan, who is the uncle who is responsible for this entire dispute all along. As I had also mentioned, your lordship, this is as a result of the Honorable High Court's order, which is at page 122. Lordship, I kindly see page 122 with this, which is the writ petition.
My order.
No. Your Lordship, in this civil dispute, very briefly, all of them are grantees. Several rounds of litigation where they're sold, it reverts back to them, then again sold. Then some of the people whom they had sold to had approached the court stating that they are purchasers. What this honorable court ultimately said was that whoever it's been sold to, you compensate all of these people an X amount so that whatever land is left over, let them all distribute it amongst themselves. In this, your Lordship has observed this particular Narayan who had already received amounts from them, yet this honorable court said, all of you divide the amount.
Now you have registered some crime against them. That's correct.
Please.
This is also correct.
No, this has been filed as a counterblast. Now, your Lordship, with respect to POCSO.
164 statement is very, very clear. I've seen. I just now saw it. If what crime you have registered on a particular day's incident is correct and those offences have emerged, crime registered by them also needs to be investigated. Why your crime only should be state?
Your Lordship, if it is an obvious attempt at their part, your Lordship, constantly, your Lordship.
We don't know, madam. Now, there is 164 statement, there is a complaint, investigation is, investigation charge sheet agilala.
Page 230, 231, 241, your Lordship.
It may be a civil dispute, it may be a dispute in the family that is not a license to assault or sexually harass someone.
There has been no sexual harassment or assault. The videos, all of them are very clear in our statement itself, wherein they have come, broken everything and entered into
Madam,
the house and
it is a
created.
maze of facts. It requires investigation at least.
I understand, your Lordship,
Then,
but
yes.
your Lordship, but POCSO will not arise. Even if your Lordship is to see, kindly see the sections.
No, the victim's statement is here. She's 17 years old.
She's
She's
18 now,
17
your
years.
Lordship.
That's a different thing. 17 is what is said. You contest all that.
No. Your Lordship, might I take your Lordship to the sections under POCSO? Whether that would be applicable in this matter, your Lordship may kindly see. The sections that have come up, your Lordship, 11 and 12.
Okay.
Section 11,
Mm.
person who is said to have committed, utters any word or makes any sound or makes any gesture, exhibits any object or part of the body,
Correct.
that with the intention that the such word shall sound be heard or gesture or object or part of the body be seen by the child, makes the child exhibits his body or any part of his body, shows any object to a child in any form of media or pornographic purposes, repeatedly or constantly follows or watches or contacts a child, that is also not there, threatens to use in any form of media, real or fabricated depiction, electronic.
Offense is not 11 and 12, it's 8 and 12.
Your Lordship, may kindly see page 16, your Lordship.
8 and 12.
Sexual assault, your Lordship.
Huh?
There is no sexual assault either.
It is 8 and 12.
Your Lordship, even if we have to go aggravated and leaving aside 7, even if I am to go to 8, your Lordship may
No,
kindly
that's-
see whether the
Madam,
160.
that is, this is a crime. 8 and 12 of POCSO is alleged. The statement is, who is Santosh? First petitioner. ಸಂತೋಷ್ ಎಂಬುವನು ತನ್ನ ಕೈಯಿಂದ ನನ್ನ ಬಾಯಿಯನ್ನು ಮುಚ್ಚಿ ನನ್ನ ಸೊಂಟವನ್ನು ಹಿಡಿದುಕೊಂಡು ಮುಂದೆ ತುಂಬಾ ಇದೆ. Statement 164
Lordship, if
of the victim.
I'm to read 8.
How will I disbelieve this?
No. It's not about disbelief, your
And if I
Lordship.
don't disbelieve, how will I entertain the petition?
Under what section it is come under? I'm not saying that the entire FIR.
It's an FIR. Charge sheet ಅಲ್ಲಿ ಡ್ರಾಪ್ ಮಾಡಬಹುದು, ಬೇರೆನೂ ಆಡ್ ಮಾಡಬಹುದು.
Your Lordship, whether at prima facie, whether.
Prima facie it is there.
Your Lordship, that doesn't even come within the purview of POCSO.
Madam,
None
POCSO,
of the allegations
POCSO
made.
cases when it is alleged, we will not quash it.
Your Lordship, in one statement, she says they push me down. Another statement, she just said they made it.
No, that is 164 statement is here of the victim, madam. Push me down ilve illa. ಕೈಯಿಂದ ಬಾಯಿಗೆ ಮುಚ್ಚ ಅದು ಇದೆ ಇಲ್ಲ.
No. So there itself, there is a contradiction. She says that in this is pushed down. 164 statement, whether that push down is there, it is
Madam,
not.
I cannot disbelieve this statement under 164 of a victim.
Complete contradiction.
That's a different thing, madam. I can't disbelieve this statement straight away unless it is put to evidence. It's a POCSO case, madam.
whether there is sexual harassment or
Madam, what do-
aggravated sexual.
No, no,
assault.
what do you call this act?
If at all, if it were to be taken.
No,
to
that
be,
is the statement.
also
Should it not be evidence
354 only, your lordship.
against a child? Against a child, where is 354? It is POCSO only.
Your lordship, but then if it is under POCSO, it should meet the requirement of 8 and 12, which they have.
Not at this stage. Not at this stage. You want me to answer, I'll answer.
Your lordship.
The
if there-
offense is under POCSO. I have seen the 164 statement. You may have dispute within the family. That is not a license to assault. And it is never a license to behave like the manner in which this accused number 1 has behaved with the child.
Your
That's
lordship,
all.
in fact, in this advocate's clerk, advocate's brother and advocate's junior, all have been dragged in. Ultimately, they were left out of the FIR after the commissioner's intervention. All other cases by the very same person, all of them have still cases pending against them. This is a natural, format that this person seems to follow all along. And he's getting away with it all the time. And now he's realized, your lordship, he even attempted at SC/ST. Then he realized all of them are SC/ST, so he did not know what to do. All of these attempts, ultimately, he's left before this girl turns 18, which he already has turned 18, make full use of that. And this was a counter blast. Your lordship, if they are able to file and register an FIR on POCSO, exactly after my FIR is registered, which from the previous day I have been continuously attempting, we are giving them room to develop upon their complaints and then register, and yet face the
There is a
trial.
complaint, offense is under POCSO and 354,
Sir,
506. And the matter is at this stage of.
Elderly people in their.
No, these are,
family, your-
that's all right. That's not a license for all this.
It's
I don't know
not.
we don't know what has happened. It's only a complaint.
But then would 8 and.
No,
12
I am,
apply itself would be the
simple question, madam. If the incident has happened,
Incident didn't happen. In what?
then why
incident?
did you
It was
why
our-
did you register a complaint?
Please, your lordship.
If incident has not happened, why did you register a complaint?
Our incident occurred. What they are claiming never occurred. That's a fabrication to counter ours.
That I cannot decide.
Your lordship, even the police trying to turn this into 22nd, where 21st is written. Kindly see how the police have also manipulated. And your lordship, they're vacating IA application, they kindly see.
Mm.
How they did not serve us one page conveniently, and after mentioning that page came to be added on.
Mm.
That page, your lordship may kindly see, which was attached later. Page 3 of their vacating IA. Kindly
No,
find
what
it.
becomes of that page?
The allegations, kindly see. Say about after the 8th line in page 3.
ಯಾವ್ದ್ರಲ್ಲಿ vacating stay application?
Please. Which they pull out and serve us, and after mentioning, it's given to us later.
ಯಾವ ಡೇಟ್ ಏನು? IA 2 of 24.
IA 2 of 24, please.
ಅದ್ರಲ್ಲಿ ಏನ್ ಕೊಟ್ಟಿಲ್ಲ?
Line 9 or so, your lordship, page 3.
Page, government ಅಲ್ಲ. Page 3.
Document page 3, your lordship.
Document ಅಲ್ಲ. Paragraph 3, or what are you reading? Page 3 is paragraph 3.
They have not numbered also. The
Document 3, na?
that they attached along with it.
All right. Document 3.
Please,
Huh.
the last 2 pages.
All right.
3 in that.
Huh.
Kindly read from after the 8th line or so. Dinanka 18 from there.
ಪೋಕ್ಸೋ ಕೇಸಿನ ನನ್ನ ಮಗಳನ್ನು ಮಹಿಳಾ ಅಧಿಕಾರಿ ವಿಚಾರಣೆ ಮಾಡಿದೆ ಪುರುಷ.
Further down, your lordship, about the others. Last few lines. sir. Lordship, they don't want to spare even the advocates now, even even juniors joining this advocate's office in view of the fact that this is the
Advocates are accused here.
now ultimately after mentioning that was removed. Complaint had all of their names, the brother's name, the clerk's name.
Complaint doesn't contain their names. I don't know what they are. The complaint doesn't
Your
contain their
lordship, I
names.
find I'll take the lordship to where the FIRs. are.
Even 164 doesn't contain their names. Complaint
230,
contains.
31 to 41.
Not this case.
Even in this case, I had already mentioned, your lordship, after speaking with the commissioner, then the lawyers were taken out. Otherwise, it was still mentioned. These, all the other facts are still continued. This lawyer represented all of them put together, even with up to the High Court. When it was settled, he's refusing to hand over certain plots to the other brothers and sisters, and that is how this is arisen. The first line of the complaint itself reflects, your lordship. 164, she might say something else.
Madam, it is simple. You have registered a crime on the day's incident. They have registered a crime on the day's incident. They may have registered it next day or 2 days later.
They claim that it was an incident that occurred 4 days earlier, your lordship.
All right, that is not fatal anyway.
It starts with that there is a civil dispute. Kindly see the complaint
So
itself.
maybe, madam, your incident also started with a civil dispute only.
And we are not trying to, your lordship, tomorrow we can also have a FOXO against any of those people. That is not the-
Definitely, no problem.
Your lordship, then it cannot, when it's obvious that it is a counter blast, your lordship.
Not in a case of POCSO, madam. Any other case I would have
Lordship,
definitely heard.
1812 would not apply at all.
That's,
354 at best, your lordship, even.
madam, against a child, 354 barala, 1812 barada.
I understand, but 8 and 12 is not applicable, your lordship.
Charge sheet, they may change to something
They will
else.
definitely take a call.
Your lordship, at least an observation to that effect, your lordship, that.
No, you
whether-
want me to
whether-
pass orders on merits, I will pass. Not a problem at all, but not today. I will post it on Tuesday and pass.
Please. Please.
On merits, will pass.
Please.
Anything else you have to say, sir?
It's 160, the complaint, as my learned friend said, there is no allegation against any of the lawyers. Complaint is very specific against the named persons in the complaint itself. The receipt of the complaint at that time is not in dispute. The question of somebody else intervening, names being let out, these are all, it's a telltale story, which is not forthcoming from the records. Now, so far as the investigation is concerned, it is progress substantially or probably come to an end. 164 statement is recorded where it is clearly indicative of the fact that there is a sexual assault. But matter requires to be investigated and taken to a logical conclusion, considering the fact of the object with which the POCSO Act is coming to existence.
In the complaint, she says she fell down, she bruised. None of that in the 164. 164 will not say any of those.
Well,
And then the brother fell down. At one breath, she fell down and hurt herself. Another breath, the brother fell down and hurt himself.
We'll see. Once, yes, heard so and so reserved.
Great.
Tuesday.
Tuesday will pronounce. Tuesday or Wednesday will pronounce.
Please.
Yes.
Or
The offense under section 380.
Correct.
Four, bro.
Pujari
the
connection.
Allegation is, Lord, the complainant's husband was, when he was in jail. Lord, the accused number one was, had a conversation. And she voluntarily.
Who is
had
the
given-
complainant?
Complainant is the wife of one convicted prisoner.
Ashok Pujari,
Yes, bro.
correct?
Yes, bro.
Yes.
And conversation.
One HCGP, 2 emergent notice.
So far as A2 is concerned, there is no allegation,
No,
Lord. The
let's
amount
see.
was given.
Let's see, yes.
Fine.
JJ,
JJ,
huh?
it's acquittal. The allegation.
ಯಾವ
against
acquittal? JJ board.
the JJ board acquittal as against the JJ board, my lord. It's a major allegation as against that accused. And these are the CH lady, my lord.
JJ board's acquittal does not inspire any confidence. You come to the charge against, charge frame ಆಗಿದೆಯಲ್ಲ ಈಗ?
That's why today.
Today, let it be framed.
One moment, can you see?
Yes, sir, please. Several moments will give you. Tell me.
Page number.
Hmm.
There is a dispute between the families for the civil dispute. And kindly see the death postmortem report.
Yes.
It's a natural death. They make use of that natural death. They created a story and filed this false cover.
So I will in 482 see whether it is a natural death or you have killed them, killed him or her, whatever it is,
As per the doctor.
and quash the proceedings.
Doctor report.
No, doctor report is sacrosanct that I take it, it should not be put in evidence. Should it not be put in evidence?
Page number 109.
Yes, sir.
That too is, they are admitted that my lord in the JJ board, saying that's a my lord, he's having
Will get acquitted, buddy.
because it's a age petition number 3, my lord. Petition, She can't move. Even all family members is falsely implicated. Petition number,
Sir,
Three.
falsely implicated ಇರ್ಲಿ. You come to the allegation now. Page 40 ಬನ್ನಿ. ಇದು ಬೇರೆ ದಿನ ಬಂದು ನಾನು ಓದಕ್ ಟೈಮ್ ಇರ್ಲಿಲ್ಲ. Yes, come to page 40.
40.
That is the complaint. ನಿಮ್ಮ ಲ್ಯಾಂಡ್ ಬಂದಿದ್ದಕ್ಕೆ ಎಳೆದು ಹೊಡೆದಿ you have, and JJ board ಬಂದು ಹೋಗಿದ್ದು, your child which was 17 years old so went before the JJ board. He is acquitted. That acquittal will not inure to your benefit at all. You are all adults who have assaulted the child, the victim.
Victim assault ಮಾಡಿದ್ದಂತಲ್ಲ.
ಯಾರಿಗೆ ಗೊತ್ತು?
He assaulted the other members. He saw that person's and he has
Whatever.
it's a heart ailment.
No sir, come ಬನ್ನಿ ಇಲ್ಲಿ. ದಾರಿಗೆ ಹಾಕುತ್ತಿ ತಿಳಿಸು, ನಾನು ಸೋಡ್ಸು. Come to page 41. ಯಾರು ಮಾಡಿದ್ದಾರೆ ಅಂತ ಇದೆ. ಆಮೇಲೆ
ನನ್ನ ತಾಯಿ ನೋಡಲು ದಾರಿ.
Come to page 59. The juvenile was accused number 6, correct?
Accused number 3.
Accused number 3 na?
Please.
Accused number 3, he is acquitted.
He is acquitted. It's a major allegation as I can say, accused number 3. And finding.
Surprising that all adults are shooting from the shoulder of a juvenile
No.
who has been acquitted on
Kindly see
those
the judgment
grounds.
of the juvenile court.
Correct, ನೋಡಿದ್ದೀನಿ.
Judgment of the
I
juvenile.
have seen. I will not follow that.
And they admitted in the cross
And
examination.
what is that you have accepted the juvenile board's judgment, which does not inspire any confidence? It's a case of 304.
In fact, the constitution of the juvenile justice board verdict is totally in violation of section 4 of the juvenile
Then
justice
what are
Act.
you doing?
No, we are going to challenge, my lord. The copies itself were not given until the
ಇದು
court.
ಬೇರೆ. Board the
They're
biggest
taking
problem.
advantage saying it is
The
confidential. and-
classified document ತರ, defense document ತರ they
Yeah,
behave.
there's one provision, they're taking advantage of that provision to not give copies. We have asked to apply for certified copies of the whole proceedings, my lord. Also, the juvenile justice board
See,
has to
aim
deal
of
with the
aim
matter
of the
within.
juvenile should not be made known to everyone. That is the only rider.
Yeah.
That doesn't mean that proceedings should not be given or this.
And
no,
even
sir.
even the 6-month timeline, my lord,
ಇದೆಲ್ಲ ಏನಾಗಿತ್ತು, ಯಾಕೆ ಅಡ್ಜನ್ ಮಾಡ್ತಾ ಬಂದೆ ಅಂದ್ರೆ I had no time to completely read the.
yes.
I will
Now
put
I
the
have seen.
evidence on
My-
evidence.
my
Copy
lord-
my lord, place before.
My lord,
the
I may kindly submit. There is a 6-month timeline. It has to be done within 4 months and an
Forget
extension.
about juveniles.
That is 1.5 years, my lord.
No, you
And
forget- you
the
forget
doctor has not been examined there at
Oh,
all.
forget about juvenile. I
Yes.
am not following.
It's unconnected.
Closing this. Period, sir. I am not following and closing it.
My only.
No,
Because I will produce the entire evidence copy.
whatever you want to produce,
Evidence-
let the court, you want, I'll adjourn it by 4 weeks, but this will not come in the way of framing of charges.
Yes. Yes.
There is no ground to interfere at all.
There are clear-cut allegations against accused 1, 2, even 3 and 4, 5, 6.
Can't move, ಅದೆಲ್ಲ ನೀವು bail ಹೇಳ್ಕೊಳ್ಳಿ, not here.
They've hit the vital parts, the head, the chest,
That is the
even the
allegation.
groin area, and then the others have held them. It is prima facie
Anything
case.
else?
In fact, it is sought to be diluted, my lord. It is a case of murder, not culpable homicide.
I am permit to withdraw the.
Is there a finding I will give? What is the allegation? And I will say juvenile justice board's judgment is not binding
It is not binding,
on that court.
it's violating.
If you want, I will do that.
Section 4, my
Permit to
lord.
withdraw the.
It's violating section 4, my lord.
This
They
is
have no powers to give that.
grave allegation. ಯಾವ್ದು 230 ಮೂವ್ ಮಾಡಿದ್ರಿ, ನಿಮ್ಮ ನಾಳೆ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ, ಬೇರೆ ಕೋರ್ಟಲ್ಲಿ ಮ್ಯಾಟರ್ ರೀಚ್ ಆಗ್ತಾ ಇದೆಯಾ?
The way those proceedings have been conducted, my lord, even whether he really is a juvenile is also in.
No, don't worry. He is thinking bitre ಸಾಕ್ತಾನೆ ಈಗ. Counsel for the petitioner what do you? After arguing the matter at length, seeks leave of this court to withdraw the petition and urge all the contentions before the concerned court at the appropriate time. Submission is placed on record, petition is disposed as withdrawn.
Grateful, my
Yes. Two not seven.
207, my lord, non-complaints of 206.
May I, my lords?
ಹೇಳಿ.
207 3B. Section 207 summons page 51, my lords.
Yes.
Page 51 is the summons issued. The summons is issued by the regional director to the two directors
Hmm.
at their address.
Hmm.
Now that address, it is already known to them, is incorrect.
ಏನ್ ಅಡ್ರೆಸ್ ಪ್ರಾಬ್ಲಮ್ ಕಾಪಿ ಬಂದಿಲ್ವಾ ನಿಮ್ಗೆ?
Bandilla, admitted by them.
The reason is this.
ಅಲ್ಲ, ಒಂದ್ ನಿಮಿಷ. If
Please.
they have not been heard and an order is passed, redo it.
In fact, when the
your
court notice was issued to me, I requested that summons may be once again issued. I'll attend to it.
So what?
And section 20 of the Companies Act provides that the communication to the officer of the company should be made by the company. They didn't do it.
Now the contention is, you have communicated to a particular address where the company was not there.
Well,
And
the
you-
company was the
Director-
directors.
Directors were not there. And the directors, where the directors are there, address you knew is what he's saying.
For a moment, my lord, the address given was, my lord, if
Now,
you
ಈಗ
lordship. Now,
we will
flat
assess the
number
address.
three,
ಒಂದ್ ನಿಮಿಷ, ಯಾವ address sir?
The show cause notice is issued to the correct address. Show cause notice
Page.
at page 59. Page 59 is the show cause notice for initiation of prosecution.
Which address, sir?
At page 60, my lords,
All
bottom.
right.
Serial number 2, Visakhapatnam address.
ಯಾವುದು?
Page 60,
ದಿಲೀಪ್ ರಾಜ್
Dilip Raj
Bukela.
Bukela,
ಹಾ.
the second address is the one that is,
ಫಸ್ಟ್ ಅಡ್ರೆಸ್ ಏನದು? ಕಲ್ಯಾಣ್
ಅದು
ನಗರ್.
ಹಳೆ address, which was returned.
That is the issue, my lord.
That is the
Your
address
lordship
to
may
which
kindly
someone
see
was
the
earlier
first
issued.
address, flat number 3, first floor, Hennur Bande, Kalyan Nagar.
ಆಯ್ತು. ಅಲ್ಲ, ಎಲ್ಲಿ ಇದು ಈ ಅಡ್ರೆಸ್ ಇತ್ತ ನಿಮ್ಮ ಹತ್ರ?
ಆ ಅಡ್ರೆಸ್ ಇರ್ಲಿಲ್ಲ. ಆ ಅಡ್ರೆಸ್ ನಮಗ್ ಸಿಕ್ಕಿದ್ದು, that was on,
No, sir. 1 minute, Shanti Bhushan.
please,
ಈಗ there is one Kalyan Nagar address of the same man.
please,
There is one address at Visakhapatnam. ವೈಜಾಗ್ ಅಲ್ಲಿದೆ.
please.
ಇದಕ್ಕೆ ಯಾಕೆ ಕಳಿಸ್ಲಿಲ್ಲ ನೀವು?
That address was given to us on 4/2/2021.
4 to
2021. If your lordship may kindly see, I'll just
1 minute.
pass
4
on the dates.
ಅಲ್ಲ, 4 to 2021.
Please, my lord.
This is prior to the issuance of the show cause notice.
Please.
Show cause notice ಅಲ್ಲಿ both the addresses you sent. Why you did not send this? Show cause notice came to this address only?
Yeah, show cause notice came to the Visakhapatnam address, which was duly responded to.
All right, 1 minute. And where is the order passed now?
No order is passed, my lord. Directly prosecution complaint is filed.
Reason?
For the reason that section 207 subsection 4 is violated and he needs to be prosecuted, both the directors.
Now what address are you wanting now?
I am
What-
right now, the correct address is in the petition as well.
All right. Now show cause notice reply ಕೊಟ್ರಿ.
Court way.
ಆಮೇಲೆ what communication you want?
I only asked in the show cause notice, first of all, that 207 subsection 3 envisages
IT
a
Act
disobedience.
ಅಲ್ಲ, Companies Act.
Companies Act. 207 subsection 3 envisages a disobedience. For me to disobey, I must be in the knowledge of the summons, and then I can disobey.
Which summons are you talking of? This 207 proceeding summons?
Yes, my lords.
All right. This is now sent where?
It is sent.
Chennai, Tamil Nadu. So what is this Chennai, Tamil Nadu?
Chennai is my address to which the summons was issued. They have sent it to multiple addresses. Chennai is this address to which the summons was issued.
So this you did not receive this?
No, I did not receive it, which is acknowledged by them in the complaint itself.
Where did they get this Chennai address?
That was the old address. That was the old address. Subsequently, that address was vacated and new address was, he was shifted to the new address.
New address, my lord, under section, on Rule 12, he should have communicated to us.
You knew it, sir. Show cause notice ಕೊಟ್ಟಿಲ್ವಾ? Show cause notice ಕೊಡ್ಬೇಕಾದ್ರೆ ಗೊತ್ತಿತ್ತು ಅಂದ್ಮೇಲೆ ನೀವು how did you communicate this summons to a different address?
For a moment, my lord, I'll just,
And even otherwise, it
I'll
remains,
just,
my lords.
just,
ಆಯ್ತು, dates ಕೊಡಿ ತೊಂದ್ರೆ.
please, my lord, I've just have the dates, my lord.
You reissue summons and
Your lordship may kindly see, my
continue
lord.
the proceedings.
I'll be
I
obliged.
just read the dates, my lord, 6/10/2017, my lord, report by RD, my lord, that is the registrar, my lord, stating that the company of the franchisee of QNet has allegedly cheated the public, my lord. On 14/2/2017, Ministry of, my lord, directed inspection of the company under the section 2065. 13/7/2018, inspecting officer was appointed, my lord, accordance with the directions of the central government. On 7/8/2018, my lord, after the a letter was issued by the company informing about the inspection and directing to keep all the documents and the papers readily available for inspection. Note. My lord, I'll straight away come to 12/12/2018. The inspecting officer issued preliminary finding letter to the company during the course of inspection. On 7/1/2019, company sought additional 10 days time. Your lordship may kindly see, the company sought additional 10 days time to submit its reply to the preliminary finding, but no reply was given to the submission of the inspection report. 25/1/2019, inspection report submitted by the inspecting officer. Inspection report forwarded by the RD to the ministry. On 4/4/2019, instructions by the ministry to the registrar to conduct re-examination regarding certain violations and block the DIN. That is on
Companies Act
4/4/2019.
Hmm.
Please, my lord.
21.
On 16/5/2019, my lord, the petitioners
Hmm.
were disqualified under section 164(2) of the Companies Act.
Hmm.
21/10/2019, during supplementary, my lord, here comes, my lord, during supplementary inspection, summons under 207(3)(b) of the Companies Act
Hmm.
was issued to the petitioner to appear before the IO on 6/11/2019.
Hmm.
Summons issued to the director were returned as left.
Hmm.
This was the earlier address, my lord.
Correct.
Therefore, my lord, on 2/9/2020, a supplementary inspection report submitted by the IO. On 4/2/2021, new residential address of petitioners were communicated to the,
All right. So from 4/2/2021, you knew the address,
please.
correct? ಆಮೇಲೆ 31/5/21, based on the supplementary report, ministry directed ROC for prosecution for violation of 2074.
Please.
Regional
Then the prosecution, the show cause notice again for violation of 274. Where did you send it? 9/9/2021 to the new address,
Please, my lord.
to the new address,
To the new address.
correct? And this notice,
Reply to the
a
show cause-
reply also is given.
Please, my lord.
Then on,
That is not satisfactory. Therefore, my lord, 207.
therefore 207, right? Now 207, notice where do you send? Because that is the allegation.
If your lordship may kindly come to 207(3)(b), my lord.
And even in the complaint you have filed,
Please.
if you see, the summons were returned undelivered with postal endorsement left, correct? Left. Amele he has communicated the new address. It's a case of prosecution. Why all this, till up to a point, you are fine. They have bungled, they have erred or whatever it is. But when it came to the brim, you should have definitely communicated it. Address ಗೊತ್ತಿಲ್ಲ ಅಂದಿದ್ರೆ communicate ಮಾಡಿಲ್ಲ ಅವರು ಅಂದಿದ್ರೆ you accept communication. You have to, ಈಗ ಮತ್ತೆ ಶೋಕಾಸ್ ನೋಟಿಸ್ ಕೊಡಿ, ರಿಪ್ಲೈ ಕೊಟ್ಟಿದ್ದೀರಾ?
Reply ಕೊಟ್ಟಿದ್ದೀವಿ.
ರಿಪ್ಲೈ ಕೊಟ್ಟ ಮೇಲೆ ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅನ್ಸ್ಯಾಟಿಸ್ಫ್ಯಾಕ್ಟರಿ ಅಂತ ಆಗಿದೆ. But from the stage of summons in the 207 proceedings, you have to start. I'm not quashing everything. From that stage, you reserve liberty to do it.
Please.
Because it's violation of principle natural justice.
Yes, my lord.
He should receive summons. ನೀವು ಯಾವ್ದೋ ಅಡ್ರೆಸ್ ಕೊಟ್ಬಿಟ್ರೆ ಕಂಪ್ನೀಸ್ ಹಾಕ್ಬಿಡಿ, ಇಲ್ಲ ಇಸ್ಕೊಳ್ಳಿ ಬೇಡ.
Lord, that would violate the rule 12(1) of the Companies Act.
Now, what is rule 12(1)?
Your lordship may kindly see, my lord,
Now, 207(4) proceeding is summoning and enforcing attendance of persons and examining them on oath. If any disobeys the direction issued by the registrar inspector shall be punishable. So disobedience is 207(4). Disobedience will spring only when he has received it and disobeyed it. If he has not received it, where is the question of disobedience? Rule 12 ಏನು ಹೇಳಿ?
rule
ಅದನ್ನು
12, my
ಬರೆಯಿರಿ.
lord, the one more ground which my learned friend has raised, that, my lord, the company is to be not made party. Lord, it is only for the director.
That I am not entering into at all. That all other contentions will be left
12(4)
open.
12(4) of the company's appointment of director rule 2014. Lord, the shifting of
Appointment of
director rules 2014.
appointment remuneration. 2014.
Please.
Manager, appointment of directors, 2.148. ಇದರಲ್ಲೇನು rule 12?
Rule 12(4).
12?
12(4), my lord. 12(1) and 12(4), my lord.
One moment. intimation of changes in particulars.
Please.
Huh.
That-
Every individual allotted so and so shall intimate the change to the central government within a period of 30 days of such change.
Please,
All right.
Lord, if it were, he had to change the address, he had to intimate us.
You have received the communication, sir.
Thereafter, my lord, initially, my lord, his address was,
When addressee left on the band mele, he has communicated it to you. Rule 12 has been complied. Violation in Agal. See, you punish them, but punish them after hearing them.
Yes, my lords.
Your Lordship,
Without
observe-
hearing it, can't be. I'll answer that also.
Please, please.
And one more fact, my lords, on 15th of December 2018, similar summons was issued by the regional director at the very same address, which was also returned as address left. Despite that, they issue once again the summons to the very same address.
All right.
When section 20 of the
Why
Companies
fight
Act,
shy of issuing summons already? Adralli, what is big, we are not acquitting him of anything. Hear him and pass out such summons. See, more so because 207(4) proceedings is initiated for disobedience of summons. If summons has not reached, where is the question of disobedience? I'll give this.
please, my lords.
Both the matters, huh?
Both the matters, identical,
Both directors.
identical, both the directors.
The petitioners in both these cases are directors of Vihan Direct Selling India Private Limited. Is Chinese saida?
Yeah, Chinese are
ಏನಲ್ಲಲ್ಲ?
they are into, absolutely not,
China connection ಏನಿಲ್ವಾ?
absolutely not.
Scheme.
Not even, not Ponzi scheme.
All right. The direct ones. They are knocking at the doors of this court in these petitions, calling in question initiation of proceedings under section 207(4) of the Companies Act 2013. Heard so and so. Facts in brief, germane, are as follows. The petitioners, the company is into what business, sir?
The company is in the business of direct selling.
Page, if your lordship may kindly turn to my objections, my lord, para 5, last line, my lord,
Objections ಹಾಕಿದ್ದೀರಾ?
please, my lord. 26/9/2000.
ಇಲ್ವೇ ಇಲ್ಲ ಇಲ್ಲಿ. Yes.
Para 5, last line, and my lord, para 6, line 1.
That's not relevant. Not relevant, my lords.
One minute. Petitioners ಏನ್ ಮಾಡ್ತಾರೆ ಅಂತ?
Multi-level marketing and running a Ponzi scheme, my lord. It is at.
That is not
para
the
5,
business.
Pledge,
line 3, my lord. Para 5, line 3.
That is not the business of the company, my lords.
A report emerges against these petitioners on 6/10/2017 by 6/10/2017 alleging that the petitioners are a franchisee of QNet and has allegedly cheated public, which formed the basis of ordering of inspection. Proceedings since then have gone on against the petitioner by exchange of reports or communications. It is unnecessary for the issue in the list at this juncture to travel throughout the issuance of notices or reports against the petitioners. As the petitioners are before this court on a short point that they were not served with the summons and therefore proceedings under subsection 4 of section 207 could not be initiated for disobedience of the summons by the competent authority. Authority na ಏನದು? By the
By
court,
the regional director. Inspector.
by the,
Inspector is the correct word.
1 minute.
Inspecting officer.
By the inspecting officer. Therefore, it would suffice if the story is fast forwarded to 2020, i.e. to 2/9/2020, which the date on which the supplementary inspection report is submitted by the inspecting officers. Hitherto, to the date aforementioned, communications were being sent to a particular address of the petitioner, the petitioners, the directors of the aforesaid company. On 4/2/2021, when the proceedings were pending against them, a new residential address of both the directors were communicated to the Registrar of Companies, Karnataka. This is ostensibly in compliance with Rule 12 of the rules. On 31/5/2021, based upon the supplementary inspection report submitted by the inspecting officers, the ministry directed the regional director to file prosecution against these petitioners for violation of section 207(4) of the Act. Therefore, emerges the prosecution against these petitioners for violation of section 207(4) of the Act. After the prosecution, a show cause notice comes after the permission for initiation of prosecution. The show cause notice comes to be issued to these petitioners on 9/9/2021. This is sent to the old address and the new address. The petitioners reply on 22/9/2021. The reply is found to be unsatisfactory, and a complaint is complaint in CC 12 of 2022 for violation of 207(4) of the Act is filed by the ROC before the Special Court for Economic Offences. The our summons issue madidra?
ಅವ್ರು ಸಮನ್ಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರು ಅದಕ್ಕೆ ರೆಸ್ಪಾನ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಿ ನಾವೀಗ.
The issuance of summons by the Economic Offences, Special Court for Economic Offences is what has driven these petitioners to this court in the subject petition. The learned counsel appearing for the petitioner would contend with vehemence that the change of address was communicated to the ROC Karnataka, and based upon the communication, show cause notice comes to the changed address. Reply is submitted, but summons thereon does not come to the by the inspector rather. Summons thereon by the inspecting officer / the competent authority does not come to the petitioners as it is communicated to the old address. If old address, he would contend that if show cause notice can be sent to the new address, it is presumed that they are aware of the new address and summons is not sent to the new address. The disobedience cannot spring without the summons being served upon the petitioners. He would therefore seek quashment of the proceedings and permit them to quashment of the proceedings to that extent. Per contra, the learned DSGI, Shri Shanti Bhushan, representing the respondent, would vehemently refute the submission to contend that the allegations against these petitioners are grave, and there are multiple inspection reports or supplementary inspection reports with regard to the functioning of these petitioners who are directors of the aforesaid company, which is allegedly involved in cheating several people. He would contend that the petitioner's change of address ought to have been communicated in terms of Rule 12 of what rules are they?
Companies Act.
Company's appointment of
Appointments
directors.
of-
Rule 12 of the company's within bracket appointment of directors rules 2014. Non-compliance thereof cannot now be projected to be in violation of principles of natural justice and non-receipt of summons from the hands of the inspector, from the hands of the inspecting officer. He would seek dismissal of the petition. I have given my anxious consideration so and so. The afore narrated facts are not in dispute insofar as they relate to the issue at this juncture. As the issue lies in a narrow compass, I deem it appropriate to notice the a narrow compass and revolves around the addresses of these petitioners. I deem it appropriate to notice the earlier address, Delhi,
Earlier address here at page 51, my lords.
50.
Page 51. Page 51.
The address that the petitioners were earlier is as follows. This was at Tamil Nadu. Summons were issued to the earlier address on 21/10/2019, and the said summons is appended to the petition. The summons was issued under section 2073B of the Act. The petitioners communication elidad,
Communication of
new address.
new address that is not made a part of the petition, but the show cause notice,
Admitted, yes.
show cause notice at
It
page
transpires
60.
that that a supplementary inspection report is generated by the inspecting officer. Pursuant to the supplementary inspection report, after the drawal of the supplementary inspection report, the new residential address of the petitioners is communicated to the Registrar of Companies, Karnataka. The new address is as follows.
Page 60,
Page 60, mark
the
portion,
second address in both the cases,
2 and 3.
3 and 5,
3 and 5.
3 and 5,
5 ಎಲ್ಲಿದೆ ಇಲ್ಲಿ? Oh,
Next
3
page.
and 5.
two
Black
petitions.
ಬಿಡಿ. Three and 5. The show cause notice, this is show cause notice, the show cause notice is dated 9/9/2021. The petitioners receive the show cause notice and submit their reply on 22/9/2021. The issuance of show cause notice to the aforesaid address is a presumption that the respondent ROC knew the new address of these petitioners. After of these petitioners, a complaint then comes to be registered invoking section 200 of the CRPC before the Court of Economic Offences. In the complaint, the averment with regard to summons is as follows. Page 29. The complaint itself narrates that the summons that were issued to the petitioner were returned undelivered with the postal endorsement, quote unquote, left. It is obvious that the summons could not be served as it was sent to the old address.
But it was delivered to the other address, my lord, page 30 of the petition, para 8, last 4 lines, my lord.
But was delivered at his other address at Visakhapatnam.
Please.
A copy of the postal acknowledgement.
That is a show cause notice, not the summons.
Was not.
That is acknowledged. Para 8 talks about show cause notice service, not summons.
That is prior to that. It show cause notice, yes. So and so. Therefore, the summons was admittedly not served on these petitioners. The offense now alleged is the one punishable under section 207(4) of the Act. Section 207 reads as follows. Subsection 3 of section 207, subsection 3 of section 207 permits the registrar or inspector to make an inquiry and for such purpose summon and enforce attendance of persons and examining them on oath. Subsection 4 punishes those persons who receive summons and would not appear before the inspecting officer for an inquiry. The allegation against these petitioners is under subsection 4 of section 207, which punishes disobedience of a direction issued by the inspector. The direction issued by the inspector, if communicated and disobeyed by any of the noticee or to whom the summons is issued, it would undoubtedly become an offense under subsection 4 of section 207 of the Act. In the case at hand, as observed herein above, the summons are served to an address where the petitioners did not reside. The new address, the ROC or the inspector, the new address as show cause notice is sent by the inspector of, by the inspector to the new address. Therefore, the issue is jugglery of addresses, and the result is violation of principles of natural justice. As if the petitioners have not received a summons, they cannot be alleged of disobedience of a direction issued by the inspector. That is the allegation against these petitioners, and the allegation for the reasons rendered herein above is unsustainable. This would unsustainable. Therefore, the case against the petitioners will have to be restarted from the stage of issuance of summons as obtaining under section 206, as obtaining under subsection 3 of section 207, require their attendance and proceed further.
Got it. Can it be from 206, my lord? Because it 206 says, my lord, power to call information, inspect and conduct.
Correct, 206 and
Not necessary,
207
not
ಮಾಡಿ
necessary, not
ಕೊಟ್ರೆ,
necessary.
solve it. So and so.
Because inspection report is already filed and much water has
The
flowed.
learned counsel for the learned DSGI, as observed here and above, would submit that it would be in violation of Rule 12. In the considered view of the court, it cannot be a violation of Rule 12, as the petitioners have communicated. Rule 12 reads as follows. The submission is unacceptable as the petitioners have communicated the change of address, and the change of address is acknowledged by the respondent as show cause notice is issued to the changed address. Therefore, it is in compliance with Rule 12. If it were not to be in compliance with Rule 12, the submission of the learned DSGI would have merited acceptance. Since it is in compliance, the said submission is as observed is unacceptable. For the aforesaid reasons, the following order. Allowed, quashed, the matter is remitted back to the hands of the competent inspector,
Inspectors.
inspecting officer to redo the exercise from the stage of issuance of summons, bearing in mind the observations made in the course of the order. It is made clear this court has not considered the merit of the matter or the defense of the DSGI, as all those issues are kept open.
Great. Deeply obliged, my lords.
Both. Common order. Companies Act 30.
7.
Petitions, my lord. The offences were punishable under section 415, 417, 418 and 420 of
ಇದು ಗೊತ್ತಾಯ್ತು 2017 crime. ಚಾರ್ಜ್ ಫ್ರೇಮ್
today, my
ಆಗಿದೆಯಾ?
lord, HBC
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆಯಾ?
HBC ಅಂತಾನೆ ಹೋಗ್ತಾ ಇದೆ.
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ charges frame ಆಗಿದೆ.
The petitioner is before this court calling in question proceedings in CC CC 452 of 2021, which arises out of PCR so and so. The complainant is the second respondent. The petitioners are cable operators and distributors in Chamarajanagar district. The allegation springs when Sony channel reports the intervention of signals from unauthorized entities. The allegation is then made by the complainant, who is a rival operator. Finding the dispute between two entities being projected to become a crime and prima facie abuse of the process of the law, I deem it appropriate to stall. That is grant stay of further proceedings before the concerned court. One HCG ಹೇಳಿದ್ನಲ್ಲ ಆಗಿದೆಯಾ? Post the matter in usual course and admission. Next.
My lord, this is the matter
petition filed by the retired partners. I will just pass on the relevant dates, my lord, so that.
Three cases. Three
Three
checks,
three
cases.
checks, total amounting to 3 crore 27 lakhs.
Correct.
8.1, 8.2 and 8.3 arises out of same CC number.
One ನಿಮಿಷ. 8.1
2, 3,
ಅಲ್ಲ 8.
I'm sorry,
Eight.
8. No. 0.1, 0.2, 0.3 arises out of same CC number, man.
one ನಿಮಿಷ. 8.1, 8.2, 8.3.
Arises out of one CC number.
All right.
And 8 and 8.4 are of the different CC numbers.
But all of them are retired.
That is our same. No. In respect of
Accused
three
number-
checks, I'll just
Sir,
complete,
please.
sir. I'll
Or
complete.
mostly that.
In respect of three checks, cases have been filed.
ಇಲ್ಲ one ನಿಮಿಷ.
Three separate cases have been filed.
Around go case by case. Now 8 ಅಲ್ಲಿ ಏನು?
8 ಅಲ್ಲಿ there are,
Come to 8, that is 9443
Please,
of
my lord.
2024.
please, my lord. In this case,
You
the
are
two
a,
petitioners
you are a
are
retired,
accused,
retired director,
partners. Please,
retired partner.
please.
ಒಂದು ನಿಮಿಷ. ಆಮೇಲೆ 8.1 ಅಲ್ಲಿ
8.1 ಅಲ್ಲಿ it is of the same. Accused number, it's only sole petitioner. Please, accused number
ಅದು
4,
ರಿಟೈರ್ಡ್ ಪಾರ್ಟ್ನರ್.
please.
All right. 8.2
They are the, in that, though I am not representing, in that case, 8.2 only. In that case, in fact, one of the partner is a retired partner. I am not.
all right. 8.2 side ಗೆ.
Please,
This 8.3
is of the retired partners.
all right.
8.4 is also
8.4
of the same.
ರಿಟೈರ್ಡ್ ಪಾರ್ಟ್ನರ್. ಈಗ ಡೇಟ್ಸ್ ಕೊಡಿ.
Dates ಕೊಟ್ಟೆ ನಾನು.
ಕೊಟ್ರಾ?
ಹಾ.
Thank you. Yes. Two dates you have to give. When did you retire?
My lord, 11/10/2021.
11/10/2021.
Please,
And date of the check.
checks are of 2022 December.
Dates ಹೇಳಿ sir.
ಅದ್ರಲ್ಲೇ ಇದೆ.
Dates of the check is 1st December 2022.
ಯಾವ್ದ್ರಲ್ಲಿ?
That is in, my lord, in fact,
Arun, be specific.
I'm sorry.
In the first case ಅಲ್ಲಿ ಯಾವತ್ತು date of the check
I'll mention.
ಓದ್ಕೊಂಡ್ ಬಂದಿಲ್ವಾ?
I'm sorry. This is of the 2nd December 2022, first case.
First ಅಲ್ಲಿ
2nd December 2022.
that is in 9443.
Please,
2/12/22.
please.
ಇದರಲ್ಲಿ 8.1 ಅಲ್ಲಿ
This is of 3rd November 2022. 3/11/2022.
third now 3/11.
Please,
All right. ಆಮೇಲೆ 8.2 ಬಿಡಿ, 8.3 ಬನ್ನಿ.
8.3. This is of 30th November 2022.
8.4.
5th December 2022.
ಇವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ, ಆದ್ರೆ ತೊಂದರೆ ಇಲ್ಲ, ಹೇಳಿ. ಎಸ್, ಒಂದು ನಿಮಿಷ ನೀವು ಬಿಡಿ. ಕಿರಣ್ ಹೇಳಿ.
My lord, lordship has granted the interim order relying upon redundant judgments.
ಆಲ್ ರೈಟ್, ತೊಂದರೆ ಇಲ್ಲ, ಹೇಳಿ.
No, I want to distinguish that judgment and move forward because the dates are undisputed.
Dates are undisputed.
Dates are undisputed.
Retired partners is an undisputed fact.
No, retiring is an undisputed fact in virtue of the section 32 of the Partnership Act. That is my case.
Now, 1 minute. Now, where is the, how did you retire from the partnership?
But there is the document in
I am holding, I think,
9443.
9443.
That is appended at page 47.
47.
7.
Agreement between retiring and continuing partners. All right.
Apart from the reconstitution deed, they have not produced any.
ನೀವೇನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ?
I had made the averments in the complaint. And because at the time of filing,
Registered reconstitution deed?
it is not a registered reconstitution.
Not a registered. You are the signatory to this?
No, I am.
Hello, you are a complainant. Sorry, yes. Now, who are the partners who entered and who are the ones who exit?
But the document to which I just referred, page 47.
Hmm.
The name.
Retiring
of
and
the
continuing
present
partners.
petitioners are 1 and 2, which is at page 47.
Jay Agarwal.
Anjana Agarwal and Jay Agarwal.
These are the
Retired partners.
retiring partners. Now, who is the signatory to the check?
Signatory is Renu J. Nair, accused number 2, who is the respondent number.
All right. Signatory to the check, yaru?
I'm not the signatory.
Alla.
Renu Nair is what?
To all the checks.
Yes.
To all the checks. Yes, sir. ಯಾವ judgment distinguish ಮಾಡ್ಬೇಕು ಹೇಳಿ?
I will just pass on few more judgments, my
Please.
lord, so that.
Give it.
The first judgment, my lord, is Rajesh Viransha versus Redington India Limited. The distinction what I want to draw in this case, my lord, lordship may kindly come to page 3, my lord, the first paragraph of the judgment. Leave granted whether a director who has resigned from such position and which fact stands recorded in the books as per the relevant rules and statutory provisions can be liable for certain negotiable instruments, failing realization is the sole and short common question that this court must consider in these appeals arising out of the judgment and order, so and so. My lord, this is as far as a company is concerned. This is under the Partnership Act.
All right.
So coming to the next line of the judgment, my lord, lordship may kindly come to paragraph number 6 of this judgment. We also notice that this court to have observed in regard to the exercise of the inherent powers under section 482 of CRP, say, in cases involving negotiable instrument, that interference would not be called for in the absence of unimpeachable, incontrovertible evidence, which is beyond suspicion or doubt or totally acceptable circumstances, which may clearly indicate that the director could not have been concerned with the issuance of check, and asking him to stand the trial would be abuse of process of court. So and so, SMS Pharmaceuticals has been observed. Now the paragraph 8, my lord. The veracity of Form 32 is neither been disputed by the respondent, nor has the act of resignation simpliciter has been questioned. As such, the basis on which the liability is sought to be fastened upon in the instant appellants is rendered questionable. Here, my lord, in this case, apart from the reconstitution date, there is no form filed before the register of firms has been produced. Hence, my lord, no communication as far as this complainant is concerned has been made. And there is a clear distinction, my lord, it is not a company, it is a partnership firm. The liability continues even after retirement as per section 32. That judgment also I have the next judgment, my lord, which says, lordship may kindly come to the next judgment, my lord, Rallies India. This is the judgment, my lord, where when there are disputed facts, the complaint cannot be quashed. That is what the judgment. So I will just skip this judgment. Next, I will go to a judgment of Madras High Court, my lord.
Kupaswamy.
Sorry, my lord. Sundaram versus Kupaswamy. Kupaswamy judgment, lordship may kindly see paragraph 24 for a moment. Rule 4 of the Tamil Nadu Partnership Registration of Firms Rules 1951 deals with the formation of intimation of notice under section 61, 62 and 63 of the Indian Partnership Act, which shall respectively in the form of form 3, 4, 5 and 6 annexed to the rules, which variation as circumstances may require. Form number 5 is the form prescribed for giving notice of change in the constitution or forwarded to the register of firms for filing under section 63(1) of the Indian Partnership Act. 3 decisions cited by so and so may be useful looking into this regard. The first reported in so and so. From the decision cited above, it is clear that a partner who has retired from the partnership is bound to give notice in a vernacular newspaper of the locality wherein the principal place of business of the partnership situated, and also in the official gazette. Further, from the judgments referred above, it is also clear that notwithstanding the dissolution of the partnership firm, a partnership continues to a third persons who deals with the members of thereof as partners until public notice of dissolution is given. Even though, as between the partners, the firm has been dissolved prior to such notice. In other words, a partnership is presumed to be continued to the third persons until public notice of dissolution has been given, unless the person dealing with the firm after his dissolution has actual knowledge of such dissolution. Section 45 of the Indian Partnership Act says that a partnership continues as to the third person unless the dissolution of the firm is taken to the knowledge of the third person who deals with the firm. Similarly, my lord, the next judgment, HDFC Bank judgment, my lord. What is the role of the outgoing partner has been explained in this case. Para 8, my lord, which lordship will get at page 25. This is the case of this. Thus, the case of the complainant is that issue whether on the date of commission of the alleged offense, the applicant was a partner of the firm or not, being a disputed question of fact. The same cannot be gone into this court in the present proceedings. The principal arguments of the learned counsel appearing for the complainant is that, assuming for the moment that the applicant accused has retired as a partner from the firm, whether such retirement could be said to be in accordance with law, and if such retirement could not be said to be in accordance with law, then even if the applicant has ceased to be the partner, the applicant would not give absolve from her liability under section 138, read with section 141 of the Act. In such circumstances referred to above, the learned counsel prays that this being no merit in this application. So this is the facts of this case, my lord. The finding starts from paragraph 14 onwards. The Honorable Court has relied upon a few judgments of various high courts, my lord, and subsequently, para 17, lordship may kindly see. I am in respectful agreement with the view taken by the learned single judge of Madras High Court. The mode and procedure prescribed for the purpose of retiring from the partnership firm has been explained under the provisions of sections 45, 63, and 72 of Indian Partnership Act. If the legal procedure prescribed has not been followed, then the civil liability of a retiring partner continues to the third parties who deals with the members of the firm as partners until public notice of dissolution is given. However, I am dealing with the matter under section 138 of the Negotiable Instrument Act. While considering the criminal liability of the retired partner of the firm or the partner of the dissolved firm under section 138 of the NI Act, the main question to consider is as to whether on the date of issue of check and on the date of arising of the cause of action, such partner was really and actually a partner of the firm or not. Having regard to the materials on record, I am of the view that issue raised as regard to the retirement of the applicant as a partner on the firm being dissolved and reconstitution is highly disputed question of fact. Not only in the special civil application number so-and-so filed by the partnership firm as referred above, the application has been shown as one of the partners. Even in the written submissions filed in OA number so-and-so, affirms in November 2016, it has been asserted that the applicant is a partner of so-and-so. This is evident from Annexure C to the reply filed by the complainant. Next, my lord, paragraph 20. The Supreme Court in the case of Rallis India Limited versus so-and-so has taken the view that once the vicarious liability of a partner of the firm is specifically made out by an appropriate averment in the complaint, then the High Court should not discharge the accused of their vicarious liability for the offences under section 138 and 141 of NI Act at the threshold on the ground that they have retired from the partnership firm. The question as to whether or not accused were partners of the firm on the date of the commission of the offence is one fact which has to be established in trial. I may quote the relevant observations. Then, my lord, para 21 is important. May I read, my lord, para 21? I have also considered the case law relied upon by the learned counsel appearing for the applicant in support of his submission. There need not be any debate as regards the principles on or the ratio propounded in the decisions of the Supreme Court. The statutory documents such as annual returns, Form 32 in the context of a company and Form G in the context of a partnership firm can be relied upon and looking into by the court. But so far as the case in hand is concerned, the materials placed by the other side on record would indicate that the picture is very hazy and the parties must be given an opportunity to lead appropriate evidence before the trial court. My lord, in this case also, my lord, no statutory forms or the acknowledgements for having filed this retirement before the register of firms has been produced. Apart from the deed of retirement or a reconstitution of partnership deed has been produced. The next judgment, my lord, is SP Mani's judgment, my lord, wherein the Honorable Apex Court, my lord, has given the guidelines for quashing the complaints, or what should be the averments should be made as against the to drag a 141 into the offense. Page 61, my lord, is the conclusion part, my lord. Para 58.
Yes.
My lord, as far as this case is concerned, my lord, I had specifically made our allegations in the complaint that all the partners are equally responsible for placing the purchase orders, taking the goods delivery, and are liable to make the payments, my lord. As far as supply and delivery and usage of the goods are concerned, my lord, there is no dispute. So, para 58.1, my lord, is. Then, my lord, I will go to page 63.
That is Delhi High Court. Judge.
Delhi High Court.
2024 August. Yes. Yes, sir.
Lord, the government, what my friend is saying, I challenge the.
Let me.
ಅಷ್ಟೇ ಇನ್ನೇನಿದೆ?
Para 24 of this judgment, Delhi High Court.
ಆಯ್ತು.
ಆಮೇಲೆ ಕೊನೆ judgment ಒಂದು. Page 82, it is of the Punjab and Haryana High Court, my lord. Lordship may kindly come to page 86. Same section 32, it speaks about section requirement of section 32, my lord. Para 11. Where perusal of the above makes it clear that though the partner may retire with the consent of the other partners, but he cannot be discharged from any liability to any third party for the acts of the firm done before his retirement only by way of an agreement made by him with such third party and the partners of the reconstitution firm. In the present case, there is no averment on part of the petitioner that before retiring, he entered into any such agreement with the complainant respondent number 2. Then, my lord, the para 40. In the present case, there is no averment on part of the petitioner that before dissolving the firm with the other partners by way of retirement deed numbers, annexure so and so, and public notice was issued. In the same facts and circumstances, it was held in so and so and so and so. This court has held that a retiring partner could be absolved of his liability to a third party for acts done prior to his retirement only by way of an agreement with such party and the reconstituted firm.
Yes, sir.
Lord, I have
ಅವ್ರು
challenged.
ಅಷ್ಟೊಂದು ಕೊಟ್ಟಿದ್ದಾರೆ, ನಿಮ್ದೇನ್ ಇಲ್ವಾ?
ಇದೆ.
ಅಲ್ಲೇ ಹೋಗ್ಬಿಡಿ ಅಂತ.
Sebi Thomas judgment is what I want to rely upon. The averment what is being cited in the complaint would be insufficient to prosecute the petitioners because there is no averment as on the date of the offense. These petitioners were the responsible person. That is the requirement.
That's all right.
Sebi
Keep it.
Thomas, please.
Yes, sir. Anything else?
As far as averment, my lord, the entire complaint is the averments are as against all the 4 partners of the firm.
Fantastic. ಅಷ್ಟೇನಾ? The 8.2 ಡಿಲಿಂಕ್ ಮಾಡ್ಬೇಕಾ?
Maybe, please. That can also be disposed of, my lord. ಯಾಕೆಂದ್ರೆ ಅಲ್ಲಿ trial is unnecessarily stalled.
There is no interim order, sir, in that matter.
But still,
Notwithstanding that,
they are
wherever
taking
I am,
advantage of the connected.
8.2 he is not appearing, so
Please.
It can be dismissed, my lord.
So
So
that
that I
is
will proceed with
instance
the case.
we'll delink 8.2.
Dealing ಮಾಡಿರೋದು unnecessarily.
ಅದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿಲ್ವಲ್ಲ?
ಇಲ್ಲ.
ಮತ್ತೆ ಬಿಡಿ.
The averment in the complaint is only para 3.
Confidence okay, but over confidence ಯಾಕೆ? Dismiss ಮಾಡ್ತೀನಿ ಅಂತ. Yes. The petitioners 8.2 ಬಿಟ್ಟು KG. The petitioners in all these cases are erstwhile partners of ಯಾವ ಕಂಪನಿ ಅದು? ಯಾವ ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಫರ್ಮ್?
Infocom.
Part of RR Infocom. The heard so and so. ಏನ್ ಮಾಡಿ? 8.1 ನಿಮ್ದಲ್ಲ?
In that I have filed an NOC. Wakalat.
They heard so and so. Since these are batch of petitions projecting a solitary issue in law, they are taken up together and considered by this common order. The issue is whether the partners who have retired from the partnership firm can be prosecuted for an offense punishable under section 138 of the Negotiable Instruments Act for a check that is rendered by an incoming partner
No, my lord. It was
After-
also an existing partner.
who
The check has been
sorry,
issued.
by the existing partner. Criminal petition 9443 of 2024. The subject criminal petition is preferred by accused 3 and 4 in CC 9585 of 2023. Their names are Jai Agarwal and Anjana Agarwal. The Berella Kodi madam. The criminal petition 8100 of 2023 is preferred by Anjana Agarwal, accused number
3.
accused number 3 in CC 7311 of 2023. Criminal petition 13150 of 23 is by Jai Agarwal, accused number
One
Accused
correction, my lord.
number-
Anjan Agarwal is accused number 4.
3 in CC 7311 of 2023. Therefore, the 2023. Criminal petition 8523 of 2024 is by Jai Agarwal, accused number Jai Agarwal and Anjana Agarwal, accused 3 and 4 in CC 9504 of 2023. The instrument involved in the subject transactions are 3 different checks, totally amounting to 3 crores,
27 lakhs.
3 crore 27 lakhs. The complainant is the second respondent. The complainant is the respondent. One, Inflow Technologies Private Limited in all these cases. It transpires that a transaction between the company Infocom, RR Infocom and Inflow Technologies Private Limited leads leads RR Infocom to issue certain invoices and invoices.
RR Infocom issues purchase order.
Transaction between the RR Infocom and Inflow Technologies Private Limited is with regard to certain purchase orders placed by RR Infocom and the deliveries made by the complainant Inflow so and so. The payment due date on these purchase orders are of different dates. They are 18/10/2020, 21/9/2020, 29/11/2020. At that point in time, it transpires that the petitioners in all these cases were partners in the said firm, i.e. RR Infocom. On different dates, on 11/10/2021, these petitioners who are arrayed as accused in the aforesaid cases retire from the partnership and the partnership is reconstituted by drawing up a reconstitution deed of drawing up an agreement between the retiring and continuing partners of RR Infocom. The averment is that all necessities in law with regard to the intimation of retired partners is complied with. The partners retire on 11/10/2021. The existing partner, one Renu J. Nair, Renu J. Nair, who's accused number 1 in all these cases.
No, accused number 2. One is the firm.
One firm. Accused number 2. in-
Represented by very same.
All right.
So,
Accused number 2 in all these cases issues 3 checks, albeit towards the payment that had to be made on 18/10/2020, 21/9/2020, and 29/11/2020. The instruments were issued on 30/11/2022, 2/12/22, and 5/12/22. Those checks were presented for its realization and were returned with an endorsement, quote unquote, funds insufficient. It is then a notice is issued by the complainant initiating proceedings under the Negotiable Instruments Act. Nimgu notice kotra?
Illa, we have not received.
The
Notice
Have
is
not.
given.
We have
Para
not.
11 of the
all
complaint.
right, the complainant narrates that the notice were sent to the petitioners as well. The petitioners, the learned counsel for the petitioner defends, contending that no notice was received by them, be that as it may.
One submission, my lord. It is not for insufficient funds. Payment stopped by the Troyer.
ಅದು change ಮಾಡ್ಕೊಳ್ಳಿ. So and so. The learned, so and so. The proceedings were then initiated before the concerned court invoking section 200 of the CRPC, drawing all these persons along with the firm and accused number 2 as accused in these proceedings. The proceedings are now pending as criminal cases as aforesaid. The issuance of summons is what has driven these petitioners to this court in the subject petition. The learned counsel Arun G, appearing for the petitioners in all these cases, would contend that the petitioners were no doubt partners on the date on which the supply was made or the delivery was made and the payment due date. But the checks are not issued by the present petitioners. It is issued by the existing partner after the partnership was reconstituted when these petitioners came out of the partnership. The learned counsel for the petitioner would further contend that the complaint averments are omnibus against accused 1 to 4 and no particular role or responsibility being continued after the retirement of these petitioners as partners is averred. And therefore, the learned counsel would submit that the proceedings against these petitioners are necessarily to be quashed. The learned counsel appearing for the respondent complainant would vehemently refute the submissions, seeking to contend that the judgment on which reliance is placed at the time of grant of the interim order is inapplicable to the facts of the case. He would submit that that was a judgment dealing with the company, dealing with the director of a company retiring, director of the company resigning, and proceedings taken up against a resigned director. He would seek to place reliance upon the following judgments. The learned counsel would take this court through several paragraphs of all these judgments to contend that mere retirement of a partner would not suffice to escape the liability under Section 138 of the Negotiable Instruments Act. It should be made known in terms of law that the partners have retired, and therefore the liability continues till such an action is taken in accordance with law. He would contend that that whether the petitioners have retired as partners or not is a matter of fact which should be thrashed out only in a full-blown trial and not in a proceeding under Section 482 of the CRPC. The learned counsel would submit the purport of the judgments relied upon by him is towards what he has submitted as noted herein above. He would seek dismissal of these petitions. Per contra, these petitions, the learned counsel for the petitioner would join issue by contending that the judgments so relied on by the learned counsel appearing for the complainant would not be applicable to the facts of the case. And what is applicable is the judgment of the apex court in the case of Sebi Thomas versus so-and-so, reported in 2024 1 SEC page 348, which the apex court considers wherein the apex court considers the very issue of retiring partners being hauled into a proceeding under Section 138 of the Negotiable Instruments The I have given my sense. Therefore, narrated facts are not in dispute. The petitioners being partners in the RR in the company accused number 1 RR Infocom is a matter of record. The petitioners retiring from the partnership and on the reconstitution of the partnership is also a matter of record as the document is appended to the petitions. The retirement of these partners would happen on 11/10/2021. By then, the transaction between the respondent complainant and the company had taken place and certain amounts were due to be paid. Pending payment to the complainant, the petitioners retire on 11/10/2021. These are undisputed facts. The check is issued by accused number 2, who represents accused number 1 on 3 different dates, on 30/11/2022, 2/12/22, and 5/12/22. Therefore, it is an admitted fact that the checks are issued after the exit of the petitioners from the partnership firm. The checks are not signed by these petitioners. The checks are admittedly signed by accused number 1, accused number 2, who represents accused number 1 company. Therefore, the petitioners in the considered view of this court cannot be hauled into these proceedings, as they had, by the time the instrument, i.e. the check signed by accused number 2 representing accused number 1, they had retired from the partnership. The accused number 2 does not get into the partnership on reconstitution, but becomes continues to be a partner and could be described as an existing partner. So therefore, the existing partner issues the checks close to 12 months after the retirement of these petitioners. The learned insofar as the judgments relied on by the learned counsel appearing for the respondent complainant, there cannot be any qualm about the principles laid down therein. In all those cases, in those cases, they were either the directors of the company, which are different from partners of a company, as the statutory liability or statutory obligations are different under the Partnership Act or the Companies Act, as the case would be. In much of the learned counsel has placed heavy reliance upon the judgment rendered by the High Court of Gujarat and which follows the judgment rendered by the High Court of Madras. In the judgment rendered by the High Court of Madras, the plea of the accused therein was the complainant had by deceit or erroneously taken the signature of the accused on the check. That is not the issue in the case at hand. The case at hand is plain and simple that the petitioners retired on 11/10/21. 3 checks were issued by the existing partner accused number 2, who represented accused number 1 12 months after the retirement. Therefore, what would govern the case at hand is not the judgments that are relied on by the learned counsel for the complainant, but the judgment of the apex court in the case of Sebi Thomas versus so-and-so, quoted supra. The apex court in Sebi Thomas has held as follows, quote para 6-20. The apex court was dealing with an identical situation where the High Court had rejected the petition under Section 482 on the ground that it would be a question of fact and the retiring partners cannot escape the liability. The apex court upturns the view of the High Court and holds that unless there is specific averment of the involvement of the retiring partners in the complaint with and continued liability, they cannot be hauled into the proceedings. The apex court, the judgment of the apex court in the considered view of this court covers the issue on all its force. For the aforesaid reasons, the following order. Allowed first.
Final, my lord, expeditious trial. In for court, expeditious trial direction.
ಇವ್ರ ಮೇಲೆ ಹೆಂಗ್ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಟ್ರಯಲ್
ಇದರಲ್ಲಿ ಅಬ್ಸರ್ವ್ ಮಾಡಿದ್ರೆ ಎನಿ ಆಫ್ ದಿಸ್ ಜಡ್ಜ್ಮೆಂಟ್ ವಿಲ್ ಗೋ ಟು ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅದಕ್ಕೋಸ್ಕರ.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್
ಅಲ್ಲ, ಎನಿ ಆಫ್ ದಿಸ್ ಜಡ್ಜ್ಮೆಂಟ್ ವಿಲ್ ಗೋ ಟು ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್. ಸೊ ಒನ್ ಅಬ್ಸರ್ವೇಷನ್ ಮೈ ಲಾರ್ಡ್, ಇಟ್ ವಿಲ್ ಹೆಲ್ಪ್ ಮೀ ದೇರ್.
ಅಲ್ಲ ಅವ್ರ ಕೇಸಲ್ಲಿ
ಅಲ್ಲ, ಎನಿ ಆಫ್ ದಿಸ್
ಅವ್ರ ಕೇಸಲ್ಲಿ ನಿಮ್ ಕಾರ್ಡ್
ಎನಿ ಆಫ್ ದಿಸ್ ರಿಪ್ಲೇಸ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್.
ಎಸ್ ದಟ್ ವುಡ್ ಬಿ ಇನ್ಕರೆಕ್ಟ್.
ಅಲ್ಲ, if that is so, my lord, the other petition which has been dealing can be, a date may be fixed.
ಅದ್ರಲ್ಲಿ ನೀವು ವಕಾಲತ್ ಹಾಕಿಲ್ವಾ?
ಅದ್ರಲ್ಲಿ ಅವ್ರು ಬರ್ತಾನೆ ಇಲ್ಲ. First state lordship has not granted it.
ಈಗ ಹಾಕ್ತಾರೆ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಪಾರ್ಟ್ನರ್ಸ್ ಡೀಲ್. ಆಮೇಲೆ ಆ ಡೀಲಿಂಗ್ ಮಾಡಿದ ಕೇಸಲ್ಲಿ ಪೆಂಡೆನ್ಸಿ ಆಫ್ ದಿಸ್ ಪೆಟಿಷನ್ ವಿಲ್ ನಾಟ್ ಕಮ್ ಇನ್ ದಿ ವೇ ಆಫ್ ಫರ್ದರ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಬಿಫೋರ್ ದಿ ಕನ್ಸರ್ನ್ ಕೋರ್ಟ್. ಅಷ್ಟು ಸಾಕು.
ಎಕ್ಸ್ಪಿಡಿಯಸ್ ಅಂತ ಒಂದು ಮಾತು.
ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಎಕ್ಸ್ಪೀಡಿಯಸ್
ಪ್ಲೀಸ್ on date putbitre lordship can.
Less that there is no representation on behalf of the petitioner. Amal adbari dependency of this petition. Less the matter on 29th November as a last chance. In the event the counsel would not represent, the petition would be dismissed for its non-prosecution.
Nine.
For the second respondent.
FRR reduce. Yes, sir. How do you threaten other nationals?
Pardon, Lord?
ದುಡ್ಡು ಕೊಟ್ಟಿಲ್ಲ ಕೊಡಬೇಡಿ ಅಂತ ಏನದು?
Lord, I never said any, Lord, the entire correspondence and the talk between both of us on the WhatsApp, nowhere have I indicated to her.
Come to page 21, sir.
21, Lord. The copy of, my name is Leslie Osterman, female Finnish.
That's the complainant.
Yeah, yes.
Does the complaint?
No, she lodges the complaint to the FRRO and she exits. This complaint is now forwarded to the police by the FRRO herein. Based on which this, no, I will read this now. My name is Leslie Osterman, female Finnish citizen. Entered India through Bangalore airport on 13 January 2019, 2:30 AM. My passport was lost there. I reported it. And with the police report, photocopy of lost passport and my e-visa, I got an emergency passport issued on 17 January, valid till 15th March 2019. Embassy told these documents are enough to exit India with my flight 8.3 flight for the flight home. And immigration stops me telling I need an exit permit. Never heard of this. I call the embassy and even they are surprised and they check and can't help me. I have to get this exit permit myself ASAP. My flight is leaving on 2 hours time. After the immigration stop me, I totally panic. I Google online and find the of FRR office, and the guy who answers is on WhatsApp. He tells me I don't need to go to the FRR office at all. And I can just send him the documents of WhatsApp and he will take care. The process is very complicated, slow and expensive. The name of the person is Karthik Arora, etc. So and so, so and so. So he sent me an invoice charging me 20,500 INR for non-value service after 3 days of work, and he still didn't give me the exit permit. I have attached the email of his bill to the email of FRR office, and this is arrive in Bangalore, FRR office on March 11th.
Objections hakidira?
Malad,
What instructions?
Haki.
Malad, can I?
No, sir.
I'll just, Malad, kindly come to the next page. Malad, kindly see, Malad. Page 27. This is my invoice. Nowhere, Malad, then right from page 30 onward.
That sheet hakilwa inno?
Hakidare.
ಮತ್ತೆ
Hakidare. Malad, kindly see, Malad. Nowhere, Malad, nowhere have I ever said that I am an officer of the FRRO.
Good.
Malad, I'm a BTech graduate, Malad.
So what?
I'm not dropping names. Malad, I'm not dropping names. Malad. I'm a BTech graduate. My dad is a retired IAS officer. I am doing these services. I was working in HCL. Then after, in 2017, I started this. I only provide, Malad, the charge sheet is only for 420. There is no, Malad, I have not cheated or induced anybody. Nobody has parted money to me.
What else is the complaint about, sir?
Malad, the complaint says for the services rendered, I raise a bill. Malad, she does not have the money. Malad, to avoid payment, from 8th to 11th, this transaction takes place. she does not have the money to pay me. She leaves the country, and while going, she leaves this complaint before the FRRO.
Sir,
On
CC of 2019, you file your objections.
Please.
Yes.
Lord, grant me a stay, my lord.
No, sir.
My lord, on the face of it, my lord, there is.
No, let the objections come.
Please.
With wapas kodi ಅವರು.
Like,
Heard the learned
through-
counsel for the
through-
petitioner.
ನೋಡಿ ಸ್ವಾಮಿ, ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ. Nowhere have I said, my lord.
Objections ಅಲ್ಲಿ ಬರುತ್ತೆ. Yes.
Exit visa 48 hours, 25,000, 5 days, 15,000. I'll
Yeah.
produce it, sir.
Well, it's my fee, but you have not paid my fee. Sir, you file your objections, and nowhere have I said, my lord.
Objections ಹಾಕ್ಲಿ ಬಿಡಿ.
Yes.
Great.
Learned DSGI
The
6
fourth-
to
Third date.
2 weeks time. So what?
My lord,
2019 years ಸುಮ್ನೆ ಇದ್ದೀರಾ ನೀವು?
ಗೊತ್ತಾಗಿದ್ದೆ.
Sir. Learned DSGI 6, 2 weeks time. Saka?
Please.
2 weeks time to file statement of objections. List the matter on 4th December. Objections, if any, by then. Yes.
Great.
10.
In the meantime. Yes, next.
11.
Family dispute alla ತಗೊಂಡು. Yes, sir. Yes.
Lords, the petitioner, my lords, is a bona fide purchaser, my lords.
Bona fide purchaser.
Please, my lords.
Very good, sir.
Page 9, my lords, annexure A, my lords,
Ah,
is the complaint, my lords.
yes, sir.
Para number 2 may I read, my lords. ಸದರಿ ಜಮೀನನ್ನು ಮೋಸ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ
ಈಗ ಪಿಳ್ಳಮ್ಮ ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದು?
ಪಿಳ್ಳಮ್ಮ ಕೊಟ್ಟಿದ್ದು ಪೆಟಿಷನರ್ಗೆ.
ಯಾವಾಗ?
2022.
2022 ಅಲ್ಲಿ.
ಪ್ಲೀಸ್ ಮೇಡಮ್. 20 ಜನವರಿ 22.
Pillamma has died on 21/2/74. How did she give you?
Not sir. She might have committed.
She might have died and you got it.
But I am a bona fide purchaser, my lords.
From whom did you purchase?
Pillamma, my lords.
Pillamma is dead 30 years ago, sir.
So the allegation is that some
Yes, sir. Yes.
lady made a mischief, my lord. She played a mischief and
We don't know, sir. Allegation is you have purchased it from Pillamma. Pillamma died on 12/1/1974. The sale deed is in the year 2022. Idral investigation ಆಗ್ಬಾರದು ಇನ್ಯಾವುದ್ರಲ್ಲಿ?
my lords.
How did Pillamma come and sign in the register or appear before a sub-registrar?
I am not aware of that, my lords.
Whatever. We'll see.
The my lords, the petitioner,
No.
my lords, she is having a.
Pillamma is your vendor.
Please, my lords.
Correct.
Please.
Which Pillamma we don't know. The complaint is that now Pillamma's, there is an impersonator. Pillamma has died on 21/2/1974.
Please.
Anything else, sir?
Lords, she is suffering from health issues, my lords, petitioner,
Huh?
my lords. She is suffering from health issues, my lords. I produce a
Health
medical
issues,
certificate. Please, my lords.
Bail ಸಿಕ್ಕಿಲ್ವಾ?
Please, ಇಲ್ಲ, ಸಿಕ್ಕಿದೆ, bail ಸಿಕ್ಕಿದೆ.
ಮತ್ತೆ health issues
She
ಗೆ
is having
bail
a minor
ಆಯ್ತು.
daughter, my lords.
Health issues ಗೆ bail, interim bail ಎಲ್ಲ ಆಗುತ್ತೆ. Not for it.
She is having a minor daughter, my lords.
No,
So I pray for an
no,
interim order, my
no.
lords. Interim order.
Interim order. I'm dismissing it, sir. ಇದರಲ್ಲಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ಲೇಬೇಕು. ಡೆಡ್ ಪರ್ಸನ್ ಹತ್ರ ತಗೊಂಡಿದ್ದೀರಾ ಎಲ್ಲಿಂದ?
ಇಲ್ಲ ಸ್ವಾಮಿ, I am not
ಇಲ್ಲ.
aware of that. I am not aware of that. my lords.
Don't know. Yes, this is a cartel. ಏನ್ ಸರ್? ಏನಿಲ್ವಾ? Innocent bona fide purchase.
No, my lord. The Pillamma died.
ಅದು ನಾನು ಹೇಳಾಯ್ತು. ಅದಾದ್ಮೇಲೆ
My
ಹೇಳಿ.
34 is there, my lord. Common object they are colluding with each other and creating.
34 is not a substantive offense, sir. Come out with something else.
Yes, my lord, your lordship.
Investigation. Anything else, sir? Dismissed. Or you withdraw and file it after charge sheet.
I withdraw, my lords.
ಇಲ್ಲ ನಾನು ಫೈಂಡಿಂಗ್ ಕೊಟ್ಟರೆ ತೊಂದರೆ ಆಗಲ್ಲ.
Please.
Yes. Appropriate. Yes, next.
12.
Let's produce the entire charge sheet paper.
Correct, sir. Come to page 28. sir.
Let's 28 minutes. Absolutely, there is nothing to connect SC/ST Act. The abusers not touching.
Sir, you knew who they were?
Let's.
ಅವ್ರು ಯಾರು ಪರಿಚಯ ಇರಲಿಲ್ಲ.
ಗೊತ್ತು
ಗೊತ್ತಲ್ವಾ?
ಪಕ್ಕದಲ್ಲಿ
ಅಷ್ಟು ಸಾಕ್ಬಿಡಿ.
ಅಲ್ಲ
Notice.
ಅಲಿಗೇಷನ್ ಅಲ್ಲಿ ಅವರು ಬೈದ್ರು.
1 additional SPP, 2 emergent notice. ಆಗಿದೆಯಾ? ಮತ್ತೆ ಯಾಕ್ ಬಂತು ಇವತ್ತು? Sir.
No interim,
ನೋ ಎಂಟ್ರಿ ಮಾಡಲ್ಲ, PF ಕಟ್ಟಿಲ್ಲ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ.
ಅಲ್ಲ, ಅದ್ ಕಟ್ಟಿದ್ದೀನಿ ಸುಮ್ಮನೆ, ಆಫೀಸಲ್ಲಿ ಕಟ್ಟಿದ್ದೀನಿ.
ಯಾವತ್
Today
ಆಫೀಸಲ್ಲೇ
ಕಟ್ಟಿದ್ದೀನಿ.
ಕಟ್ಟೋದು ಇಲ್ಲಲ್ಲ, ಎಲ್ಲಿ ಕಟ್ಟಿದ್ರಿ?
Today,
ಇವತ್ತಲ್ವಾ? Learned counsel of the petitioner submits needful has been done this morning. List the matter immediately after service of notice upon the respondent. Yes, next.
date,
13.
date,
ಯಾವಾಗ ಸರ್ವ್ ಆಗುತ್ತೆ ಗೊತ್ತಿಲ್ಲಲ್ಲ.
next. Date may be fixed, otherwise.
ಅಷ್ಟೇ,
it's long.
whether you had the knowledge, you knew them ಅಂದ್ರೆ you have the knowledge that they are belonging to SC and ST.
Yes, my lords, I had the knowledge, but I have not abused. That's what the charge
that
sheet
is,
says.
that will cease. Yes,
That is the.
yes, yes, next.
14.
For the petitioner. For a short accommodation, my lord, senior counsel.
Appearing for the respondent, my lord, respondent number 2. We have no objection to their request.
You have no objection to allow the petition?
No, to their request for adjournment.
Request.
My lord, Tuesday or
My lord,
12th or
a slightly
15th,
longer date, my
Just the
lord.
matter,
12th or 15th,
ಏನು
15th, my lord.
ಇದು ಏನಿದು offshoot of pepper spray?
My lord, so
Yes,
what is
my
that,
lord. This is their counter complaint.
12th or 15th, my lord?
15th ಆಗಲ್ಲ.
Charge sheet has been filed in their, the complaint that they have filed. In my matter where your lordship had quashed the, dismissed the petition, my lord, and that even the investigation has not commenced in that matter, my lord, the pepper spray matter.
List on 15th at the request of the counsel appearing for the petitioner.
My lord,
Learned counsel so and so, you already filed wakalat?
Wakalat I filed, my lord. Legally
Learned
may be
counsel
granted to file
submits
no
that
objections.
the entered appearance so and so registry to print. We'll take it on 20th. List on 20th in the fresh matters list, objections if any by the respondent by then, failing which this court will be construed to grant an interim order.
Much.
14.
Husband,
What is it?
Husband petition, yes. Now, right here.
no representation by the petitioner, list after 2 weeks. Objections if any by then. Next,
15.
192A,
Please, madam, Kerala recommend.
Lalita Shastri compliance ಇದೆಯಾ? Notice ಕೊಟ್ಟಿದ್ದಾರಾ?
Notice ಕೊಟ್ಟಿಲ್ಲ sir.
Ah,
Complaint.
yes, sir. The petitioner is before this court calling in question registration of a crime in crime number.
I
So and
secure the
so.
notice,
Notice ಕೊಟ್ಟಿದ್ದೀರಾ?
secure the notice.
ಎಲ್ಲಿದೆ?
ಅಲ್ಲ, secure ಮಾಡು.
No,
Tomorrow.
notice ಕೊಟ್ಟಿದ್ರೆ ಇಲ್ಲಿ
ತಹಶೀಲ್ದಾರ್
ಇರ್ಬೇಕಾಗಿತ್ತು.
ಫೈಲ್ ರಿಪೋರ್ಟ್,
ಅಲ್ಲ,
ಎನ್ಕ್ವೈರಿ ಆಗಿಲ್ಲ ಅಂತ ಫೈಲ್
I-
ರಿಪೋರ್ಟ್ ಮಾಡಿ, ತಹಶೀಲ್ದಾರ್ ಫೈಲ್ ರಿಪೋರ್ಟ್ ಅನಕ್ಷರ ಕೆ ಮಾಡಿ.
My lord.
ನೋಟಿಸ್ ಬಂತಾ ಇಲ್ವಾ ನಿಮ್ಗೆ?
ನೋಟಿಸ್ ಬಂದಿದೆ.
ಮತ್ತೆ ರಿಪೋರ್ಟ್ ಏನಾಯ್ತು? ಎಲ್ಲಿದೆ ರಿಪೋರ್ಟ್ ಎನ್ಕ್ರೋಚ್ ಆಗಿಲ್ಲ ಅಂತ?
ಅನಕ್ಷರ ಕೆ ಮಾಡಿ.
ಪೇಜ್
ಪೇಜ್ ನಂಬರ್ 87.
Government,
ಸರ್ವೆ ನಂಬರ್ ಇಡುವಲ್ಲಿದಾರರ
ಪ್ರೊಸೀಜರ್ ಅಂತ ಇದೆ ಸರ್.
yes, my lord. Please kindly tomorrow, my lord.
ಅದಕ್ಕೆ
I will
ಪ್ರೊಸೀಜರ್ ಅಂತ
secure
ಇದೆ.
the notice and all.
ಇದಕ್ಕೆ when the matter is listed, you should be here with all the information.
Yes,
Annexure K,
ಪ್ಲೀಸ್ ಮಾಡಿ.
ಎಲ್ಲಿದೆ?
ಸರ್ವೆ ನಂಬರ್ ನ ಇಡುವಲ್ಲಿ
ಒತ್ತುವರಿ ಮಾಡಿರುವುದಿಲ್ಲ.
ಮಾಡಿರುವುದಿಲ್ಲ.
ಇನ್ನೇನ್ ಮಾಡಿ?
in the.
ನೀವು ಕೊಟ್ಟಿರೋ ಸರ್ವೆ
Subsequently, survey and all this done and.
ಎಷ್ಟು ಸರ್ವೆ ಮಾಡ್ತೀರಾ ಒಂದ್ ಪ್ರಾಪರ್ಟಿಗೆ? ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಕಾಣೋವರೆಗೂ ಸರ್ವೆ ಮಾಡ್ತಾನೆ ಇರ್ತೀರಾ?
It is a government property, my lord. It is a used to
Definitely.
public.
ಕರೆಕ್ಟ್ ಸರ್. ನೋಟಿಸ್ ಕೊಟ್ಬಿಟ್ಟು
Yes, my
ಮಾಡ್ಬೇಕು.
lord. Kindly.
ಲಿಬರ್ಟಿ ಇಸ್
tomorrow-
ಆಲ್ವೇಸ್ ದೇರ್ ಟು ಯು.
Please kindly tomorrow, my lord.
ನೋ ಸರ್. ಎಸ್.
It's a public purpose.
ಅಯ್ಯೋ ಏನ್ ಎಲ್ಲದಕ್ಕೂ ಪಬ್ಲಿಕ್ ಅಂತ ಇದ್ದೀರಾ? ಅದು
ಅಲ್ಲ,
ಪ್ರೊಸೀಜರ್ ಇದೆ.
Government only.
ಕರೆಕ್ಟ್. ಎಸ್, ನೀವೇ ಒತ್ತುವರಿ ಆಗಿರುವುದಿಲ್ಲ ಅಂತ ಹಾಕಿದ್ದೀರಾ ಇಲ್ಲಿ.
ನೋ ಮೇಡಮ್.
ಅಲ್ಲ, subsequently kindly, my lord.
ಸಬ್ಸಿಕ್ವೆಂಟ್ ಏನ್ ಸರ್ವೆ ಆಗಿದೆಯಾ ಮತ್ತೆ?
ಹಾಗೆ ನಂತರ.
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಪಶ್ಚಿಮಕ್ಕೆ ಓಣಿ ಇದೆ ಅಂತ ಹೇಳಿದ್ರು, ಮತ್ತೆ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ದಕ್ಷಿಣಕ್ಕೆ ಇದೆ ಅಂತ ಅವ್ರೆ ಅನಕ್ಷರ ಏನ್ ಮಾಡಿದ್ರು, ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ.
List on Tuesday in the fresh matters list. If you don't get info, I'll allow it. Yes.
16.
Interim order ಇದೆಯಾ? There shall be an interim order of stay of further
My lord,
proceedings till the next date of hearing. Yes.
Petitioner, split up
15.
Split charge ಕೊಡಿ. Page ಹೇಳಿ fast.
page 19,
Acquittal order page paragraph.
19 para 12,
Page
19 para 12, man. PW 1 to 3 are become hostile and then acquitted. Para 12,
ಏನ್ 380 ನಾ?
ಹಾ.
Theft.
yeah, 457 and 380.
Mobile phones. hostile matters, PW1 and PW2 and 3 are major witness, Caesar major. They are also
Petitioner
hostile.
is before this court calling in question continuance of proceedings in CC 565 of 2024 hyphen a split up charge sheet against him for offences punishable under so and so. The heard so and so. Facts in brief, Germain, are as follows. A crime comes to be registered in crime number 294 of 2017 against 5 accused for offence punishable under section 457 and 380 of the IPC. The police, after investigation, file a charge sheet in CC 271 of 2018 on 18/9/2018. The petitioner at the relevant point in time was not available for trial. The concerned court draws up a split charge sheet against the petitioner in CC 565 of 2024 and tries the other accused. The trial against other accused 1, 3, and 5 results in their acquittal in CC 271 of 2018. The reason for acquittal could be gathered from paragraph 12 of the said order. In CC 271 of 2018, the said paragraph reads as follows. The allegation was for the offence under section 457 and 380 of the IPC. The witnesses PW1 to 3 have not supported the case of the prosecution. They have turned hostile. Therefore, emerges the order of acquittal against the petition against those accused 1, 3, and 5. If the accused 1, 3, and 5 on the aforesaid reason have been acquitted, it can hardly be noticed or even considered that the very witnesses who had turned hostile would come and depose against the petitioner accused number 2 in this split up case. Therefore, while observing that, therefore permitting further trial against this petitioner for an eventual acquittal, would only be waste of precious judicial time. Therefore, I deem it appropriate to notice. I deem it appropriate to obliterate the proceedings against this petitioner. Following the order of acquittal, making the order of acquittal to accused 1, 3, and 5 to become to inure to the benefit of the petitioner. The view of mine, sir. Published.
17.
My lord, in this matter, B report filed, my lord.
Correct. B report ಹಾಕ್ಬೇಕಾಗಿತ್ತು. Otherwise stay ಮಾಡ್ತಾ ಇದ್ದೆ.
ಅಲ್ಲ ಕ್ಲೋಸ್ ಮಾಡು.
ನೋಡಿ. B report order. Yes. ಯಾವ atrocity ಇದೆ. ಅವು ಏನೇನೋ. Yes. Next.
18.
Amazon.
Yes.
Yes, sir.
Please, Your Lordship. My lord, here some point of law we have raised in this petition. My lord, kindly go to charge sheet, my lord, at page 61, Your Lordship.
60.
My lord, I received the tabulation. I will submit regarding that later.
Huh.
My lord, here, kindly go to 61, my lord.
Yes, sir.
My lord, column number 7, my lord, is the charge sheet allegation.
Huh.
My lord, as per this charge sheet allegation, my lord, online mode of booking of articles, my lord, is ಬೆಂಗಳೂರು ನಗರದ HPR ಲೇಔಟ್ ನಲ್ಲಿರುವ ಅಮೆಜಾನ್ ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್ ನಲ್ಲಿ ಇನ್ವೆಸ್ಟಿಗೇಟಿಂಗ್ ಮ್ಯಾನೇಜರ್ ಆಗಿ ಸಾಕ್ಷಿ 1 ರವರು ಕೆಲಸ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. ಆನ್ಲೈನ್ ಮಾರ್ಕೆಟಿಂಗ್ eBay ಇಂಡಿಯಾ ಲಿಮಿಟೆಡ್ ಕಂಪನಿಗೆ ಗ್ರಾಹಕರು.
Who is the complainant? Amazon?
Yes, Amazon's.
All right. Yes.
ಆನ್ಲೈನ್ ಮಾರ್ಕೆಟಿಂಗ್ eBay ಇಂಡಿಯಾ ಲಿಮಿಟೆಡ್ ಕಂಪನಿಗೆ ಗ್ರಾಹಕರು ತಮಗೆ ಬೇಕಾದ ವಸ್ತುಗಳನ್ನು ಬುಕ್ ಮಾಡಿರುತ್ತಾರೆ. Customer will book through eBay. eBay in turn gives an order to Amazon. Delivery of product to the customer's address.
All right.
The return form should be pickup bag delivery should be at the address where the article was delivered.
All right.
Payment should be, my lord, return payment should be, or payback payment should be to the ID of the customer who had booked the article through eBay.
Hmm.
Now here the question, my lord, before going to all that factual aspect, you see, this is a method of online mode of commission of offense. There was no direct contact between the persons. Since online mode of transaction is affected, my lord, if at all, if any cheating had happened, my lord, offense of section 16(6)(d) of Information Technology
IT Act.
attracts. My lord, that is the special enactment.
420 will not get it.
420 will not attract because there was no inducement to anyone here. Ingredients of 420 does not come here.
Yes.
66(d), my lord, that which is the offense under the Information Technology Act, it provides certain special procedure under the act. My lord, the offense under section 66(d), my lord, is a non-cognizable offense. And my lord, the offenses of 66(d) should be investigated by a cybercrime police station and of a rank of inspector only.
So that is not the offense now. Only 420 and
This
34.
is only a camouflage. They have not applied the law. My lord, invoking of 420 does not arise in the, my lord, you lordship may kindly see, this is the charge sheet now filed.
Yes, it is.
We have to advert to the facts and allegation made in the charge sheet, not the section quoted by the police.
All right.
My lord, under 190, my lord, facts constituting an offense, my lord, for which cognizance should be taken. Facts alleged in the charge sheet, my lord, it is of
No, cognizance is taken for 420.
420, it is cognizance is taken. My lord, facts alleged in this case, my lord, constitutes an offense under section 66(d) of Information Technology Act.
Yes, sir.
If that is so, my lord, the procedure is, my lord, 66(d), my lord, it is punishable to the extent of 3 years.
Hmm.
To the extent of 3 years, only an offense which is punishable 3 years and above is cognizable. Up to 3 years, my lord, it is non-cognizable. My lord, the proceedings, my lord, now the charge sheet filed, my lord, for a non-cognizable offense without the permission of the magistrate, registration of FIR.
It is non-cognizable. Which is non-cognizable here.
66(d) constitutes, my lord, that's what.
That's all right, but crime was registered for what? 420.
Yes, that registration.
Where is the question of magistrate's permission?
That is the reason, my lord, I am submitting to your lordship that the very registration of FIR, my lord, FIR complaint to your lordship may kindly see, FIR itself, my lord.
So your suggestion is that the contents of the complaint only point at 66(d) and not
Yes,
420.
yes, no other.
Charge sheet is filed under 420 and it only constitutes 66(d). 66(d) is a non-cognizable offense. Permission of the magistrate had to be taken.
My lord, very registration of FIR itself, your lord.
Say it's for 420, sir.
My lord, 420, it is.
Don't know. See, crime is registered for invoking many offenses.
My lord, no other offense, your lord.
No, that's what. Yeah, hypothetically to tell.
Please.
Crime is registered invoking many offenses. It's an amalgam of both cognizable and non-cognizable. You don't need the nod of the magistrate in that. Here it is a cognizable offense. Crime is registered. Whether contents would meet that crime or not is a different thing.
Yes.
It is a charge sheet.
Yes.
Now 420 is a cognizable offense. No necessity of magistrates.
But here I am challenging the very registration of FIR, my lord, for 420 it is. My lord, kindly see the complaint, my lord, it is. My lord, online mode of cheating, my lord, it is alleged in the complaint. My lord, for this, my lord, the specific provision under the special enactment is there. My lord, IT Act is a special enactment. My lord, penal provision is 66(d).
You will permit them to invoke.
My lord,
will permit the court to invoke.
Yes. My lord,
66(d).
here, for that, my lord, that the hurdle is, my lord, right from the stage of FIR, my lord, that. My lord, there are case laws for
Please
that.
give it.
Yes,
give it. Yes.
When a special enactment, my lord, is there, the power has to be exercised under that.
Yes. Now, who are the complainants? Who are these petitioners?
My lord, and one more aspect, my lord, in respect of accused number 2, my lord, there is no material as per the tabulation itself. She is a lady, my lord, her role is not there. My lord, in this your lordship may kindly.
After circuit.
Yes. My lord, your lordship already
Yes, open
considered
hour.
this.
Yes.
My lord, under PMLA Act, my lord,
Yes, sir.
when
Yes,
the offense, my lord, described under the special enactment, the power how to deal a person, my lord, is also described under the special enactment. The power has to be exercised under that act, not under the general law. This is, my lord, that kindly go to para 11, your lordship. Para 11, my lord, that Mr. S.V. Raju learned additions also made a civil attempt to contend that the power of seizure is available under 102 CRPC, which has been exercised, and as such, freezing of account would remain valid. We are unable to appreciate and accept such contention for more than one reason. Firstly, as noted, it has been the contention of respondent 4 that the PMLA is a standalone enactment. If that be so, and when such enactment contains a provision for seizure, which includes freezing, the power available therein is to be exercised and the procedure contemplated therein is to be complied with. Secondly, when the power is available under the special enactment, the question of resorting to power under the general law does not arise. Well, this is the general principle of law, my lord, the interpretation, and also
We'll
the
consider.
special enactment.
Yes.
Thirdly, the power under section 102 CRP is to the police officer during the course of investigation. The scheme of provision different from the scheme under the PMLA Act. Kindly paragraph 14, my lord, this your lordship already, my lord, I submitted to lordship. The Taylor versus Taylor, the principle, my lord, that it has been that. When a power is given under the special enactment, that power, that my lord, it has to be exercised with that. Now, general law do not apply here. My lord, IPC offense, my lord, that 420 is the general law. But for a particular offense, my lord, special enactment is there. Well, special provisions which is inscribed under the special enactment is to be followed. Well, 66D, my lord, is the correct provision, my lord, for which, my lord, the penal act constitutes. Well, in this, my lord, kindly section 81, my lord, that overriding effect. Well, irrespective
Under the
of
IT Act. Under the IT Act.
under the IT Act.
Yes.
Well, the law prevails than any other enactment. Apart from this, section 78, my lord, (77B), yes. Notwithstanding anything contained in the Code of Criminal Procedure, the offence punishable with imprisonment of 3 years and above shall be cognizable, and the offence punishable with imprisonment of 3 years shall be bailable. Well, 66D, let me kindly see, it is to the extent of 3 years. To the extent of 3 years is not 3 years and above.
Non-cognizable.
Non-cognizable. Well, FIR for an offence, my lord, for the allegation for which it is made, my lord, not for 420, it should have been FIR, my lord, for 66D. Well, 66D requires.
The accused is wanting to choose the offences as well.
My lord, the accused is entitled for procedural protection. That is what,
That's
my
all.
lord, that
Procedural protection.
I am only on this, your lordship, that offence, if it is committed, my lord, it never dies. My lord, it remains. It can be, my lord, invoked and punished any time. But the accused is entitled for procedural protection, which is guaranteed under Article 21.
Yes, sir.
My lord, procedural protection, my lord, when the law is enacted by the Parliament for a particular purpose, my lord, that law should be invoked, not any other law. That has been interpreted by the Supreme Court in that case.
So that's the submission.
That is, my lord, that if it is, my lord, the FIR lodged by Amazon constitutes offence under section 66D. Registration of FIR for offence under 420, my lord, is illegal. It is an abuse of process. It is only, my lord, they use it to overcome the hurdle of obtaining of permission under 155(2). My lord, therefore, my lord, the FIR registration of FIR is bad in law because offence is not cognizable. For a non-cognizable offence, there should have been a permission under 155. The very FIR goes here. offense do not die, my lord, Lakshmi kindly this.
I
Offense
know.
will not go away.
Complaint will not die, only the
Yes, yes,
registration
my
of
lord,
crime
that
will die.
registration of FIR, my lord, that this is bad in law. Consequently, filing the, my lord, once the FIR is registered, if suppose, my lord, in this case, if the FIR procedure, my lord, is followed with that of 155(2), then, my lord, investigation is taken. My lord, under the Act, my lord, section 77, my lord, the power of investigation should be by
Cyber police.
not only that, by an officer of a rank of inspector. Now, you Lakshmi kindly see the charge sheet is filed by a sub-inspector. He has not been authorized to file a charge sheet, nor
Offense IT Act alle illa. Why do you want to take the person who is
my lord,
authorized?
you Lakshmi kindly appreciate this, my lord. This IPC do not constitute an offense here. For the facts, my lord, that
So everything now we are thinking hypothetically that it does not constitute an offense under IPC. So it is only a constitution under IT Act. So the authorized person had to do it. He has not done. There is not even an offense registered under IT Act. We will see whether it is correct or not.
my lord, my submission
These
is,
questions will come if the offense had been registered under IT Act
Sorry,
and an investigation had taken place under the IT Act.
that the investigation has not taken place. It is, my lord, invoking of 420 is a camouflage.
That is, that will.
That the police have used this only to overcome the hurdle, my lord, of 155(2). My lord,
Sir,
we are-
that need not have been done. They could have added 66D and 420. Hurdle need not be there at all
my lord,
because 155(4) protects it.
155, my lord, will not protect.
155(4) protects if it is an amalgam of non-cognizable and cognizable.
What, my lord, that
Correct?
is my submission.
So they could have easily invoked 66D along with 420.
Yes, yes, my lord, in an identical case, my lord, that many of the reported decisions were under section 78 and 79 of Police Act. My lord,
They
where
include 420 there.
420 include-
Only to get over the
But
rigor
get
of
over, my lord,
155(2).
like this, my lord,
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ಬೇಕಾದ್ರೆ 420 ಬಿಟ್ಬಿಡ್ತಾರೆ 7980 ಮಾತ್ರ
those
ಇಡ್ತಾರೆ.
kind of
So
cases.
Justice Pandindar ಅವರು ಹೇಳಿದ್ದಾರೆ
Pandindar ಅವ್ರು-
that is
Madam,
ಹೇಳಿರೋದೇನು ಅಂದ್ರೆ that only to get over the rigor of 155(2) they invoked 420. ಇಲ್ಲಿ 420 ನೇ ಇದೆ beginning and ending.
That is what invoking of 420 is to overcome this, my lord, this non-cognizable procedure.
ಜೊತೆಗೆ ಏನಾದ್ರು ಮಾಡಿದ್ರೆ that submission.
Not only, my lord, independent, still worse it is. You also kindly see that the foundation, what it is started, the registration of FIR. My lord, here complaint is lodged by Amazon representative.
Yes.
Allegations, my lord, that by online mode, my lord, this company has been cheated. My lord, facts alleged in this do not constitute an offense of cognizable in nature. But it is, my lord, constitutes an offense under 66D of IT Act, which is a special enactment
We'll consider
that should
this.
prevail.
Yes.
My lord, FIR could not have been registered. Very registration of FIR in this case is bad in law.
Correct.
Because it do not constitute an offense of 420. My lord, registration is done by the police for 420 is an abuse of is without power. It is without authority of law. Because it do not fall within the purview of section 154 to register an FIR. 154 registration of FIR arises when an information of a cognizable offense. This information is of a non-cognizable offense. The registration of FIR is totally an illegal and abuse of power.
All right.
Well, with this, my lord, if the FIR had been registered for 66D, well, the investigation should have been done by an officer of a rank of.
Everything under the act will
Yes,
have to be
yes, my
followed.
lord, under the act, my lord. This is the guarantee, your lordship, that, my lord, under the Prevention of Corruption Act in A.R. Antule's case, my lord, this was the discussion that was. My lord, constitutional bench judgment, my lord, where the special enactment provides a procedure as to how to take a cognizance, on which report, my lord, a cognizance has to be taken. My lord, in this case, my lord, the charge sheet filed by an officer not of the rank of inspector.
That is IT Act.
IT, yes, yes. IT Act, my lord, that he is not the rank of inspector. He is below the rank of inspector.
All
The
right.
requirement of.
If IT Act is applicable, all that will definitely come into play.
Yes, my lord, my only submission, my lord, here, my lord, with respect to this transaction, my lord, the allegations constituting offense, my lord, is only of 66D.
All right.
420 do not attract. They have misused the power, my lord, by quoting section 420. My lord, with this, my submission, my lord, that in Bhajanlal's case, my lord, if the FIR is registered, fast disclosures only non-cognizable, but FIR is registered is one of the ground, my lord, that in the parameter 4, my lord, of 104, 102 paragraph, my lord, that what the lordships have described. Suppose if the FIR is registered for a offence which is not cognizable but non-cognizable, my lord, this is one of the ground for quashing of the proceeding. My lord, I need not.
Yes.
Bhajanlal's case, my
Bhajanlal
lord,
is not
that
required.
parameter 5.4, my lord, it constitutes this. Now, with this, my lord, what I submit your lordship, in the circumstance of the case, the mode of commission of offence covers under the special enactment, not under IPC. My lord, IPC do not apply at all here. When special enactment is there, general law should not be resorted to because of the overriding effect under section 80. With this, my lord, my submission is the charge sheet filed and also, my lord, the order of taking cognizance, my lord, is totally without application of mine. And my lord, that there is no order for issuing summons. Now, my lord, the recent decision of Rajshekhar, my lord, the lordship following this, there shall be an order under 204 to summon the accused. Kindly see, my lordship,
That I have seen.
this, my lord,
That point, yes, you have.
yes, my lord, here the order, my lord, the particular portion of order, there is no issue SS to accused number 1.
Yes.
My lord, this is not, my lord, a compliance of.
No, that's a matter of record.
Yes,
They cannot improve on that. We'll
yes,
see.
your lord.
Yes.
This is one aspect, my lord. Added to that, on merits, your lordship, my lord, the allegation is, my lord, customers have booked the article through eBay, which is, my lord, which is the agent's, my lord, a commercial unit accepts order, accepts the money for the article, then, my lord, places an order. My lord, here the product which was being given delivered, the customers who have received, my lord, they have not complained. The delivery address, my lord, is of the respective customers. Return delivery also should be at the respective address only. Amazon has issued a guidelines, my lord, e-return mode, what procedure has to be followed. My lord, they have not followed. My lord, now the diagram, my lord, what it was last time brought to your lordship's kind notice. My lord, the diagram which is very clear that return delivery is at a different address.
Like the table which
Will-
I created, my lord, it's there.
Kindly
Where-
page 213, your lordship.
2-1.
No, this is prepared, my lord, for the purpose of, my lord, understanding it is not a document, my lord, that.
Illustration.
It's an illustration, my lord. They are explaining it in this mode of customer places order on eBay, lordship in top left, my lord.
Yes, sir.
eBay with seller and makes the payment. My lord, customer, eBay.in, eBay top rated seller, lordship kindly that, then Amazon, then you lordship down, my lord. Return to sender, here Suchiro item is picked up from the different address. Well, they cannot, they should not. It is their fault it is. Well, there is no inducement here. There is no promise, my lord, that the customer has not placed an order for return delivery. The return delivery also not at the address of the accused. The return delivery, my lord, that could have been made only with the order by eBay. eBay, my lord, has not placed an order for return delivery and for return refund of amount. Lordship, the mode which was adopted by Amazon is totally contrary to the guidelines, my lord, fixed by Amazon authorities. My lord, for this, your lordship may kindly see. Yes, sir. My lord, eBay's guideline, e-return mode, my lord, your lordship may kindly, it should be at the end. the first page itself, my lord. It's refund mode, my lord, and picking up return delivery should be addressed where the original article was delivered. This is the mode, my lord, and the guidelines which is fixed here.
Yes, sir.
My lord, now in respect of this, your lordship, as per this diagram, my lord, the illustration what they have given, itself, my lord, is the wrong mode they adopted. But the fact is, return delivery was not given by any of the accused. Fact that none of these, my lord, accused have placed orders, nor they have booked anything, nor they have given any order either to eBay or to Amazon. The defective article is received, please pick back. Written order was not placed by any of the accused. No phone call, no proof, nothing is there. Now, my lord, that in respect of the tabulation given, my lord, in respect of accused number 1's account, amount is refunded. That is the allegation. Accused number 1, your lordship. Now, my lord, so far as accused number 2 is concerned, my lord, not even a single item she has applied or adopted the mode of return or mode of ordering any article. She is a lady, my lord, except her address being misused by somebody, my lord, her role is not there. Because one of the item, my lord, was picked up with that address, my lord, she has been arrested and produced before the magistrate without knowing what it is. My lord, the entire charge sheet, my lord, in respect of accused number 2 is concerned, absolutely there is no material. Her role is not there at all.
ಈಗ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದೀರಾ?
ಅವ್ರ ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ. She is not involved in this. So far as A1 is concerned, my lord, accused number 1, the amount as per the tabulation, my lord, is refunded to his account. There is an item, my lord, for having paid also to Amazon by his own account.
Yes.
There is a deposit also. With this, my lord, what I submit, your lordship, in respect of A1, if at all, now, as per the invoice, my lord, invoice is submitted by eBay. My lord, a lady by name Ankita Sanyal is the lady on behalf of eBay has filed an invoice for refund of money. It is Ankita Sanyal, my lord, who has committed the offense. Mere crediting of amount to the account of accused number 1 do not constitute an offense. My lord, with this, my lord, what I submit that unless that Ankita Sanyal, who has filed the voucher, is arrested or is shown as at least an absconding accused, it do not constitute an offense. Independently for this accused number 1, I am concentrating. My lord, with this, my lord, that the investigation with respect to Ankita Sanyal has not been diverted into, and my lord, the investigation is incomplete. My lord, on an incomplete police report, cognizance cannot be taken. You know, this is what, my lord, I could make out that. Kindly see, my lord, the voucher, what it is filed, my lord.
We'll hear the respondent. Rejoinder and Ridra, my lord.
Yes, sir. My lord, with this, my lord, in respect of A2 lady, my lord, she is innocent. She has no role at all in this transaction.
We'll see.
And the further submission, my lord, if at all, I may be given.
Yes. If necessary. Yes, sir.
Submission, my lord, your lordship recall that I have not placed an order. I have not received money. I have not received refund. Lordship may take this table which I prepared. The table, my lord, speaks about, I put their serial numbers to identify, and invoice numbers and invoice page numbers in the petition also, my lord, this is been referred. Now, your lordship, take the bank statement available next. The bank statement, my lord, has a blue ink and red ink.
Yes.
The blue ink has a serial number. That is the serial number indicates purchase. And the red ink will have the same serial number, indicate the refund of that amount. Your lordship may see in the first page, my lord, as the serial number 3 as 72,999.
Correct.
That your lordship will see in the next page, which is the serial number 3 in the red ink, the refund of 72,993.
Correct.
So all these transactions, as many as 104 transactions.
Jump agide numbers, not 104. It may be about 48 transactions.
I'll take it, my lord. If they're saying 48, I'll take it. No problem.
48 and then
No problem. All these transactions have orders of place from his account. Money was spent from his account. of the items was delivered.
Both accused 1 and 2?
No, accused number 1.
All right.
The items was delivered to accused number 2.
Hmm.
2's house. Your Lordship, now take the same table, my lord, has the delivery date and delivery state, and sometimes we have indicated the address. Address, my lord, is there in the charge sheet, shows that accused number 2's address has been delivered, and some of the items are picked up from accused number 2, and some of the items are picked up from different locations.
Now, the modus operandi, according to you, is that the accused number 1 places the order. Who is this Anita Sanyal?
She is the relative of accused number 1,
All
whose
right.
house some of the items are delivered.
Now, order is placed by accused number 1.
Yes.
Order is from eBay.
Yes, sir. Amazon.
Amazon.
Yes.
Order is on Amazon.
Yes.
Amazon delivers it to whom?
To accused number 2, some of the items, to various other addresses as well.
All right.
Majority are delivered to accused number 2.
All right. Now, there is a return.
Yes.
Return initiated.
Yes. What they do while returning, they don't place the original, they don't give the original articles. They exchange that original articles. If I'm ordering, my lord, for example, iPhone's earpods. So I take the.
Sorry, that little correction, Your Lordship. For better understanding, not intervening. Well, that is not the mode here. My lord, the customers who book the articles, my lord, they have received the genuine article, they have accepted. They did not complain that we have received defective. And they have not complained also. This is the.
No, customers have received the articles genuine, but when return is being made, they were not genuine articles. That
Yes.
is the
My lord,
allegation.
that is, my lord, that is what it is. My lord, return could be by a customer only.
It is
This
money.
is what it is. My lord,
Return is by a customer. Understand? No,
no, not in
no,
this.
no. 1 minute. Return can be by the customer only.
Yes, yes.
But why did money come into your account on that return?
Yes, it is because that is what it is. My lord, I could understand this.
It should go to the customer's account.
Yes, it should go to
Why
customer's
did it come
account.
to your account?
No, that is was the mistake played by this Amazon. It is not placed by. Lord, fact is that the customer's name list, you will kindly column number 2, my lord, in the tabulation.
So don't you think, sir, this is a maze of facts and it would
It is,
require
my lord,
evidence?
very
It
difficult.
would require evidence.
Very difficult to understand the transaction
No,
itself.
that is why it would require evidence.
Please.
It would
No,
require
not
evidence,
that.
a full-blown
My lord,
trial.
It is not comprehensible. You kindly.
No, it is not
Even-
incomprehensible, but indeducible here.
No, not like that. You kindly see, my lord, even if this matter goes for trial, the trouble will be the same. It is, my lord, that. No, I am not saying that. My lord, kindly see column number 2 in their tabulation, my lord. Persons who place orders, my lord, all these, they are the customers.
No problem, sir.
My lord, their case, my lord, is these customers, they have received genuine articles.
They have received genuine articles, no
Genuine
problem.
articles. They did not complain also.
No
They
problem.
did not adopt.
They have initiated return.
No, not.
No, you have initiated return
No,
of
not that,
articles.
my lord, not this accused. Your lordship may kindly see an employee who was, my lord, in eBay. Your lordship may kindly, it is eBay who had the.
That is Anita Sanyal.
Ankita Sanyal,
Ankita
my lord,
Sanyal.
is the lady who had all this information.
It appears to
She
be
has,
cohorts in crime. Yes.
my lord, that lady, my lord, has not been investigated. As per my lord voucher, what I could make out, it is like this. My lord, there is no role of this accused or of accused number 2.
Yes.
Either ordering for return mode or accepting return mode from them.
But anyway, money has come into your account.
Well, except this, my lord,
69 lakhs. ಎಷ್ಟು?
my lord, not to that
69
extent.
ಲಕ್ಷ ಅಲ್ಲ?
Yes.
69 lakhs, my lord, in the
correct.
charge sheet allegation is. But this amount, my lord, which is credited to the account of accused number 1 is not to that extent.
Some extent.
Well, some extent it is.
Same
My
amount.
lord, but as per the bank account, my lord, the reduction debit transaction also taken place.
That's correct.
This is surprising it is. Well, lord, from his account to the Amazon, from his account amount is also debited.
Now,
Not
Lord-
only credit it is.
Ingenious modus.
Your Lordship may take one example,
No,
page
their
258.
account, my lord, it is.
Your Lordship may take
Not
page
that.
258 of the petition.
Yes.
Now, this is the invoice generated at the time of purchasing,
258.
258.
Yes.
Your Lordship, this is placed by the accused number 1.
All right.
This, my lord, in my table is serial number 2. Now, this is shipped to Ahmedabad, and your Lordship may see the item. Largely, these kind of items were placed,
All right.
and while returning, will not be this item.
Return is initiated by whom?
Same person. Ultimately, I have paid money and purchased it, and I have to initiate return.
Yes.
But the return pickup is not from this address.
Return pickup is from which address?
Different locations.
Return is initiated by the customer?
By the customer, and amount because I initiated a return and I have received the money back to my account. Now, the gain for the petitioner here is he paid the money initially, he got the product, he sent it back, duplicate one, got the money back. Now he has the product with him.
The genuine product is with him and the money of that product is also with him.
With me.
When a product has gone to customers, your lordship, is not, it is a misunderstanding, my lord, that it requires a correct information to deal this matter.
Your Lordship may see at
My
page
lord, none
219.
of these customers have
Page
complained.
219.
Customers have received
Now,
union
who has complained? Amazon has
Amazon has
complained.
complained. Because ultimately, my lord, when they're doing the Amazon has to, Amazon is a service provider technically. So Amazon, when they say that, the product was replaced because you were the one who shipped this product and replaced it back, saying that the product is not correct. Amazon has to pay back to the.
Now, the return, when the product is returned, this man places an order.
Yes.
Accused number 1 to a particular address. Now, return is initiated by that customer or this man?
Same customer.
Same customer. So, when the product goes back, the amount comes back.
That's correct.
The amount comes back to his account,
His account.
not to the customer's account.
No, the person who purchased it. Yes, yes.
Who is the purchaser?
Accused number 1.
So
And
he
loss,
purchased.
no income it is.
No, he purchases. He
Received it.
received the genuine product, initiates return, sends the product back and gets back the money. So while sending the product back, some other product is sent.
A simple example on iPhone earphones. Now, if you go to national market, you can buy it for 2,000 rupees. A similar thing looking. What I need to do is take the box. Box is the same. I take the device out and replace the 2,000 rupees one and I keep the 25,000 rupees with me.
So you get back 25,000.
That is not the correct understanding as per the documents produced, my lord. It is a eBay official, my lord, has played a part.
And you will also see
It is
all the
eBay
orders.
official, my lord.
If somebody has been left out, I will also direct them to file
That is
application
what,
under
my lord,
319
that-
to bring
my
them
lord,
in.
This transaction, my lord, normal mode, my lord, is if a customer places an order to Amazon, my lord, article will come to the window delivery, door delivery, my lord, that pick up back also at the door delivery only. It cannot be at the address is different from that.
So that is an option of
And
choosing. And
no option, my lord. That is what the e-return mode, my lord. The guidelines given by Amazon is that I have placed on the call. My lord, the return delivery should be at the address where the original article was delivered. It cannot be at a different address. And from the particular customer and ID number, after verification, everything it is. Now the my lord, only on the basis of some amount is credited to his account. It cannot be that he has played a role of committing offense under 66D.
Return all the money that is credited to your account.
Which, my lord?
Give back all the money.
My money has gone in. That is what it is. Account is showing. You lordship may kindly see that Federal Bank account, my lord, amount is debited. From his account, my lord, amount is debited and amount is credited. There is no loss, no income for him. That is what it is shown as per their own document it is.
Yes.
And with
My
respect,
lord, somebody, my lord, has gained it on behalf of, that is the employee of eBay, not by this accused.
We will direct the prosecution to file application under 319 to bring in that employee also.
with respect to
Without
66D
a
being,
procedure of investigation, 319 cannot be added. Only that there is no evidence for 319. my lord.
We'll see.
66D being
My
not
lord,
cognizant.
At the time of evidence, it will happen.
My lord, your lordship may kindly see by your lordship if orders for re-investigation.
No, I am not, sir.
My lord, if it is, my lord, truth can be known. Otherwise, my lord, that this
We'll see.
material will going to collapse. In any manner it is. It will not be an understandable. It is
Clearly, we
whatever
let
it may
them
be.
face trial at least.
My lord, but so far as A2 is concerned, my lord, there is no role, your lordship. She is a lady. residing at Kolkata.
No,
My
Bangalore.
lord, she has not played any role in this.
Well, we'll see. Yes.
And with the,
Heard,
with the
reserved.
tabulation, what it is, my lord, will Lordship may kindly consider, my lord.
Heard reserved.
66 D may being non-cognizable, my lord. Senior counsel may be wrong, my lord, but Supreme Court in 2022 221.
I have myself written it is cognizable. Don't.
66D, my lord.
Correct.
66D
I have
punishment.
myself written it is cognizable. Supreme Court also reiterated it later.
That I have to verify.
No problem.
My understanding, my lord, that to the extent of 3 years, my lord, as per schedule 2, my lord, it is non-cognizable.
Exactly what I have said. To the extent of 3 years, it makes it cognizable.
That is what Supreme Court
But that-
2022.
That's
my
what
lord.
Supreme Court also has written, sir.
My lord,
I wrote it December 2022, then Supreme Court later wrote it.
to the extent, my lord, is not clear 3 years.
That is exactly what I have written. Supreme Court also reiterated. Yeah, this is Nagaratna Vardala.
Yes.
Yes,
Your Lordship may kindly in
Understand.
respect of accused number 2, my lord.
that will see.
No.
That will see.
All items are picked up.
Heard reserved, yes.
Would like
19,
stay to be extended.
Sir.
Stay interim order.
My intermodal will continue, reserved.
Petitioner. That's petitioner is accused number 11, please. In FIR 205 of 2024, initially, FIR came to be registered on the information by respondent number 3, stating that accused number 1 to 10 have assaulted the victim on
Where did you figure?
Well, I didn't figure in the FIR, but somewhere in charge sheet, they show me as accused number 11. In the information, I don't, the informant, respondent number 3 doesn't name me. Respondent number 4 doesn't name me. Even in the charge sheet, the eyewitness don't state me. And accused number 13, who had an enmity with the victim, he is also Madhu. But somehow I am also named in the charge sheet as accused number 11, stating that after the 307 which took place, after they beat him up, I came to the spot and I proclaimed that this person being of lower caste, he should be
Yes, sir.
assaulted. This is the entire charge sheet, please.
Heard the learned counsel appearing for the petitioner. The petitioner is accused number 11. Allegations galore against accused number 1 to 10, which had resulted in registration of a crime in crime number 205 of 2024. The police, after investigation, have filed a charge sheet. The petitioner was not named in the FIR, but figures in the charge sheet for the following offences. The allegation against the petitioner is that he came to the spot and hurled abuses concerning the caste. The improbability that shrouds in the allegation against the petitioner would inure to the benefit of the petitioner, albeit prima facie. Therefore, there shall be an interim order of stay where the petitioner till the next date of hearing. Next,
Obliged.
1 HCGP, 2 emergent notice.
Well, let's say 1 and 2 HCGP, please. Investigating officer is 2.
Yeah,
3 and 4.
where is the complainant? 3 and 4, sorry. 1 and 2 HCGP, 3 and 4 emergent notice. Next.
This matter, I'll be coming on record, my lord. Mr. Chalke has filed the,
Enna?
Mr. Chalke has filed the NOC, my lord. Now I have to come on record. I'll be filing my wakalat in that.
Learned counsel Mahesh Mahesh submits that he would enter appearance over the weekend. List the matter. When do you want, sir?
Next week, Tuesday, Wednesday. Because
List
this
the
matter is
matter on
quietly.
list the
covered by
matter on
lordships.
15th. Interim order subsisting shall continue to the next date of hearing.
This matter, my lord. Water
For
prevention is filed by the police.
Huh?
Here, water prevention.
That's all. Covered. We'll close
By
it.
Police, where your lordships have covered. in
close
petition.
15th.
15th,
Yes, next.
fresh matters.
Fresh matters.
21,
List after 2 weeks. Next. Interim order, yeah.
Illa.
List after 2 weeks. Yes. Next.
22, withdrawal memo.
In terms of the memo.
23, party in person.
This matter had come up, emergent notice was issued.
I know that. Where is the lady who was with him the other day?
He requested me to assist him today.
Huh?
He is hard of hearing. He has requested me to assist him.
No problems. You tell him day before yesterday, I did not grant an order and I did not permit him to submit. I was wrong. He has a case. Yes. The petitioner is before this court calling in question
Obliged, Your
an order passed. ECIR. Madam, ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದೀರಾ? The petitioner is before this court. The problem was pages ಆ ಕಡೆ ಈ ಕಡೆ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ ಎಲ್ಲ. Order passed in criminal revision petition 693 of 2023. The petitioner had an order in his favor before the concerned court. An appeal is an appeal is preferred under section appeal is preferred before the concerned court, before the court of session in criminal revision petition so and so. The petitioner was not even made a party in the criminal revision petition, and an ex parte interim order is granted staying the order passed by the concerned court. Therefore, the petitioner is before this court. The observation in the order is that the original court had granted an interim order ex parte. Therefore, the court of session also is granting an order ex parte. This is blatantly contrary to law. Therefore, there shall be an interim order of stay of the order impugned till the appearance of the respondents. Emergent notice to the state one. Illa, state is not there, I guess.
I have already said. Your Lordship.
5, all right. Copy ಕೊಟ್ಟಿದ್ದಾರೆ madam? So and so. List immediately after service of notice upon the respondents. Next.
Your Lordship may be given date. Don't have digital knowledge.
1 minute, sir. List on returnable by 12th December.
CJ's court, Your Lordship, sorry.
12th December.
12th is CJ's court I have got.
When do you want, sir?
When do you want?
Give me 15th, I already given Your Lordship. I will give you
15th.
notice also.
15th November.
15th you given me November.
No, but
15th November you have given.
that won't,
I already sent notice as per the direction. of
true,
the-
it won't come back by then, sir. 5th December is okay? All right.
Obliged.
Sorry for day before yesterday.
Obliged.
I should have granted it.
Obliged.
Yes. Next.
24.
12th of May.
Your Lordship, I appear for the second respondent.
Help him. Yes.
Yes, my lord. And the learned ASG is on screen, my lord.
Withdraw ಮಾಡಿದಿರಲ್ಲ.
Yes.
Yes.
We'll close it, sir.
If he wants to withdraw, my lord, let him
We'll
withdraw.
close it.
Yes, my lords. It may be treated as quashed.
Yes,
Yes.
that is there. The petitioners are officers of the Enforcement Directorate. On conduct of an investigation, the complainant was summoned and questioned. After the complainant comes out, seeks to register a complaint which has become a crime in crime number 166 of 2024. The learned counsel for the respondent, second respondent complainant would now file a memo.
ಹಾಕಿದ್ದೀನಿ.
Would file a memo. The memo reads as follows.
Along with the email, my lord, so that may also be required.
Memo along with the communication to the counsel for the petitioner. The memo and the email communication, the electronic mail communication reads as follows. The mail is indicative of the fact that the complainant does not want to pursue the matter and would like to withdraw the complaint. In the light of the said memo being filed by the learned counsel for the petitioner.
Second respondent.
Huh?
Memo being filed by the second respondent.
Second respondent, oh, sorry, but second respondent, the petition, the crime requires to be obliterated. So as a matter of form, the following order. One quashed, disposed, quashed.
Offenses are compoundable, my lord, if it is mentioned in the.
Yeke, matte?
Both the sections alleged offenses are compoundable.
Very well.
Does not. How does it? Ali heard the learned Additional Solicitor General S V Raju ಅಂತ ಹಾಕಿ.
Honorable, they are non-cognizable offences both.
Yes. Anyway.
Grateful. I'm obliged, my lords.
Yes. ಸಾಕು ಮಾಡಿ. We'll continue. ಏನು ಎಷ್ಟಿದೆ notice?
My lord, one submission with regards
36 or with.
serial number 79.
For the petition.
Today they were supposed to make the payment. They have shared a copy of the check, which is going to be received by us from Monday.
All right, whoever wants time, you grant time.
No, my lord, kindly have it in the first week of December for further payment, because they are making only part payment today.
Yes. ನಿಮ್ಮೇಲೆ ಯಾಕೆ? ಮೈಕ್ ಯೂಸ್ ಮಾಡಿ. ಆನ್ ಮಾಡಿ.
On 29/10/2024, I filed a criminal petition before the Honorable Court. Still, the matter was not listed before the Honorable Court, please, my lord. So I kindly please allow my memo on this, my lord.
FIR ಯಾಕಾಗಿದೆ?
Police, please, my lord. Chick Police Station.
ಯಾರ ಮೇಲೆ ಆಗಿದೆ?
Against me, please, my lord. I am the,
Against you?
yes.
Advocate?
Yes, my lord.
Why?
Family matters ಹೋಗ್ತದೆ ಸ್ವಾಮಿ, civil dispute ಅಲ್ಲಿ. My father has initiated a FIR against the so no respond number 2, please, my lord. For that, they filed a counter case against me in absence of my place. ನಾನು ಆ ಪ್ಲೇಸ್ ಅಲ್ಲಿ ಇರಲಿಲ್ಲ, ಅದು ನನ್ನ ಮೇಲೆ FIR ಮಾಡಿ ಸ್ವಾಮಿ.
ಯಾವಾಗ ಬೇಕು?
By Monday, please, my lord.
ಹಾಕಿ ಮಂಡೇ. FIR ಕಂಪ್ಲೈ ಮಾಡಿ.
Yes, complaint.
ಕಂಪ್ಲೈ ಮಾಡ್ತೀರಾ?
Complaint ಸ್ವಾಮಿ.
ಒಂದು ಕೆಲಸ ಮಾಡಿ, ಮಂಡೇ ಬೆಳಗ್ಗೆ 10:30 ಮೂವ್ ಮಾಡಿ 2:30 ತಗೊಂತೀವಿ.
Please, my lord.
ತಗೊಳ್ಳಿ.
Sorry for this. I'm engaged to appear for the de facto complaint in criminal petition 7709 of 2023. my lord.
Serial number,
At
I
least
don't know.
5, I understand, my lord. At least 5 memos have already been filed for
Which is-
vacating the stay.
You filed vacating stay
Yes,
application?
but it has not been listed at each time. my lord. That's why I'm
24 or 23? Which year is it? 24?
23.
Madam, ಅದನ್ನ Wednesday or Thursday ಹಾಕ್ಸಿ. It will come next week definitely.
Much appreciated. Number.
Where is the memo?
It
ಈಗ
is,
ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
no, 5 memos have already been filed.
Where is the 6th one?
I should. I just came here for another case. I'm coming from Delhi, so that I'll make
Oh,
a
that's
mention
all right.
before your
Yes.
lordship.
So when do you want it?
24th, if possible, which this month, any date, your lordship feels free.
24th is a Sunday.
Yeah, I didn't see.
We'll take it on 26th.
Yes.
26th vacating stay caption. Yes. Yes, continue the list fast. ಯಾರ್ದು ಇದು? ಎಲ್ಲ ಕಳಿಸ್ಬಿಡಿ. Yes, next.
25.
For the petition or my lord, kindly pass over the matter, my lord.
Why, sir?
Additional SPP, quota 13.
Sorry, Monday, fresh matters.
My lord, for single cause of action, 3 cases have been registered, my lord.
ಏನಿದು?
One-
Gambling da?
No, my. One, there is a incident occurred in Quarry, my lord. And
No problem. List the matter on 15th in the fresh matters list. Interim protection shall continue till the next date of hearing. Next.
26.
Post immediately after service of notice upon. Sir, interim order ಇದೆಯಲ್ಲ? No, ಕೊಡಿ. What's the case, Madhu?
The initially FR was registered under POCSO offenses. Subsequently, that case, Lords, the only reason I am pressing for interim order is that there is a possibility of settlement, my lords. 498 case. I am the complainant.
ಆಮೇಲೆ ಪೋಕ್ಸೋ ಇಲ್ವಾ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ?
ಇಲ್ಲ.
On the basis of further statement.
ಅಲ್ಲ ಪೋಕ್ಸೋ ಇಲ್ಲ ತಾನೆ?
No, my lords, there is no POCSO.
Initially, folks.
ಅಲ್ಲ ಇನಿಷಿಯಲಿ ಪೋಕ್ಸೋ ಇದೆ. ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಏನ್ ವಾಟ್ಸ್ ದಿ ಅಫೆನ್ಸ್? 498/323. Heard the learned counsel appearing for the petitioner. The learned counsel for the petitioner submits that if a notice is issued to the second respondent,
Please, my
complainant, there are chances of settlement of the issues. It is complainant.
I am the complainant, my lords.
Chances of complainant, madam. The petitioner is the complainant. He would seek issuance of notice to the second respondent for the reason that on receipt of notice, there are chances of settlement. In that light, there's interim order ಏನಕ್ಕೆ ಬೇಕು?
Interim order, the complainant is not ready to pursue the matter, my lords. She doesn't want the husband to.
How
undergo
can
498.
complainant seek interim order of the proceedings against the accused?
My lords, I am seeking for reinvestigation, my lords.
Reinvestigation.
Please, my lords.
So and so. Since the complainant is before this court seeking reinvestigation into the matter, the proceedings pending before the concerned court shall remain stayed.
Grateful, my lords.
Yes. We'll list it on 4th December.
4 December.
Yes.
Much obliged.
Emergent notice, written number 4 December. Next. Agidya?
27.
My lord, your lordship, last occasion, the records.
Lordship,
yes.
last occasion records. Why this telegraph? Ah,
Sorry.
yes,
And,
sir.
Charge sheet has been filed, my lord.
ಮಾಡಿ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರಲ್ಲ ಚಾರ್ಜ್
Challenge ಮಾಡಿದ್ವಿ ಅಲ್ಲ challenge. I am challenging the proceedings of the criminal case, my lord.
CC 1685 ಅದೇ ತಾನೇ ಚಾಲೆಂಜ್ ಮಾಡ್ತಿರೋದು.
24, 504 and 506, my lord. Petition
24?
324,
324 504 ಕರೆಕ್ಟ್.
The son is
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಲ್ಲ
son charge sheet is filed, my lord.
ಮತ್ತೆ ಯಾಕೆ ಮೆಟೀರಿಯಲ್ ಏನು ಹಾಕೇ ಇಲ್ಲ ಇಲ್ಲಿ?
ಇಲ್ಲ, son was assaulted the petitioner, my lord. Already.
Father.
Father.
It's all right. Where is the charge sheet material?
The charge sheet I have filed, my lord. Material.
Charge sheet document ಏನು ಇಲ್ವೇ ಇಲ್ವಾ?
Applied for charge sheet.
Learned counsel for the petitioner to produce the entire charge sheet material by the next date. List the matter on 19th in the event charge sheet material is placed on record. Next.
28.
My lord.
Petition this case, my lord. Senior counsel is held up in another court.
Huh?
Any date in the next week, my lord.
15th in the fresh matters list. Enter ಮಾಡಿದ್ಯಾ? Next.
29.
For the petitioner in this matter, my lord.
My lord, in this matter, the prayer is decrease the account of petitioner.
Correct.
Already decreased, my lord, and
Frozen ನಾ?
B report nu file ಮಾಡ್ತಾ ಇದೀವಿ, ಇನ್ನೂ ಮಾಡಿಲ್ಲ.
ಆಯ್ತಲ್ಲ?
Pursuant to the report, this petition may be disposed of.
Yes, that only will happen. Is okay, B report format. In the light of the submission of the counsel for the learned HCGP, that B report would be filed.
No, my lord, not yet filed, but the prayer in this petition is decrease the account.
Record
Already
ಮಾಡಿ B
decrease,
report.
ಅಲ್ಲ, decrease already.
B report record ಮಾಡೋದು ಬೇಡವಾ?
ಮಾಡ್ತೀವಿ ಅಂತ ಅಷ್ಟೇ ಹೇಳಿದ್ದಾರೆ.
ಅಷ್ಟೇ ಅದನ್ನ ಹೇಳ್ತೀನಿ. The learned counsel for the petition, learned HCGP on instructions would submit that the police would file a B report in the case at hand. The issue is with regard to freezement of the account. The learned HCGP again in further instructions would submit that the account of the petitioners has already been defrozen. In the light of the redressal of the grievance of the petitioner, the petition is disposed as having become infructuous. Reserving all liberty to the petitioner to knock at the doors of the appropriate court in the event of need, ordered accordingly.
Much obliged.
30.
This is a matter where there's absolutely no material on record
For what?
to array the
NDPS.
petitioners, NDPS. The
Your accused number.
accused number one, the allegation is that there were a group of accused from 2 to 3 were apprehended in a place. And once they brought to the police station, one of the accused said that petitioner herein
No,
has given money.
Are you pinned down only on voluntary statements?
Yes. There is absolutely no
ಏನಿದ್ಯಾ?
material in the charge sheet
Yes,
also.
my lord. Kindly, my lord, charge framed on 2/1/2023, my lord. And PW,
ಅದೆಲ್ಲ ಇರ್ಲಿ.
Witness-
ವಾಲಂಟರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಬಿಟ್ಟು ಬೇರೆ ಏನು ಕೊರಾಬರೇಟಿವ್ ಮೆಟೀರಿಯಲ್ ಇದೆಯಾ?
ಇವರು ಚಾರ್ಜ್ ಶೀಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ.
ಏನಿಲ್ಲ ಅದ್ರಲ್ಲಿ. In fact, if I could just add, the case is that ನಾವಲ್ಲಿ ಒಂದು place ಅಲ್ಲಿ
proceedings.
ಇದ್ವಿ.
ನೋಡ್ಕೊಂಡು ಹೇಳಿ.
ಅಲ್ಲ, ಆಲ್ರೆಡಿ ಇವ್ರು ಫೈಲ್ ಮಾಡೋದಿದೆ PW 1 to 3 ಆಲ್ರೆಡಿ
Examined.
ಎಸ್ ಮೇಡಮ್.
Charge frame.
ಇವರು
Charge it.
23/9/2024 ಅಲ್ಲಿ
problem is-
ಇದನ್ನ ಫೈಲ್
No,
ಮಾಡಿದ್ದಾರೆ.
before filing of the petition or after filing of the petition, charge frame ಆಗಿರೋದು.
ಮೈಲಾಡ್ 2/1/2023 ಅಲ್ಲಿ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆ. ಮತ್ತೆ ಈ ಪೆಟಿಷನ್ ಫೈಲ್ ಮಾಡುವಾಗ ಅವತ್ತೇ ಸೇಮ್ ಡೇ PW 1 to 3 ಎಕ್ಸಾಮಿನ್.
Will get acquitted. All
That's true.
contentions,
Your
all
Lordship-
these contentions
Your Lordship,
before
my
that court.
difficulty is that he's a young person trying to get a job. So every time he files
That, no madam.
for some
I-
employment,
see, after framing, ಅದು 2 years ಆಗಿದೆ charge frame ಮಾಡಿ, will not entertain.
this case comes in between. That is his only problem. And that time he had a financial
I'll
difficulty.
I'll
but now
direct
invariably,
conclusion of the trial within a time frame. Yes, by Meenakshi Bala ಹಾಕ್ಬಿಟ್ಟು the learned counsel for the petitioner submits that due to the pendency of the present petition, the petitioner is not able to secure any job outside, within the country or outside the country. Therefore, in that light, and would submit that the petitioner is pinned down as accused number one only on voluntary statement of other accused. If that be so, the concerned court shall consider that be so, it is for the petitioner to urge all these contentions before the concerned court. In the light of the employment of the petitioner being at stake or not being able to secure an employment, I deem it appropriate to direct the concerned court to conclude the proceedings within an outer limit of 2 months from the date of receipt of the copy of the order, if not earlier. That's all I can. Yes, next.
31.
Grateful.
Government advocate was directed to secure instructions. Petitioner is the advocate, my lords. Complaint is
The
lodged.
Delhi da.
Chamarajanagar.
Oh, PDJ.
Please.
Yes. We'll see, we'll hear it. Iವರು ಹಂಗೆ ಆಡಿದ್ದಾರೆ. One additional SPP. Who is the complainant? ಅವರೇನಾ?
Complaint is private.
Notice has to go.
ಒಂದು ನಿಮಿಷ. One additional SPP, 2 emergent notice. The pendency of this petition will not come in the way of practice of the petitioner before the court at Chamarajanagar or any other court.
Lord, as per your lordship direction, we have filed an application, my lord, and the same has been served on the learned
Yes, Shanti.
PSGI.
Find it page, third. The memo, page
Ah.
6, my lord, annexure A1.
Page 6.
Please, my lord. Application submitted date is 22/8/2023, my lord. It's more than a year, my lord. Now the file is closed.
Fresh application ಕೊಡಿ ಅದನ್ನ ಹೇಳಿದ್
Yes, my
ನಾನು.
lords, the B report was filed in October 2023.
It's all right. You give a fresh application, they will consider within a time frame. I will direct that.
Yes, my lords, and the prayer is for squashing of the affair, my lords.
B report ಹಾಕಿದಾರಲ್ಲ ಇನ್ನೇನು.
Yes, my lords, it's been more than a year now, my lord.
I will direct the court to close the, in accordance with law, close the B
Please, my
report.
lords.
And in the
Direction.
meantime, you give an application, they will consider.
His name, even though it is Shashank, in police verification, it is coming as Bharat. But that, my lord, he'll have.
My lords, its actual name is Shashank, my lords, like
Ah.
his other name is Bharat in
Other name,
like,
you mean to say AKA Bharat, also known as?
no, my lords, its actual name is Shashank, my lords. In all the records, it is Shashank. In complaint, it was given as Bharat.
Let him justify that, no problem.
We'll give him passport, my lord, that.
Yes.
Please, my lords, our direction may be issued, my lords, for the trial.
The-
court.
Check to police.
Correct, in accordance with laws.
Please.
The petitioner is before this court seeking the following prayer. The learned counsel appearing for the petitioner submits that the police, after investigation in crime number, they are-
21.
in
21.
crime number 21 of 2023, have filed a B report before the concerned court way back in the year 2023. The said proceeding has not culminated or taken to its logical conclusion by the concerned court. Therefore, I deem it appropriate to direct the concerned court to close the proceeding in accordance with law. Either accepting the B report or rejecting the B report after hearing the complainant. The learned counsel would further submit that on the ground of the pendency of crime 21 of 2023, petitioner is not being issued with a passport. The learned DSGI who was directed to secure instructions from the regional passport office has sought instructions and would submit that the application of the petitioner is more than a year old and has been closed. If the petitioner would submit a fresh application, the same would be considered and the passport would be granted to the petitioner if it is grantable in accordance with law. The submission is placed on record. Therefore, the petitioner shall, if he wants a passport, file an application before the regional passport office within 2 weeks from the date of receipt of the copy of the order, and the application shall be processed and disposed either by granting passport or passing necessary orders within 4 weeks thereafter, if not earlier, ordered accordingly.
Grateful, my lords.
33.
Lordship, the short accommodation to secure records. Matter is stayed.
Yes, interim order was not passed on last occasion.
Yes, Soni Krishna.
My lord, the second respondent would file a complaint on the basis of hearsay. He says that I've visited the property, threatened some two guards, who in turn speak to an engineer, and he in turn speaks to the manager.
What is the suit pending?
My lord, this is a civil suit between, not between these parties.
Then-
There are civil suits in respect of these properties. Basic performance, I've supposed to have sold it to the, to a company whose
Who are you?
manager is. My lord, I'm one of the landowners, and I own some properties.
Get the records, madam.
Please.
Lord, even otherwise, my lord,
1 and 2.
unlawful assembly, two.
Minute, is learned HCGP is directed to secure the investigation papers conducted till today and place it before the court. Lest the matter on 28th, further investigation shall remain state till the next date. Yes, next.
34.
For petitioner, I request a short
15th, fresh matters. Next, at the request of the council. Idea. Lest the matter after 3 weeks, interim order subsisting will continue to the next date of hearing. Post the matter in admission in usual course. Next.
35.
Petition.
They secured the records, my lord. Then I have some time, my lord, will have to go through it. What's the
15th online. List on 15th in the fresh matters list till such time. The interim order subsisting shall continue to the next date of hearing.
Lordship permit, one matter which your lordship reserved, 9 judges bench, my lord, is reported in 2024.
2000 slum matter.
Slum
Kodi.
matter.
Hmm.
Shall I make it stitch model hage?
Kodi.
Stitch model.
Madi kodi.
Para 200 onwards. I'm sorry, my lord, for mentioning in this case. Because I thought.
That with regard to the
Section
property
20 of the Slum
distribution.
Clearance Act. Your lordship reserved, I thought I should bring it to the notice.
The opposite side ಹೇಳ್ಬಿಟ್ಟು ಕೊಡಿ. State ಗೆ.
State or slum board.
Board
State
ಗೆ.
also is there.
ಯಾರಿಗೆ? State is also there.
People party.
ಅವರು ಕೊಟ್ಬಿಟ್ಟು ಕೊಡಿ.
Please,
You can hand it over to the court officer.
I'll stitch and give it.
No problem.
36.
Appeal for the petitioner. Lord, petitioner working in the, as a surveyor in the BDA. Lord, surveyed the sketch stating that it comes under the, Lord, the acquired land of the BDA for the Kempegoda layout. No, my lord, the allegation is that, my lord, I have not verified the genuinity of the documents. But Tahsildar has, my lord, clearly, my lord, given the genuinity certificates to the land acquisition officer. My lord, land.
When did you
acquisition-
conduct this survey, sir?
My lord,
When did you conduct this survey?
well, in the year 2019, man. 19, after the receipt of the genuinity of letter, my lord, written by the Tahsildar on 1/10/2019, my lord.
Lordship, page,
Annexure D, page 48.
surveyor along with the special Tahsildar, they have conducted this survey.
Special
is-
Tahsildar is also an accused.
I have noted if she was in some other matter, it has come up before.
Well, I am not the Tahsil surveyor.
ಎಲ್ಲ ಗೊತ್ತು ಸರ್. ನಿಮ್ ಜೊತೆ ತಹಶೀಲ್ದಾರ್ ಇದ್ರಲ್ಲ ಅವ್ರು ಅಕ್ಯೂಸ್ಡಾ?
ನಾನ್ ಬಿಡಿದಲ್ಲಿ ಮಾಡ್ತಾ ಇದ್ದೆ. ತಹಸೀಲ್ದಾರ್ ಇದ್ದ ಬೆಂಗಳೂರು ಸೌತ್ ತಾಲೂಕು.
ಆಯ್ತು, ಅವ್ರು ಅಕ್ಯೂಸ್ಡ್ ಇದಾರ ಈ ಕ್ರೈಮ್ ಅಲ್ಲಿ?
ಅವ್ರು ಇದ್ದಾರೆ.
ಹೇಳ್ಬೇಕು.
ಅವ್ರಿದ್ದಾರೆ. And your lordship has granted interim order to the, my lord,
ತಹಶೀಲ್ದಾರ್
the land acquisition officer wide annexure H, page 64, my lord.
ಯಾವ್ದು ಕೊಡಿ?
Where under whom I am working, my lord, as surveyor.
Tag this petition along with writ petition 28343 of 2024. List them both on 20th in the fresh matters list. Till such time, in the light, the learned counsel would submit, there's an interim order operating in the companion petition. In that light, there shall be an interim order in the case at hand as well. Both will close on 20th. Yes.
Please.
Orders 37.
Withdrawal, yes, next.
38.
My lord, second respondent, party in person.
Accommodation in this matter, my lords.
Okay, why this has come here? What's the matter, sir?
My lords, it's pertaining to an affair which was under the section 75 of Juvenile Justice Act, my lord. A stay had been issued by this honorable court, my lord.
Stay is that?
There is a stay which is.
You have filed vacating stay, sir? Respondent?
Yes, my lord.
Can you
Actually,
complain-
I haven't
You
received
are
the
appearing as
statement.
party in person.
Please.
Yes, my lord.
committee.
Yes, my lord, I am appearing in party in person.
Please get the appropriate form from the committee, sir.
Yes,
Yes.
my lord, I will do that next week. Kindly direct
When
the
do you-
state to file the
when do you want
statement
it?
of objection. I just need one day, my lord. I'll file
Monday?
it on Monday.
Alright.
Kindly issue the direction to the state to file the statement of objection, my lord, please.
State,
They
we
have-
can direct them, they will file, yes. List the matter on 3rd December. The objections, if any, comma, by any, comma, by then. Yes. next.
Lord, interim order to be extended.
Interim order subsisting shall continue till the next date of hearing.
Great.
Next,
49.
withdrawal. Office objections.
It is submission. Office objection is I have not produced entire order sheet. That's on 28/8.
ಈಗ ಮಂಡೇ ವರ್ಗು ವೇಟ್ ಮಾಡದೇ ಇರೋ ಅಷ್ಟು ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ?
It is posted for framing of charge
ವೆನ್ ಸರ್, ಯಾವತ್ತು?
on 3/12.
3/12.
ಅಂದ್ರೆ ನಿನ್ನೆಯಿಂದ
ಪರವಾಗಿಲ್ಲ. List the office objection stand overruled. List the matter on Monday in the fresh matters.
Please.
ಅಷ್ಟೇ. Yes, Raju. R2. PF ಕಟ್ಟಿಲ್ಲ. Appear ಆಗಿದ್ದೀರಾ?
R2 in this case.
Counsel so and so undertakes to enter appearance for the respondent. Registry to print the name of so and so is appearing for the respondent. Petitioner to serve set of papers upon the counsel representing the respondent. There is no representation on behalf of the petitioner. List the matter after 4 weeks. Objections, if any, by then. Next.
41 ನಲ್ಲಿ cannot survive 40.
ಯಾಕೆ ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ದೀರಾ?
ಅಲ್ಲ ಇವ್ರ ಮೇಲೆ they are not made an accused.
ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ?
Yes.
ಕೊಡಿ. ನಿಮಿಷ ಕೊಡಿ. ಫೈಲ್ ಕೊಡಿ.
And the petitioner 2 and 3 are not named as an FIR also.
Then why have they filed?
And only petitioner 1 was.
The petitioner accused number 2, 3 ಅಂತ ಹಾಕಿದ್ದಾರೆ.
ಹೌದು.
Accused ಯಾಕಾದ್ರು without naming them?
Not even named in FIR. I've been told that in further investigation ಅವ್ರನ್ನ witness ಆಗಿ convert ಮಾಡಿದ್ದಾರೆ. Petitioner number 1 has been dropped.
The petitioner is before this court seeking the following prayer. The learned counsel so and so submits that he has entered appearance for so and so registry to print the name of so and so. The learned additional SPP on instructions and verification of the records would submit that the first petitioner who describes himself to be accused number 3 has been transposed as witness.
No, then he was in fact in FIR is an accused number 1. Wrongly
Has been dropped from the array of accused while filing the charge sheet. The other accused who describes himself as accused number 2.
And 3 ಅಂತ print ಮಾಡಿದ್ದಾರೆ.
ಅವ್ರು ಎಲ್ಲ ಹೇಳ್ತಾರೆ 2 and 3. 2 ಅಂತ ಹೇಳಿ 2 has been transposed as witness. In that light, quashment of the proceedings would not arise. Quashment of the crime would not arise. The petition is disposed as having become infructuous.
42.
Office objection.
Entire order sheet produced ಮಾಡಿಲ್ಲ ಅಂತ.
Monday, overruled Monday in the fresh matters list. Yes.
matter also.
Next ಅದೇನಾ? All right, same. Devi Prasad,
54.
ಕೊಡಿ ಏನು objection? 2 weeks time to comply with the office objections. Next. Satyanarayana.
45.
My lord, the postal status, my lord, shows that, my lord, it is delivered on 29/5/2023, my lord, to the respondent number 2.
Last time no representation.
Last time, my lord, due to oversight.
ಬೇರೆ court ಅಲ್ಲಿ.
I was held up in another.
Postal ಶರ ಇದೆಯಾ?
That is
Alla,
the
police
postal
report,
status, my
sorry.
lord, which is showing.
The police report is indicative of the fact that the but ಏನು ಇದೆಯಾ? ಏನಿಲ್ಲ, ಎಲ್ಲಿದೆ ನಿಮ್ಮ ಹತ್ರ? ಇದೆಯಾ? ನಮಗೆ ಗೊತ್ತಾಗಲ್ಲ. ಸರ್ವ್ ಆಗಿದೆ. ಸರ್ವ್ ಆಗಿರೋದು.
Shows it is delivered on that date.
The police report is indicative of the fact that the service of notice has been effected on 29/5/2023. Therefore, registry to print the name of the second respondent and show the name and show the said respondent as served.
Lord, here this is the case.
List on Monday in the fresh matters list.
Freshman, please.
Yes. In 7 13 7A, pass over. Copy kudi. Copy kudi and objection is haki. Anyway, I am hearing those matters. Yes, you are not well under madane?
No, my lord, sir, just a little bit under the weather, my lords, otherwise fine.
ಹೌದಾ? ಮೋಡ ಕವಿದ ವಾತಾವರಣ ಇರ್ಲಿ ಬಿಡಿ. ಆಯ್ತು, ಎಸ್.
Please, my apologies.
ಬೇಡ ಬೇಡ ಅದು ಕಾಪಿ ಕೊಟ್ರಾ? ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕೊಂಡಿದ್ರೆ ಹಾಕಿ.
Rest also, my lord, sir, some of them.
Which one?
After 47, 47.
ನಿಮಿಷ,
lords will come.
46 ನೋಟಿಸ್ ಆಗಿದೆಯಾ ನಿಮ್ಗೆ?
ಆಗಿದೆ.
Counsel for the petitioner is directed to serve set of papers upon counsel B.V. Patil. Objections if any by the next date, 5th December. Yes, anyway, ಅದು hear ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಅಷ್ಟರಲ್ಲಿ ನೋಡಿ.
Please,
Next, Prasanna Kumar, 7 13
47.
Objection ಹಾಕಿದ್ದೀರಾ ಇದರಲ್ಲಿ?
Ready, my lords, I'll file it.
ಆಯ್ತು.
ready,
Learned
I'll file.
counsel B.V. Patil.
Notice again, needful has been done today.
Learned counsel submits needful has been done. List on same 5th December. Objections if any by then. ಏನ್ entry ಮಾಡ್ರು?
My lords, the same interim order when charge
Not
is
to
not.
file.
Not to file. charge.
ಅಷ್ಟೇ ಬೇರೆ
Same.
ಏನಿಲ್ಲ. That will continue. Yes, next. Enlargement of the petitioner.
Hearing on IA?
This is the infamous case of us not having to make payments to the opposite side and.
Check.
May I?
Issue
No,
is
no,
there
since
are some
30th
shocking
September,
developments.
not a rupee has come, my lords. Since
No, no.
30th September, and they've gone and lied to the learned magistrate in Mysore. What they're doing, my lords, is
Please let them
I'm just
submit.
filing some documents to show their conduct, my lords. They're pressing on a bail application there as well and here as well that
Yes.
Grateful.
My lords, no, my
Grateful.
lords, there is-
Dismissed.
No, my lords, there's one submission, my lords. My
Yes, sir.
deprivation of liberty, my lords. 90 days I've been kept in custody where my application for bail is neither heard nor it is rejected.
my lords,
Let
they are
the court
taking,
to
But
consider.
they have not done that. They have,
I will
there
direct.
is one submission.
lords,
yes.
they are taking time before the learned
No, I have
magistrate.
not taken
They are
time, my
not
lords, there's
arguing
one
their bail application.
Get it. The learned counsel for the petitioner submits that the bail application before the concerned court is not being taken up on its merit on the score of the pendency of this petition. This court on several occasions granted time to the petitioner to comply the orders passed by this court from time to time. The same are left uncomplied even today. Therefore, the petition stands rejected. The concerned court shall consider the bail application of the petitioner on its merit and pass necessary orders as expeditiously as possible without brooking any delay.
My lord.
The application shall be considered in accordance with law and then decided.
But
Lord,
there is-
I'm
there-
grateful,
there
my
is
lords, it's
one
my duty.
occasion where, my lords,
My
the
lords.
magistrate goes on record and says, I'll grant you time for 2 days, pay 13 lakhs. I will.
ನನಗೆ
acquit the
ಗೊತ್ತಿಲ್ಲ.
accused."
Challenge that in a manner.
Lords,
not
it's my
to that.
duty to bring on record what has actually happened there, my lords.
Bring
It's a
it to the record of the magistrate.
They are seeking time there, my lords. It may cause.
I have already ordered, sir. Yes.
Lords, my petition
No
will be
indulgence to such people, sir. No, nothing. Yes.
My lords, my deprivation of liberty for 90 days, my lords, where
You-
it is neither considered, my lord, nor it is
ಕಾರಣ
rejected.
ಯಾರು?
My lords, for 424. not-
ಕಾರಣ ಯಾರು?
My lords, I have gone on every date of hearing and
No
requested for
problem.
bail.
ಈಗ I have directed it to be done. ಎಷ್ಟು time ಅಲ್ಲಿ ಬೇಕು?
In a week's time, my lords, we have
within
been in custody for the last 90
Brooking
days.
any delay, at any rate, within 1 week from today.
Last order sheet, my lord, says they pray for time for hearing on bail application.
1 week from
Order
today.
sheets are here. They pray for time for
Lords,
hearing on
may
bail
just
application.
kindly
They come
consider-
here and say, learned magistrate is not deciding.
My-
Cause ಆಯ್ತಲ್ಲ.
My lords may kindly consider this, my lord.
No,
Only
sir, I am
reason-
not going to consider anything. I have passed the order. You can take it anywhere. Yes.
Obliged.
49.
Your Lordship, this is a GST reimbursed matter where your Lordship, the respondent was not served the notice, so they could not participate in the writ petition proceedings.
ಯಾವ್ದು
Lordship,
sir
on
ಇದು?
the
One
similar-
minute, sir, one. Mic on.
I was respondent number 6 in the,
1 minute.
I'm sorry.
I have just followed another order. sir.
Your Lordship recently passed an entry.
Not recently. I have followed the orders of the coordinate bench and closed it.
Yes, your Lordship.
Who are you?
I was respondent number 6 in the, in the petition, your Lordship, in the writ petition.
ಏನ್ ನೀವು respond number 6 ಅಂದ್ರೆ ಯಾರು?
Respondent number 6 is for
Karnataka State Police
Karnataka
Housing
State Police
Infra-
Housing and Infrastructure. Your Lordship, one more respondent has filed review petition.
ಕೊಡಿ.
Your lordship has.
Tag this petition along with so and so in the light of the interim order subsisting in the said case. Adrಲ್ಲಿದೆ ಅಲ್ಲ interim
Other
order.
interim order ಇದೆ.
So there shall be an interim order in the case at hand as well.
Obliged.
Emergent notice, ಅದ್ರಲ್ಲಿ ಯಾರ್ಯಾರಿಗೆ ನೋಟಿಸ್ ಮಾಡಿದ್ದೀನಿ ಅದೇ ಸೇಮ್. Next.
Same issue, lordship.
Same.
Same matter. Seal number 50.
Section-
lordship.
Same,
50
same
is-
order, same order.
Obliged.
713,
Print of petition, 7A matter.
7A.
Yes.
Notice ಆಗಿದೆ first time.
Notice ಆಗಿದೆ.
List on 5th December. Next.
Admission 52.
N Ramesh, vacating stay.
Lords, if fraud has been paid,
Fraud
Lord-
has been played.
my lords, a sale deed happened for the petitioners.
Ah.
In 52.2, my lord, pay for adjournment. in this case.
Fraud has been played and how can you seek adjournment?
My lords, now the charge sheet is completely read, my lords, with a review of this.
Stay ಇದೆಯಾ?
Oh, stay.
Give, ಎಲ್ಲಿ material ಕೊಡಿ ಚಾರ್ಜ್ ಶೀಟ್. ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಇಲ್ವಾ ಇಲ್ಲ? ಸ್ಟೇ ಆಗಿದೆಯಾ?
Stay ಆಗಿದೆ.
ಚಾರ್ಜ್ ಶೀಟ್ ಹೆಂಗ?
ಅಲ್ಲ, ಅಲ್ಲ, charge sheet complete investigation, my lords, before granting stay, my lords, investigation has been completed.
Test the matter on Tuesday in the fresh matters list. Interim order subsisting shall continue to the next date.
Much of.
ಆಗಿದೆ. ಆ ನೋಟಿಸ್ ಅದರಲ್ಲಿ ಹಂಗೆ ಮಾಡಿದ್ವಿ. ನೋಟಿಸ್ ಇಲ್ಲ, ಸಿನ್ಸ್ ದೇ ವರ್ ನಾಟ್ ಹರ್ಡ್, ಅದಕ್ಕೆ ಡಿಲೇ ಕಂಟ್ರೋಲ್. ನಾವು ಒಂದು ಕೆಲಸ ಮಾಡ್ತೀವಿ ಅದಕ್ಕೆ, ಅದರಲ್ಲಿ IA 1/24 ಇದೆಯಲ್ಲ, 213 days delay for the reason so and so and so, as also the fact that the petitioners, though were parties, were not heard in the matter, the delay application so and so allowed, delay condoned. Next.
Respondent.
Vacating
The-
stay ಹಾಕಿದ್ದೀರಾ?
Yes, ma'am. On the last day, the court had heard this matter on 138 complaint, whether the endorsement on the bank return memo would
Oh, correct,
amount to an
yes.
offense.
ಅದು covered against you.
There are decisions in my favor of the apex court, ma'am. Petitioner,
ಅದು all right, ಬರ್ಲಿ. ಲೀಲಾಧರ.
Yes,
yes. Sir,
Ah.
your lordship see that endorsement I appoint last time.
Please represent again.
Telangana High Court also has been made.
ನಾನೇ ಹೇಳಿದ್ ನಿಮ್ಗೆ ತೆಲಂಗಾಣ
ತಾವೇ ಹೇಳಿದ್.
Apex court judgment which holds that.
on this endorsement only.
endorsement itself.
ಕೊಡಿ ನೋಡಿ.
And other high courts also. My lord, the judgment of the apex court, on the face of the judgment, my lord, the endorsement is not clearly seen. That is why I have produced the impugned order. If I may take the court first through the impugned order, that's the Madhya Pradesh High Court judgment on page 5.
Hmm.
That judgment dated 15th November, on the 4th paragraph, my lord, the end of the 4th paragraph.
Kindly
remark is-
contact Roy Bank
Yes,
and present
yes.
again.
Yes, so the Madhya Pradesh High Court had allowed this petition on the ground that this would not be an offense.
That is upturned.
And that is upturned on the previous page, my lord, page 3 of my ink, page 3, paragraph 3. Paragraph 3, the present.
ಅಷ್ಟೇ ಇಲ್ಲ
arise-
ಸರ್. ಕ್ಲೋಸ್ ಮಾಡೋಣ.
But
ಅಲ್ಲೇ ಹೋಗಿ.
ಅಲ್ಲ ಅಲ್ಲೇ ಹೋಗೋದಕ್ಕಿಂತ ಮುಂಚೆ why I am submitting your
ವೈ ಇಲ್ವೇ ಇಲ್ಲ. Supreme Court says it can be.
ಅಲ್ಲ I will submit your also. It is not only that one your lordship see that.
ಇಲ್ಲಿವರೆಗೂ ಓನ್ಲಿ ದಟ್ ಅಂತ ಇದ್ರೆ ಈಗ
Not only that ground, there are other grounds also your lordship.
Yes, sir.
Your lordship see that his complaint your lordship, internal page. Internal page.
ಈಗ ಚೆಕ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಆ?
ಚೆಕ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
You have not given check.
ಅದೇ ಮ್ಯಾಟರ್ ಆಫ್ ಎವಿಡೆನ್ಸ್.
Before that one your lordship, his claim your lordship,
Hmm.
he has paid several monies you handed over to some other person. It is internal page.
Hmm.
3, para number 3. He has been stated your lordship. The complainant has paid a cash of rupees 90,000 to TC Rajanna. Then another says that the complainant has paid rupees 13 lakhs.
ಸರ್ ಅದೆಲ್ಲ ಮ್ಯಾಟರ್ ಆಫ್
And
ಎವಿಡೆನ್ಸ್.
sale deed has
ಲೀಗಲ್
been
ಗ್ರೌಂಡ್
executed.
ಲೀಗಲ್ ಗ್ರೌಂಡ್ ಇದ್ದಿದ್ದು ಇದು ಒಂದೇ.
Sale deed executed. Sale deed also we have executed for all the persons who have been cited, so that there is no amount at all. Section 91 of the Evidence Act has been clearly stated that there is a secondary evidence to show that the
ಅಲ್ಲಿ
alla,
ಟ್ರಯಲ್ ಕೋರ್ಟ್
what I am submitting before your lordship is
ನಾಟ್ ಇನ್ 480. ಇದೊಂದೇ ಲೀಗಲ್ ಗ್ರೌಂಡ್ ಇದ್ದಿದ್ದು. ಐ ವಾಸ್ ಎಂಟರ್ಟೈನಿಂಗ್ ದಿ ಪೆಟಿಷನ್ ಓನ್ಲಿ ಆನ್ ದಿಸ್.
that's the legal ground your lordship, that what I want to submit your lordship. The Telangana High Court your lordship is that
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಸರ್.
Supreme Court.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇರ್ಬೇಕಾದ್ರೆ ತೆಲಂಗಾಣ ಹೈಕೋರ್ಟ್ ಹೆಂಗೆ?
My submission, Your Worship, so that aspect is concerned, Your Worship.
Only that aspect is considered.
ನೋಡ್ಬಿಟ್ಟು ಹೇಳ್ತೀನಿ ಸರ್, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಹಾಕ್ಬಿಡ್ತೀನಿ. ಐ ವಿಲ್ ಸಿ. ಅಲ್ಲ ಯಾಕಂದ್ರೆ ಜಡ್ಜ್ಮೆಂಟ್ ಈಗ ಕೊಟ್ಟಿದ್ದಾರೆ.
List on Tuesday in the fresh matter.
ಎಸ್ ಯುವರ್ ಎಸ್ ಯುವರ್
Weekend ಸಾಕು ನೋಡಕ್ಕೆ.
ಅಲ್ಲ ಆಯ್ತು ಬೇಡ
Correct.
ಯಾಕಂದ್ರೆ ಈಗ ಕೊಟ್ಟಿದ್ದಾರೆ ಜಡ್ಜ್ಮೆಂಟ್, ಅದು
ಗೊತ್ತಾಯ್ತು.
ಓದ್ತೀನಿ.
Over the weekend ಮುಗಿಸ್ಬಿಡಿ.
ಇಂಟ್ರಿ ಮಾಡಿದ್ರು
List on Tuesday in the fresh matters list.
ಮಚ್ಚು
Interim order subsisting shall continue to the next date of
Macho.
hearing. Yes, sir.
54.
The petitioner's lordship. Offences are 420 and 406, your lordship.
Notice ಆಗಿದೆಯಲ್ಲ?
Notice last date.
Serve ಆಗಿದೆಯಾ?
Served.
The petitioner is before this court calling in question 420 ಮಾತ್ರ.
420,
420.
406 ಅಂದ್ರೆ
34. Sorry, lordship.
420 ಗೆ ಎಷ್ಟು ದುಡ್ಡು ತಗೊಂಡಿದ್ದೀರಾ?
Illa, lordship, we have paid entire amount with regard to the materials what they have supplied.
138 initiate ಮಾಡಿದಾರಾ?
Yes, your lordship.
ಹಾಕಿದಾರಾ?
Yes, your lordship.
The learned counsel of the petitioner submits that in the same cause of action the proceedings under 138 are initiated by the petitioner. The issue whether the two would go hand in hand, i.e. the proceedings under section 138 of the Negotiable Instruments Act and a crime under section 420 of the IPC has been referred to a larger bench by the apex court in so and so 2022 SEC online SC page 1100. Therefore, there shall be an interim order of stay of further proceeding, further investigation by the petitioner till the next date of hearing. Yes, next.
55.
55, Rupesh.
Hearing for respondent number 1 in the matter.
ಈ ಕಡೆ ಬನ್ನಿ madam.
Yeah, short, as a minor inconvenience.
ಎಲ್ಲಿದ್ದಾರೆ? ಗುಲ್ಬರ್ಗಲ್ಲಿದ್ದಾರಾ? ಆಯ್ತು ಸರಿ. 20ನೇ ತಾರೀಕು ಹಾಕ್ತೀನಿ ಅಂತ ಹೇಳಿ. ಲಿಸ್ಟ್ ಆನ್ 20. ನಿಮ್ಗೇನ್ ಬೇಕು ಮೇಡಮ್?
Same. Also, I just want.
ಲಿಸ್ಟ್ ಆನ್ 20th 20ಕ್ಕೆ. Yes, preliminary hearing.
56.
I'm appearing for the petitioner in this matter, your lordship. This is a matter under section 7A of the PC Act, your lordship.
We'll have it on 5th, madam.
7A.
7A.
You have to kindly consider the interim order.
Charge sheet is filed.
No, your lordship.
Same order ಮಾಡ್ಬಿಟ್ರಿ. List on 5th December.
Much
If
obliged.
charge sheet is not filed without the leave of the court, it shall not file. Yes, next.
57.
Same, my lords. Sir.
ಇದು same 5th. Prasanna Kumar P. ಇದು 7A na?
This, my lord,
Charge sheet is filed. So no order, only 5th.
on Wednesday, my lords,
Framing of charges.
framing of charge.
ಯಾವ ವರ್ಷದ ಹಂಗಾದ್ರೆ ಇದು?
2024, my lords.
ಅಲ್ಲ ಸರ್. ಕ್ರೈಮ್ ಯಾವ ವರ್ಷದ?
Crime, my lords, 2020.
21.
21, my lords.
All right, the concerned court shall defer its proceedings till the next date of hearing. 5th December. Yes, next.
B group.
My lords, 57, my name may be deleted, my lords, my friend.
57 ನಾ? ನಿಮ್ಮ ಹೆಸರಲ್ಲಿದೆ?
58.
ಬಿ ಬಿ ಪಾಟ್ಲೆ ಇರೋದು? ಲತೀಫ್ 58.
50, please.
59.
7A, my lords, once again.
Same 5th December. Yes.
Interim orders.
Huh?
Interim order.
ಇದೆಯಾ? Continue.
Please.
Yes. ಅಲ್ಲ ಅದು ಹಿಯರ್ ಮಾಡ್ಬಿಡಿ, ಇವತ್ತು ಮುಗಿಸ್ಬಿಡ್ತೀನಿ.
Please, please.
60.
Same, my lords, 7A once again.
Appearing for the petitioner, my lords. My lords, it's a 7A matter. In this writ petition, we are challenging the order.
All right, Nishai,
To-
5th. Yes.
5th of December, 5th of December.
Much obliged.
Yes, Sani madam.
61.
I prepared the synopsis.
ಅಲ್ಲ ಅದು senior ಗೆ ಹೇಳಿದ್ನಲ್ಲ, those 5 matters,
Ah.
different kinds of.
I-
You got them?
Matter, sir.
Given it to,
Where is Sandesh sir?
today is not, there's some inconvenience.
Today is not there ಅಲ್ಲ. Somebody had to make submission. Panindra sir and madam Lakshmi Iyengar.
Okay.
ಅವ್ರದಲ್ಲ? ಪ್ರಸನ್ನ ಕುಮಾರ್.
Well,
ಪ್ರಸನ್ನ ಕುಮಾರ್ ಕೊಲಿಗೆ ಯಾರು ಇದ್ರಲ್ಲ ಇಲ್ಲಿ? ಆ ಸೀನಿಯರ್ ಟು ಕಮ್. ಇಲ್ದರೆ ಹಂಗೆ ರಿಸರ್ವ್ ಮಾಡ್ಬಿಡ್ತೀನಿ. 13th ಕಲ್ಲ ಸರ್, 7A. 7A ಇಲ್ವಾ ನಿಮ್ದು ಯಾವ್ದು? All right, ಕೊಡಿ. Yes.
my lords, one thing in this matter, on the last date, my lords had indicated that not to file charge sheet order, but that's
ಬಂದಿಲ್ವಾ
not,
ಅದು?
not no, ma'am.
JK, ಅದನ್ನು ಪ್ರಿಂಟ್ ಮಾಡಿ ಸರ್. Yes, next. Yes, 62
62,
settlement.
reporting settlement.
Petitioner, 376 and 417.
37, promise of marriage.
Both parties are represented.
Though both parties are present, even if they are absent, we will consider only on merits. No settlement in this case.
The one judgment is passed. Your lordship has to pass an orders in the
Settlement
settlement ಮೇಲೆ ತಾವೇ ಒಂದು order.
ಯಾವ್ದು ಕೊಡಿ ಸರ್? ಅದು 2022
22 sums.
ಅದು ತಪ್ಪು ಆರ್ಡರ್ ಹೇಳ್ತಾನೆ ಇದೀನಿ, ಅದು ರೀಕಾಲ್ ಮಾಡಕ್ ಹಾಕಿ ಅಂತ ಹಾಕ್ತಾನೆ ಇಲ್ಲ ನೀವು. That's a wrong order in 2022.
Considering the Jian Singh judgment.
ಏನು?
Settlement.
Nothing doing, I will not settle. Come on merits. ಎಷ್ಟು ವರ್ಷ ರಿಲೇಶನ್ಶಿಪ್?
ಇಲ್ಲ, only ಅಕ್ಕಪಕ್ಕದ ಮನೆಯವರು only
ಅದೇ ಪಕ್ಕದ ಮನೆ ರಿಲೇಶನ್ಶಿಪ್ ಎಷ್ಟು ವರ್ಷ ಸರ್?
1 year, your lordship.
only one.
Only 1 year.
There is a delay of 5 months for lodging income.
ಪರವಾಗಿಲ್ಲ. I will not settle it anyway. The offence punishable, or the offence alleged in the case at hand is one punishable under section 376 and 417 of the IPC. The learned counsel for the petitioner submits parties to the list have settled the dispute amongst themselves and have produced a memorandum of settlement. Since the offence is the one punishable under section 376 of the IPC, there can be no question of closure of the proceedings by way of a compromise, as the alleged offence is a heinous offence. The learned counsel would seek to place reliance upon an order that was passed by this court on 23rd May 2022 in criminal petition 4172 of 2022. The order in the considered view of this court was rendered without looking into the judgments rendered by the apex court on the issue, and therefore would not become a precedent. The memorandum of settlement is thus denied. The ಹಾಕಿದ್ದೀರಾ memo?
ಇಲ್ಲ, ಕೊಡ್ತಾ ಯಾವ
ಬೇಡ. Therefore, the plea of settlement is declined. The petitioner is at liberty to come on merits. Yes, list the matter on 5th December. ಅದು ರೀಕಾಲಿಂಗ್ ಹಾಕಿ ಅಂತ 2 ವರ್ಷದಿಂದ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ನಿಮ್ಗೆ, ರೀಕಾಲಿಂಗ್ ಹಾಕಿ ಅಂತ. ಅರ್ಲಿಯರ್ ಕೌನ್ಸಿಲ್ಗೂ ಹೇಳಾಯ್ತು, ಎಲ್ಲ ಹೇಳಾಯ್ತು. That's a wrong order I've written. Yes.
date will fix.
Well, 5th December. Yes. ಇಲ್ಲ ಇದಾ ಸಿರಾಜುದ್ದೀನ್. ಏನು?
Serial number 64.
ಏನ್ ಮೇಡಮ್ ಡಿಕ್ಟೇಟಿಂಗ್?
A case
One
against
minute.
the wife is registered.
1 minute. Pass over ಮಾಡಿ ಬರ್ಲಿ ಅವ್ರು.
One
You are there?
submission, 64, another one submission.
63, I mean 63, 1 minute. 63 na?
64, my lords.
Where is Shyam Sundar? Busy today? ಇರೋದ್ ಬೇಡ ಅಂತ. Tuesday ಮಾಡಿ. Yes, list on Tuesday. 64, ಸಿರಾಜುದ್ದೀನ್.
64.
My lords, I am submitting the written arguments, my lords.
Written argument?
Yes, my lord.
ಯಾವ್ದಕ್ಕೆ?
For their reply, my lords, sir. And submitted some
Aye,
documents.
my lords.
The allegation against the petitioner is that, my lords, she has committed an extortion and she has cheated the husband, my lords. And in this regard, the FIR came to be registered against her.
You are the wife,
Yes, my lord, I am the wife.
you are the husband.
Yes, my lord.
Role reversal.
Your
Yes.
lordship has directed to conduct further investigation.
Hmm.
Last date of vacation, this is the lady, my lord, has married army officers.
Oh, yes.
Army, yes.
And when we issued a notice, my lord, she doesn't turn up.
Hmm.
And she says that there is a stay order, I will not come.
No, my lords, it is informed
ಈಗ
yesterday.
ಯಾವಾಗ
Yesterday itself,
ಯಾವಾಗ
my lords,
ಹೋಗ್ತೀರಾ?
yesterday itself, she got a call by the investigation officer.
Cooperates.
No, my lords, I will cooperate, my lords.
She
But my
noticed, she rejected the notice. Refused to
my lords,
accept the
yesterday, my lords, yesterday itself, she got a call from the IO, my lords. Now, it was not intimated to her, my lords. It was our duty, I did not intimate to her that interim order has been
You got a
vacated.
call or she got a call?
She got a call, my lords.
Why have to you intimate?
My lords, I have to inform regarding the case, my lord, that STA has been vacated. I have not intimated her.
When do you intimate her?
I have already intimated. She got a call, she
So
came.
when do you appear?
My lord, I will appear, but she resides in the Pithargarh, my lord. I am ready for final arguments, my lord.
No, sir. First appear, come for investigation.
My lord, at the time of registering FIR, already investigation has been done, and without,
Then come on merit, sir. No problem. Don't worry. Yes.
my lords, the allegation against her is that she has extorted the money, my lords. Now, my lords, she has transferred the money, my lords, which has submitted the documents before this court, my lords, in the registry, my lords, along with the memo. She has transferred the money. Before the marriage, my lords, she spent the money for her marriage, my lords. And she gave a money of some 25 lakhs, my lords, to the husband. And when there was some misunderstanding, the husband was not cooperating with the wife, my lords. She left, the husband left the wife without intimating her to Assam, my lords. And when in this regard, my lords, she has, when she has transferred the money for her, she asked return to her money. In this regard, the case came to be filed that she is extorting money. The bank statement I have produced as document number 15, my lords. She has transferred online, my lords. Before the marriage, my lords, she has deposited 11 lakh rupees to purchase a car, my lords.
ಯಾರಿಗೆ?
10 lakh, in the car purchase ಮಾಡಕ್ಕೆ 11 lakh rupees she has
ಯಾರಿಗೆ ಕೊಟ್ರಿ?
to the husband, my lords. In the husband.
Which husband?
This husband, my lords.
This
That husband.
husband.
The first husband, there was a dissolution of marriage by way of mutual consent, my lords.
That husband ಏನ್ ಕೊಟ್ಟಿಲ್ಲ.
No, my lords.
This
It is
husband
different.
ಕೊಟ್ಟಿಲ್ಲ.
This husband, no, my lords. That.
All right.
And thereafter, my lords, the husband, he produced a forged document.
Husband.
This petitioner, this accused, my lords, the complainant.
All right.
The complainant produced a forged document before the company to purchase a car, my lords. That he is working in the in Himachal Pradesh, but he was working in Manipur, my lords.
ಸರಿ.
Only to get the registration of the car. And thereafter, my lords, once they registered, she deposited a money of 10 lakh rupees to purchase a car. Immediately, that husband cancelled the car registration and received the money. Received the money. Because the car was registered in the name of the husband, the complainant, he received the money of 10 lakh rupees. ಅವ್ರು ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ತಾರೆ ಮೇಲೆ ಕಾರ್ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಮಾಡ್ತಾರೆ ಇವ್ರ ಹೆಸರು ಮೇಲೆ ಅಕ್ಯೂಸ್ಡ್ ಹೆಸರಲ್ಲಿ ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ತಾರೆ. ಹಿ ರಿಸೀವ್ಡ್ ದಿ ಮನಿ ಅಂಡ್ ಅಗೇನ್ he took money of 25 lakh rupees from the husband, Melas. The statement I have produced, Melas. When she started asking the money which she has given to the husband, Melas, he has registered a complaint for extortion, Melas.
ಕೊಟ್ಟಿದ್ದು ದುಡ್ಡು ಕೇಳಿದಕ್ಕೆ ಎಕ್ಸ್ಟಾರ್ಷನ್ ಆಗುತ್ತಾ?
That is the case, Melas.
Please.
He was not cooperating. She filed a complaint in Pithargarh that because of domestic violence and harassment for the wife, Melas. After registration, there was a case pending. She informed to the SP here without intimating. A case has been registered. This offense is up to 7 years, my lords. According to the Arnesh Kumar guidelines, she has not intimated. She has not even given a notice before registering a FIR. And NCR has also been lodged, at least without giving an opportunity of hearing a case came to be lodged. And this, there is no essential ingredients of the FIR complaint, my lords. My lord, she has given 25 lakh rupees and he has received the money for registration of a land in her name. According to his promise, he has not registered the land in his name and he got registered in his name and transferred the same to her mother, my lords. There the misunderstanding started, my lords. ಅವರು ದುಡ್ಡು ತಗೊಂತಾರೆ ನನ್ನ ಹೆಸರಲ್ಲಿ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಫಾರ್ ದಟ್ ರೀಸನ್ ಇಟ್ ಸೆಲ್ಫ್ ಮೆಲಾಟ್ ದ misunderstanding started and in this regard the FIR came to be registered. When the land itself is not registered, and when I started asking the money, an extortion case has been registered against me. This is the allegation, my lord.
We'll hear the husband.
Yes, my lord.
My lords, similar allegations were raised by the wife in the DV Act case. It has reached finality. Trial has been conducted in depth about the exchange of money and the transactions. I have annexed the DV court order along with my vacating IA.
I shall even highlight the page numbers, my lords, of the relevant paragraphs.
Hmm.
I have also filed a synopsis along with my statement of objections, which will give it. My lords, if I may just take you to two aspects to point out the conduct. On page 38 of my statement of objections, I have annexed the complaint which I have filed with the Commissioner of Police. 2nd July 2021, I get married to the complainant.
I'm at page 35 where your objection.
Please, R3,
R3.
please.
Ah.
I'm 2nd July 2021, I get married.
Hmm.
I find out these criminal antecedents, previous marriage, and all those allegations, all the allegations which I have leveled against her. 19 July, I separate from her.
Hmm.
28 July, I give this complaint.
What? 17 days you lived.
Please.
Okay.
And on annexure R3, on that date, I have filed this complaint to the Commissioner of Police.
Hmm.
With respect to the allegations of the money that they are making against me, the lordships may see on page number 37. Seventh line from the bottom after annexure P3. Further, the accused trapped the complainant and his family and had transferred a sum of rupees 5 lakhs and
Charge
subsequently.
sheet file madli bidi.
Yes, my lord.
File discharge
Not law.
after filing charge sheet.
It's okay, my lord.
Want to. Illandre you'll have to appear for investigation.
Yes, my lords, I am ready to appear, but all the cases has been transferred in the Supreme Court except this case, my lords.
Is that so?
Not this case. That's
Not
been
this-
Except this case, my lord. All the cases are relating to,
File a transfer petition before the apex court.
filed and rejected.
Reject. Yes. Filed and rejected.
Yes.
Anything else?
no, my lords.
Discharge ಹಾಕೊಂಬಿಡಿ. Charge sheet ಹಾಕಿ ನಿಮ್ಮ ಮೇಲೆ ಏನಾದ್ರು ಬಂದ್ರೆ.
Idralli
Otherwise,
Swami,
these
one,
disputed
My
questions
lords,
are-
the allegation against me is that
Why should
I
I
have
show
not
indul-
intimated.
No, why should I show indulgence to a person who is not even cooperating with the investigation?
No, my lords, it is their allegation, that too yesterday, my lords. Yesterday I got a call. I am ready to cooperate with the investigation. I will cooperate, my lords, but already a part of investigation is done and the FIR and statement.
Investigation ನಿಮ್ ಪ್ರಕಾರ ಅಲ್ಲ, ಅವ್ರ
Yes.
ಪ್ರಕಾರ ಮುಗಿಬೇಕು.
It's okay, my lords. I am ready to cooperate, my lords.
Then cooperate once if they file the final report against you, you approach this court or file discharge, whatever you want.
Yes, my lords, I am ready, my lords, but the allegation, the essential ingredients of the complaint and FIR is not made out, my
No,
lords.
they may-
Because, my lords, their submission was that I have earlier marriage, I have not intimated them.
It's all right, they may file a B report even, who knows? ನೀವು ಕೋಆಪರೇಟ್ ಮಾಡಿದ್ರೆ ಏನಾರು ಒಂದಾಗುತ್ತೆ.
Yes, my lord, I will cooperate, but investigation, if they intimate me, they issue no notice, I am ready to cooperate, but
It's up to you.
transfer, coming from there, it will be hard, I will cooperate.
That I am not saying.
fact,
In
I
the
have
manner,
acknowledgement, my lord, acknowledgement which says there is.
In the
rejected
manner they want investigation, you cooperate with the investigation. That's
I am
all.
ready, my lord.
All right. Then
But-
you approach this court again after the filing of the final report.
Yes, my lord.
Because vacating this and keeping is of no use.
My lord, a direction may be given to Iva that some forged document has been submitted to obtain the car and he has also forged.
You submit everything to the IO, sir. Why should I sell? Why should I pass that order?
They should consider, my lords. I will submit before the
You
IVA
submit
everything.
whatever you want, they will file their final report however they want.
Yes, my lord.
But
A
what else?
direction to the state may be given to verify the document, my lord, because he has forged.
Heard the learned counsel appearing for the petitioner. This court, owing to the non-cooperation of the petitioner for investigation, had vacated the interim order. The learned counsel for the petitioner submits that he would, the petitioner would cooperate with investigation and would further submit that the investigating officer be directed to take all the records that she is wanting to submit. It is this court has no reason to disbelieve no reason to believe that the investigating officer would not take all the records and then prepare his final report, reserving liberty to the petitioner to approach the appropriate fora once the final report is filed. And in the event the final report would go against her, the petition stands disposed, all contentions remain open.
One, serial number 41, my lord, there's two FIRs are there in serial number 41.
Ah.
In one, the B report is filed, another one, therefore it survives petition.
ಒಂದೇ ಇದೆ ಇಲ್ಲಿ
ಅಲ್ಲ ಅದರಲ್ಲಿ ಎರಡು FIR ತೋರಿಸಿದ್ದಾರೆ. ಸೊ ಒಂದರಲ್ಲಿ
ನೋಡಿ ಬರ್ಲಿ ಬಿಡಿ.
ಅಲ್ಲ ತಾವು ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅದಕ್ಕೋಸ್ಕರ.
ಅಲ್ಲ ರಾಜು ಬರ್ಲಿ ಬೇಕು ಅಂದ್ರೆ ನೀವು ನೋಡಿ ಅದ್ರಲ್ಲಿ ಒಂದೇನಾರು ಇದ್ರೆ ಐ ವಿಲ್ ನಾಟ್ ಸೈನ್ ಇಟ್.
ಎಸ್
Okay, yes, next. Further hearing. Hello, further hearing moves on.
65.
My lords, appear for the petitioner in this case. Senior counsel has been engaged. Due to some inconvenience, senior counsel could not be present today. A date be given, my lords. Tauta sir has been engaged.
Idralla?
Yes, my lords.
Why are the, what are this matter connected? Why?
But it's all same offense, my lord. These people
Allah,
are.
are they
My
accused
lords,
in?
these are BDA matters. That the alleged offenses that there have been sale of BDA lands, my lords.
No, no, these people are
For-
found in the premises of these people, the
No, the
letter-
matters have connection with each other.
Yes, same offense.
Please, yes, my lord.
The learned counsel appearing for the petitioner in criminal petition 72227 of 2022 seeks time on the score that the arguing senior counsel Sandesh Chowta is not available today. Therefore, list this matter on 15th.
My lords, please. The 3rd December is the date, my lords. The arguing counsel has some inadvertence from.
Inadvertence? Yes,
Lords,
madam.
the arguing counsel's wedding is from next. The briefing counsel's wedding is next week, my lords.
Sandesh Chowta wedding ಅಂತ ಹೇಳಿದ್ರು.
Please, sorry, man. Briefing counsel's wedding is next week and it's 3rd
All
December.
right, list the matter on 3rd December.
3rd, please, my
Yes.
lords.
Please.
At
As
2:30
interim
PM.
order may be extended.
My interim orders will stand extra.
Please.
Interim order ಇದೆ ಅಲ್ವಾ ಎಲ್ಲಾದ್ರಲ್ಲೂ?
Yes. Interim order is.
ಹಾ?
Interim order.
Interim order ಇರೋದು extend ಆಗುತ್ತೆ.
May I request for passover, ma'am?
Pass over.
Please.
Passed over by 1 week, next 15th, next.
My lords, please. Yes, madam.
ಯಾವ್ದಿದು?
66, my lords.
ಓ ಇದು ಆ ಮ್ಯಾಟ್ರಾ?
Pertaining to
ಪಾಸ್
second-
ಓವರ್ ಕೇಳಿದ್ರು ಮತ್ತೆ?
ಅದೇ, I was just reading. Other court.
ನಿಮ್ ಕೊಲೀಗ.
Sorry, my lords.
Respondent Srinivas,
Last two occasions appeared. The lordships were waiting for his appearance.
Tuesday, fresh matters list.
Please.
We'll dispose it on that.
Please.
List on Tuesday in the fresh matters list.
Greatly applied.
67,
67.
I am for the respondent, my lord. I have received 5,51,000 out of this amount.
Please, my lord, 138 settlement before the Lok Adalat, my lord.
ಎಷ್ಟು ಆಗಿದ್ ಸೆಟಲ್ಮೆಂಟ್?
ನಮ್ಮ ಪ್ರಕಾರ ಇನ್ನ 51,000 ಬರ್ಬೇಕು ಸರ್.
ನಮ್ಮ ಪ್ರಕಾರ 21,000 ಇದೆ. Some interest, my lord, calculation.
25,000 ಮುಗಿಸ್ಬಿಡಿ.
My lord, you Lakshmi kindly have it on 13th or 14th, my lord, by that time.
ಆಯ್ತು ಸರ್.
ಇನ್ನ 25,000 ಕೊಟ್ಟು ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಡಿ.
But difficulty is that, my lord, she is
30
having,
ಮಾಡ್ಬಿಡಕ್ಕೆ.
Hmm?
30 ಮಾಡಕ್ಕೆ ಹೇಳಿ at least.
my lord, she is having 16 more checks with her. And she is filing, my lord, one after the other cases
ಇಲ್ಲ sir, ಅದು-
through her sister and
ನೀವು
relatives.
ಆತರ ಒಂದು ಎಲ್ಲ ಕೊಟ್ಬಿಟ್ಟು ಒಂದು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಎಸ್, ಲಿಸ್ಟ್ ಆನ್ 15th,
ಅಲ್ಲ 13 ಸರ್.
13th ಬೇಕಾ? ಆ ಲಿಸ್ಟ್ ಆನ್ 13th in the fresh matters list. We'll close it.
230, my lord.
Fresh matter ಬೇಡವಾ?
ಆಯ್ತು.
ಸರ್, ಎಸ್.
ಆಯ್ತು sir.
Next.
68.
My lord, so I appeal for the petition in this matter. My lord, there are 7 connected matters. Synopsis have been filed. My lord, learned senior counsel Ravi Shankar sir was to address. Kindly be taken on next week, my lords.
Senior counsel Chandesh Chowta,
Ravi Shankar sir,
where is he?
he is, my lords,
Whom are you appearing, madam?
My lord, in serial number 68.5, I appear for respondent number 2. My name may be, I have filed NOC Vakalat.
In place of N. Umesh.
Please, my lord.
What's the name?
Preeti Karetti.
So learned counsel so and so submits that she has entered appearance in place of N. Umesh. Registry to delete the name of N. Umesh and print the name of so and so.
my lords, detailed hearing ಬೇಕಾಗ್ಬೋದು. So kindly be
ಬೇಕಾಗುತ್ತೆ, ಡೀಟೇಲ್ ಹೇರಿಂಗೇ ಮಾಡೋಣ.
if my lords
Indeed.
permit, 230.
ಆಯ್ತು,
I've filed the synopsis as well, my lords, in all the.
15th, 2:30 PM.
Grateful,
Yes.
great.
In the fresh matters, may I request, my lords? Please.
Detailed hearing ಬೇಕು ಅಂತ ಇದಾರೆ.
Identity.
Yes.
Please, ma'am.
69.
ಅದೇನ್ ಡೀಟೇಲ್ ನೋಡೋಣ ಅವತ್ತು. ಪ್ರಸಾದ್, ಏನಿದು?
Exonerated, my lord, is there.
ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಎನ್ಕ್ವೈರಿ.
Department inquiry. That is not considered, my lord, because entered without examined witness.
ಇದು ಯಾವತ್ತು ಹಾಕಿದೀವಲ್ಲ ಅಲ್ಲಿ? ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಎನ್ಕ್ವೈರಿ ಎಕ್ಸಾನರೇಷನ್ ಯಾವ? 22nd. 22nd. List the matter on 27th. 27th, yes. That key continues, don't worry. Yes. 70.
70.
NDPS much, my lord.
Ah,
Mainly related of
vehement opposition ittala last time, adene.
vehement which made me silent.
Ah. Your silence continues till today?
No way.
Ah,
Now
yes,
it
sir.
will come out vigorously.
Yes, sir. Heli.
My lords, in this matter, one of the main condition is, my lord, is non-compliance of 50A, which is the control delivery.
Mm.
But in this regard, I would draw your lordship's kind attention to the private complaint.
Mm.
Lordship, can you to page 48? It unfolds.
I will
how-
just run through the list and take it.
Very well,
7 matters is Muxputto.
very well.
I'll take it. Just wait for 10-15 minutes.
71.
Lord, in 71, I appear for the petitioner's counsel. Sorry, my lord, I had some other VC hearing, so I'm appearing online.
Right in 71.347.
Oh, wrong interim order perpetuated.
Yes, your lordship.
Correct.
Change in council now.
ಹೌದಾ?
ಹೌದು,
Last time ಇವರೇ ಇದ್ದಿದ್ದು.
ಇಲ್ಲ ಬೇರೆಯವರಿದ್ದಾರೆ.
Who's alleging that the interim order was incorrect is resigned.
I had filed my NOC wakalat, your lordship, and as per your direction, I have filed synopsis list of dates and events on September 18th.
In each case.
My lord, we have filed one comprehensive, my lord, list of dates and synopsis.
Ah. We will also pass one comprehensive order.
I'm so grateful.
But on Wednesday.
I'm very grateful.
Just on Wednesday in the fresh matters list.
Grateful.
Wednesday. Wednesday in the fresh matters list.
Please.
Wednesday, my lord, so
Disposal
great.
ಎಲ್ಲ ಹಂಗೆ ಮುಗಿಸ್ಕೊಳ್ಳೋಣ.
Interim order ಇದೆ.
ಅದೆಲ್ಲ ಕಂಟಿನ್ಯೂ.
Please, so grateful.
Yes, be ready on Wednesday.
Very well.
Next.
72.
ಇದು 7A.
7A.
This one, ಯಾವತ್ತದು? 5/12, yes.
73.
Same,
Please.
same.
25.
Lord, Same.
75 is DA, my lords.
ಅದು 27th.
And 76,
Interim order ಎಲ್ಲಿದೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. Yes.
76 also is DA.
D ನಾ? That is, ಅದೇ DA. DA or DE?
DA.
Oh, DA ಆದ್ರೆ ಮೇಡಮ್ ಇನ್ನು ಉಳಿದಿರೋ 13 ಯಾವತ್ತು? 27th, yes. 27th, correct.
77.
By then we
My
would have
lords,
pronounced all that.
77,
Ah.
my lords, this is a KDB matter where my lords had, the petitioner, my lords, does not make the
Oh, we
request.
recalled the order.
My lords, it is covered by the judgment of my lords in Kamalalaya, which says that if you have not paid within certain date,
Ah.
it will lapse, my lords.
Yes, Abhinay.
My lords, my only apprehension is,
Wednesday in the fresh matters list.
my lords, one request. In the meantime, my lords, during the pendency of the writ petition, without any interim order from the court, by taking the account number of KIDB from the website, he has deposited the money without any. My lords, we seek permission to refund that money, my lords, the DD is ready.
Unilaterally they have done. Unilaterally you do. Why
Please.
do you need an order from the court?
Please.
Yes.
My lords, some urgency because,
Wednesday, fresh matters.
please,
Yes.
deeply obliged.
List on Wednesday in the fresh matters list.
Deeply obliged.
Yes.
78.
DA case.
DA,
DA.
27th, list on 27th. 79, agenda.
Appear for petitioner. Oh, short accommodation next week, my
ಏನಿದು 7A ನಾ 13
7A.
ನೋಡಿದ್ದೀರಾ ಇಲ್ವಾ?
ಇಲ್ಲ, my lord, senior,
FIR ನೋಡಿ. ಫೈಲ್ ನಿಮ್ದಲ್ವಾ?
senior ಸ್ವಲ್ಪ.
ಫೈಲ್ ನಿಮ್ದಲ್ವಾ? ಆಯ್ತು, ಲಿಸ್ಟ್ ಆನ್ 5th December. Yes.
Much of it.
Next, Prasanna Kumar,
81.
13, 27th. Yes. By then we'll pronounce that. Oh, sorry. Yes.
82.
Sirajuddin, premature release. Rahul,
Your lordship, in this matter, the first matter, he
Charge
was,
4 you're here. That's
he-
good. Good, yes.
he was left on parole for 90 days. He last surrendered on 15/9/2024.
Hmm.
So the 90 days period is over.
Ah.
And then, since he's been convicted under the Arms Act,
and the SCST Act. His
Premature release.
premature release, his, so his
Other
petition
co-accused
is
has
pending
already
before,
been released.
one ನಿಮಿಷ, submission ಮಾಡಿ.
ಮುಗಿಸ್ಲಿ ತಾಳಿ.
His plea for premature release is pending before the Ministry of Home Affairs.
All right.
So they have to take a decision.
ಈಗೇನ್ ಮತ್ತೆ ಪೆರೋಲ್ ಬಿಡಕ್ ಆಗಲ್ವಾ?
90 days ಆಗಿದೆ, fresh ಆಗಿ ಹಾಕೊಳ್ಳಿ some.
Fresh, I have filed an IA, my lords.
ಅಲ್ಲ, ಅಯ್ಯೇ ಹಾಕೊಂಡು ಹೋದ್ರೆ
ಫ್ರೆಶ್ ಪೆರೋಲ್
Fresh
ಅಪ್ಲಿಕೇಶನ್
parole is
parole
after
ಹಾಕ್ಲಿ
6 months, my lords. Now my
ಇಲ್ಲ ಹಾಕಿ
ಅಲ್ಲಿ ಹಾಕಿದ್ದೀನಿ, my lords.
ಎಕ್ಸ್ಟೆನ್ಷನ್ ಕೊಡಕ.
fresh ಹಾಕಿ.
My lords, your lordship has asked me to file an IA because,
Ah.
because, my lords, already his co-accused has been considered premature release, 5 accused has been released, my lords. That document is, I have produced that.
ಫ್ರೆಶ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಕ್ ಏನ್ ಪ್ರಾಬ್ಲಮ್?
Fresh application I filed for premature, my lords. But according to the prison rules, after 6 months cooling period only, I can be granted parole.
ಈಗ ಇವ್ರು ರೆಕಮೆಂಡ್ ಆಗಿದ್ ಪೆಂಡಿಂಗ್ ಬಿಫೋರ್ ದಿ
Pending before the Ministry of Home Affairs.
It is 19 years.
So what?
Your Lordship,
Anyway, you
after
have found him fit.
no additional 15 days again, he's been left on parole after 90
I'll
days.
tell you. Anyway, he has been recommended for release prematurely. So his conduct is definitely good. And during the period when he was out, is he indulging in any
No, he's
crime? Nothing.
not.
That is also good.
So let there be a direction to the Ministry of Home Affairs to give a,
That we will do.
ಅದನ್ನ ಮಾಡಿ ಇದ್ ಮಾಡಿ.
ಯಾರಿಗೆ ಏಟ್ ಬಿತ್ತು? The petitioner is before this court. ಅಲ್ಲ, IML order ಮಾಡೋಣ. The petitioner has filed an application seeking extension of parole for it having come to an end. ಯಾವತ್ತು end ಆಗಿದೆ?
Last month, my lord.
For it having come, you have gone back to the goal?
Yes, sir.
It having
59
come,
2024.
it having come to an end and the petitioner returning back to the goal. The learned counsel for the petitioner Sirajuddin submits that the case of the petitioner has been recommended for premature release owing to his conduct, and the order on premature release is to be passed, is pending before the Ministry of Home Affairs. Therefore, he seeks release.
Other co-accused, my lord.
ಅಲ್ಲ, ನಿಮಿಷ. Co-accused ಅಲ್ಲ?
Co-accused has been released by premature.
He would further submit that all the co-accused in the same crime have already been released, have already been granted the benefit of premature release and are out of the prison. He would submit that till the application of the petitioner is considered, the petitioner be granted parole. In that light, the petitioner is granted parole from Monday. From Monday for a period of 30 days. I further deem it appropriate to direct the state to pass necessary orders.
Your Lordship, we have sent the central, the Home Affairs, Ministry of
This
Home
to
Affairs,
central government.
our central government.
Then
From
central
our
government-
end, we have done, we have sent
central
it.
government ಯಾರು ಕರ್ಕೊಂಡ್ಬಂದ್ರೆ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟು ಕ್ಲೋಸ್
ಅದೇ ಅದಕ್ಕೆ ಅವ್ರಿಗೆ direction ಕೊಟ್ರೆ let them.
ಇಲ್ಲ ಶಾಂತಿ ಭೂಷಣ್ ಕರ್ಕೊಂಡ್ಬಂದು ಕ್ಲೋಸ್ ಇಟ್.
Yes, my lords.
ಈ
ಕರ್ಕೊಂಬರ್ತೀನಿ.
ಪೆರೋಲ್ ರಿಲೀಸ್ ಮಾಡ್ಬಿಟ್ಟು list this matter on 15th. Petitioner to implead the Ministry of Home Affairs, Union of India as a party respondent. Learned DSGI Shanti Bhushan is directed to accept notice for the DSGI. The petitioner shall serve set of papers upon the learned DSGI forthwith. This is the matter on 15th.
No, your Lordship,
90 days.
kindly have it on 14th.
14th, all right.
My lords,
15th.
90 days may be granted to him because
ಆಗ್ಲಿ, 9,
ಅದರಲ್ಲಿ direction I will give to dispose the application in 30 days.
30 ಆಯ್ತು.
like
I don't know. 30 days ವರೆಗೂ parole ಬಿಟ್ಬಿಡಿ, 30 days to become operational from Monday, 30 days duration.
Your Lordship,
Copy Monday,
14th.
14th, list on 14th. Shanti Bhushan amend ಮಾಡಿ ಕಾಸ್ಟ್ ರೇಟ್ಲು,
Yes.
Shanti Bhushan copy ಕೊಡಿ, then 14th will ask him to come, we'll do it. 14th, no, November, not 4-5 days. 14th November, Rahul.
14th November.
Yes. 14th November. All 3 matters.
No, your Lordship, no, in the second matter,
Ah.
again 90 days
So
period is
premature
over.
release,
yes, my lords.
Recommend
All
ಆಗಿದ್ಯಾ?
premature
ಅಲ್ಲಲ್ಲ,
release. Other co-accused has been released only.
recommend ಆಗಿದೆಯಾ?
recommend
Yes, my lords,
ಆಗಿದೆ.
recommend ಆಗಿದೆ.
The proposal is pending before the
Pending.
committee.
Committee, not before the Home
ಇಲ್ಲ.
Affairs.
ಅದಕ್ಕೂ ಒಂದು direction
Madam,
ಇದೆ.
ಒಂದ್ ನಿಮಿಷ, ಅದರಲ್ಲಿ 82 ಮಾತ್ರ ಶಾಂತಿ ಭೂಷಣ್ ಕಂಪ್ಲೀಟ್ ಮಾಡ್ಲಿ. 83 and 84 ಅದ್ರಲ್ಲಿ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಹಾಕಿದ್ದೀರಾ?
Yes, my lords, extension
ಅಲ್ಲಲ್ಲ,
ಹಾಕಿದ್ದೀನಿ. 83, what happened, my lords? Another petition was filed before the coordinate bench. Now he is out
No,
on
no, no,
parole.
no, no, your lordship, I'll make, that's a wrong submission. What you-
ಹೇಳಿ ರಾವ್.
Swami, 82 ಅಲ್ಲಿ, let there be a direction to the committee to consider it.
ಒಂದ್ ನಿಮಿಷ ರಾವ್. Now 82
82.
is where I passed.
No, no, 82.1.
Madam, ಈಗ ಹೇಳಿದ್ದು 82.1 ಅಲ್ಲಿ, not in 82. 82 ಅಲ್ಲಿ ಏನು?
No, 82, since your lordship has directed the union government to be implemented, ಅದರಲ್ಲಿ 82.1 ಅಲ್ಲಿ, it is before the committee.
82 ಅಲ್ಲಿ. 82.1 ಅಲ್ಲ, ಈಗ ಏನ್ ಹೇಳಿದ್ದು ಅದು 82. ಈಗ 82.1 ಅಲ್ಲಿ ಏನ್ ಬೇಕು?
82.1 ಅಲ್ಲಿ,
ಹಾ.
that is pending before the committee. So let
Alright.
there be a direction to the committee to consider it within a reasonable period of time.
IA for extension allow ಮಾಡಿ will permit 30 days.
ಅದು 30 days ಇದ್ ಮಾಡಿ.
ಅದು ಮೇಡಮ್ ಆರ್ಡರ್ ಆನ್ IA 1/24 allowed for 30 days extension of parole. ಆಮೇಲೆ ಹೇಳು. The learned counsel for the petitioner submits that the plea of the petitioner for premature release is pending before the committee constituted to consider consider the convicts who are entitled for premature release. Therefore, the committee shall consider the application of the petitioner and pass necessary orders in accordance with law within 30 days from.
My lords, already I am on parole, my lords. Already I have been.
ಹೇಳಿ ಸರ್. 30 days from the date of receipt of the copy of the order. Parole ಆಗ್ಲೇ ಕೊಟ್ಟಿದೆ, ಹೇಳಿದ್ನಲ್ಲ ಮೇಡಮ್. ಇದೆ, ಇದರಲ್ಲೂ parole, extension of parole. Yes, you are already on parole.
Yes, my lords. I am
Who has
already-
granted you?
My lords, before this IA is listed.
Parole ಇದ್ದಾರೆ ಅವ್ರು already.
Yes, my lord.
No, your lordship, you know, ಇಲ್ಲ, ಇದ್ರಲ್ಲಿ-
Before this case is listed, I filed a application before the coordinate bench, my lords.
ಹಾ.
I have been granted parole.
ಯಾಕೆ
Now I am-
credit court ಅಲ್ಲಿ ಮಾಡ್ತೀರಿ?
ಅದನ್ನೇ-
ಅದು
my lords,
problem ತಾನೆ?
January ಅಲ್ಲಿ ಹಾಕಿದ್ದು IA memo, this came to be listed now, my lords.
Then ಬಿಟ್ಟಾಕಿ ಅಲ್ಲೇ ಹೋಗ್ಲಿ, ಅದು ಅಲ್ಲೇ ಇರ್ಲಿ.
Already, no, my lords. Direction for premature release, that is only for parole, my lords.
That's all right, you can take the direction from the honorable judge there.
Yes, my lord. That is.
28/11
It is
ವರೆಗೆ
for-
he
My lord, that
ಅಲ್ಲಿ
is for
ಕೊಟ್ಟಿದ್ದಾರೆ.
parole.
ಇದು the learned counsel for the petitioner ಇದರಲ್ಲಿ ಮೇಡಮ್ 82.1 ಅಲ್ಲಿ counsel for the petitioner submits that this application was filed long ago. In the interregnum, he has preferred another writ petition.
ನಂಬರ್ ಕೊಡಿ ಅದು.
Another writ petition
16435, my lords.
in
16435.
WP number so and the coordinate bench has granted parole. If that be so, extension of parole of any kind shall be sought before the same bench which has now granted parole. Yes, IA disposed accordingly.
ಅಲ್ಲಿ ಪ್ರಿಮಚರ್ ರಿಲೀಸ್ ಕೇಳಿದ್ದೀರಾ?
ಅಲ್ಲಿ ಏನ್ ಬೇಕಾದ್ರೆ ಕೇಳಿ.
No, my lords. The premature,
ಕೇಳಿಲ್ಲ ಕತ್.
that order may be.
ಇಲ್ಲಿ IA ಮಾತ್ರ
Yes,
ಇರುತ್ತೆ,
my lord.
ಅಷ್ಟೇ ಸಾಕು, ಎಲ್ಲ ಅಲ್ಲಿ ಕೇಳಿ.
My lords, the main petition was for premature release, my lords. It was not considered.
ಅದು ಅಲ್ಲೇ ಕೇಳಿ ಸರ್, ಅಲ್ಲೇ ಹಾಕಿದ್ರೆ
amend ಮಾಡಿ.
ಎಸ್.
My lords, earlier election, but it was correct, my lords. Within
Listen,
30
Manish,
days, he may be
I am not
considered.
holding GM.
Yes,
It
my
is
lords.
only on extension it has come here.
Yes, my lords.
Extension has become infructuous because you are already been released
Yes,
on
my lord.
parole. ಅಷ್ಟೇ, that's all the order. Yes.
That's,
Next
because
matter,
your lordship
82.
asked me to file an IA, that is why, that's the reason, and also I have filed an memo,
Correct,
my lords.
Siraj. Then ಆಮೇಲೆ ಅಲ್ಲಿ ಹಾಕಿದಿರಲ್ಲ
ಅಲ್ಲಿ
already.
ಹಾಕಿದ್ದೀನಿ, my lords.
ಅಲ್ಲೇ ಕೇಳಿ.
My lord, that
Justice
petition is
ಹೇಮಂತ್ ಅವ್ರ
disposed.
ಮಾತು ಕಷ್ಟನಾ?
My lord, that petition is disposed of, my lords. I have given granted for
ಅಲ್ಲೇ ಒಂದು extension ಹಾಕಿ.
extension, my lords. I am not asking for extension, my lords. I am asking for guidelines for direction for premature release, my lords. Because the similar matter is heard by this honorable court, my lords.
ಒಂದ್ ನಿಮಿಷ ಸರ್. Haphazard ಆಗಿ ಏನ್ ಬೇಕಾದ್ರೆ ಮಾಡ್ಬೋದು ಅಂತ. There is an IA for extension. I can pass orders on the IA ಅಷ್ಟೇನೆ. That IA is already spent itself because you already released on.
Yes, my lords.
If you want, you file another IA there or another petition there in GM jurisdiction.
My lords, my submission was that, my lord, because the main petition was on the premature release. This was disposed of by this honorable court. I understood what your lordship is telling, my lords. But my submission is that because the similar matter in the direction is given to the state government.
ಬರಲ್ಲ, then GM is not my court. Yes.
Your lordship, the other matter, 82.2,
ಹಾ,
he was
ಇದೇನು?
parole for 45 days. He, no, ಇಲ್ಲ ಸಮ್ ಇದ್ರಲ್ಲಿ there's a case being registered when he was on parole.
ಇದು ಪರೋಲ್ ಕೇಳಿದ್ದೀರಾ ಇದ್ರಲ್ಲಿ?
Premature release, my lords.
ಅಲ್ಲೇ ಹಾಕ್ಬೇಕು ತಾನೆ?
My lords, premature
ಅಲ್ಲೇ
release.
ಹಾಕ್ಬೇಕು ತಾನೆ?
ಅಲ್ಲೇ ಹಾಕದ್, my lord, because this case was, this honorable court was hearing on premature release, was supposed to pass guidelines on premature release. That's why I requested this
ಒಂದಿದೆಯಲ್ಲ,
honorable court to connect, my lord.
ನೋಡ್ಕೊಂಡು. ಇದು
But
ಅಷ್ಟೇ.
he is 23 years, my lord. So let
Po-
the
Post the ಅಲ್ಲೇ ಮಾಡ್ತಾರೆ, ಮಾಡಲ್ಲ, ಹೇಮಂತ್ ಸಾಹೇಬ್ರು ಮಾಡಲ್ಲ.
ಮಾಡ್ತಾರೆ.
Post the matter before the bench having appropriate roster. Yes,
So date may be given.
ಆಯ್ತು, Monday.
Monday.
Yes.
No, in that matter, this honorable court, your lordship had granted him parole for 45 days.
He is not sought extensions.
No extension. What has happened here is, he, when he was on parole.
ಅಲ್ಲೇ ಹೇಳಿ.
ಅಲ್ಲೇ ಆಯ್ತು.
Yes. Tuesday, sorry, Monday ಆಗಲ್ಲ, Tuesday, ಟೈಮ್ ಆಗೋಯ್ತು. ಮೂರು ಡಿಲಿಂಕ್ ಮಾಡಿ, ಮೂರನ್ನು ಅಲ್ಲೇ ಹಾಕಿ. ಎಸ್.
ಮೂರು, my lordship. 3 ಇಲ್ಲ, my lordship.
ಇದೊಂದು 82 ಮಾತ್ರ ಇಲ್ಲಿ.
82.
ಮಿಕ್ಕಿದ 2 ಡಿಲಿಂಕ್ ಮಾಡಿ ಅಲ್ಲಿ ಪೋಸ್ಟ್. ನೆಕ್ಸ್ಟ್
83.
7 ಏನೋ 13.
13.
No, my lords, 13(1)(a), my lord.
ಏನೀಗ ಅದಕ್ಕೆ?
Petitioner was working as Tahsildar Bangarpet on additional charge, my lord.
13(1) ಏನು ಕ್ರಿಮಿನಲ್ ಮಿಸ್ಕಾಂಡಕ್ಟ್ ತಾನೆ?
Committee was constituted to
ಹಾ.
regularize the land in favor of Srimati Munima, my lord. The committee regularized the land. Pursuant to the direction of the committee, being Tahsildar, I have granted the land, my lord.
File your objections.
I filed objection,
File,
Lord.
file.
The committee was headed by the son, who is the sitting MLA, and the applicant is the mother, and the sitting MLA has declared the asset in his declaration while contesting the election. And the application was filed seeking grant of the lands with the contention that she do not having any other properties. There are 50 more acres of land she is in possession, and she was not cultivating without conducting the spot inspection. The recommendation was made by the Tahsildar, and being the head of the committee, and sitting MLA has recommended for grant.
My lords.
And the son who declared this asset while in the election, this declaration saying that it's a property worth about 35 lakhs. And the application was filed by the applicant, the mother, saying that she was a BPL holder having an income at 15,000 rupees per year. And the beneficiary was the son who declared in his declaration.
Objections ಹಾಕಿದ್ದೀರಾ ಎಲ್ಲ?
I filed objection.
I am the Tahsildar, my lords. I cannot go against the committee's decision, my lords. I am the Tahsildar.
Committee is not, committee ಮೇಲೆ ಏನ್ ಮಾಡಿಲ್ವಾ? Members of the committee?
Committee, Lord, there
Complaint
are
is
the
against
accused.
only committee members, my lord. Complaint is
There
also
are,
not against me.
Complaint.
17 permission is granted against me also.
Yes, there are other accused also. The
Yeah.
spotting surveyor against the surveyor, my lord, and the village accountant, everybody is are accused in this FIR.
At any rate, I cannot be treated as accused, my lord.
Why
I am the Tahsildar, my lord.
So what?
He is the person who recommended to conduct a survey, and he is the signatory in the application. He was not conducted spots inspection. As per the allegation that was not in possession of the complaint, the applicant. They are not at all cultivating the land.
Bound by the direction of the committee.
All right, ಏನೋ ಬೇರೆ ಹೇಳೋದಿದೆಯಾ?
I'll file list of citation, my lord. In that case,
Please do.
please, ma'am. Please, ma'am.
Wednesday. Yes,
In the fresh matters, ma'am.
fresh matters list. Yes.
Interim order may be extended.
Interim order continues till that date. Next.
84.
84, 85 and 86, my lords. 13(1)(b).
13(1)(b). We'll take it on 27th, 27th, yes.
85 and 86.
13(1)(b) and 13(2). 13(2) is always common. Yes. Well, 27th, madam.
86.
So,
27th, yes. Heard the learned senior counsel Pramod Katave and ಹಾಕ್ಬಿಟ್ಟು ಆಮೇಲೆ list on 27th. Next.
Obliged.
80,
87.
87 ಹೇಗೆ ಹೇಳಿದ್ದು?
88.
For the petitioner, my lord. The previous date, my lords had passed an order, my lord. This is a case wherein, my lord, the
Doctor.
doctor.
Ah.
So court said, my lord, let the police conduct an inspection of the hospital records and find out whether actually
Where is the
surgery has
report?
taken place.
List the matter on Wednesday in the fresh matters list, the learned HCGP to secure the report directed to be filed after an inspection pursuant to the earlier order. Madam, ನೋಡ್ಕೊಳ್ಳಿ.
One
ಅದು check.
submission, my lord, one submission, my lord. Fourth, this honorable court granted no precipitative action to be taken against the petitioner in the garb of investigation.
ಏನಾಯ್ತು ಈಗ?
And subsequently, this honorable court said that the state shall secure the record of inspection on 25th September, my lord.
All right.
When the complaint went with the, I filed the objections with complete supporting documents.
All right.
He wanted, he went to the police station to IO, to Mimet IO to give all these statement, for taking his statement. Till now, he is saying there's a stay, I will not do anything unless until stay is vacated. There's absolutely no stay for investigation.
No, ask the IO not to play smart. The learned counsel for the petitioner submit despite
Respondent to my lord.
despite a direction, the second respondent submit despite a direction to conduct an inspection and no stay being granted in the case at hand. The investigating officer has not completed his investigation. Therefore, he shall be present before the court on Wednesday at 2:30 PM.
Grateful, my lord.
Investigation charge sheet file ಮಾಡಬಾರ್ದು next date ತನಕ. They will interpret it as we have to file charge sheet and immediately they'll might file charge sheet
Wednesday, don't worry.
for filing of report, my lord. This
No,
Wednesday, he shall be present. Don't worry, yes.
interim order to be extended, my lord.
ಯಾವ interim orders?
Not to take any precipitative action. against the
Precipitative
petitioner.
action. That
It is
is,
an interim order, my lord.
he's
And
taking
the
it
court,
as a
my lord,
shield.
also directed, place the case diary before the court, my lord. They have not placed, my lord. Then the court passed
Everything,
an
madam, get everything? Yes, next.
interim order till
Hey,
then.
ಅದಕ್ಕೆ ಇದು contradictory ಆಗುತ್ತೆ. Wait, nothing is going to happen. Yes.
89.
Grateful, my lord.
Fresh matter, man, fresh matter.
Fresh mat, ಅಲ್ಲ, 2:30.
2:30, yes.
DA case.
DA. 5th December, 5th or 27th?
27th.
27th, yes.
90.
DM.
Same date.
91.
Same date. Swami,
92.
Please, my lord. But, respondent number 12 is the husband of deceased, please, my lord. Petitioner is the father-in-law. But, my lord, he was working as a police sub-inspector at Begur police station.
I asked you to prepare a chart.
I have submitted it in the counter also, please, my lord. On
ಏನ್ chart?
27th September 2024, I filed a compilation along with the synopsis.
ಅಲ್ಲ, I asked you to prepare a chart of the lacunae in the investigation.
Yeah, that I have made it. In page number 5 in the compilation, please, my lord. And copy has been served to the
Which
state. authorities.
compilation, sir? Madam, ಯಾವ compilation ಕೊಡಿ ಇದು?
ನಮಗೆ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅವ್ರೆ, ಯೂನಿಯನ್ ಆಫ್ ಇಂಡಿಯಾ.
It was served to the state also. I'll
Nam-
furnish one more.
ಕೋರ್ಟ್
set
ಎಲ್ಲ ಕಾಪಿ ಇಲ್ಲ?
taken there.
There is.
ಯಾವತ್ತು ಫೈಲ್ ಮಾಡಿದ್ರಿ?
27 September 2020.
Madam, get it. ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಡಿ.
ಕೊಡ್ತೀನಿ.
Yes.
And especially medical report and medical evidence, it was not scrutinized in the charge sheet. That itself point outs how casually they have concluded the charge sheet.
20th in the fresh matters list.
Please.
Obligation.
File everything. Madam, get that
Obligation.
interim order granted earlier stands extended to the next date.
93.
Lots, all the matters from here on till the end, it is DA,
DA na? ಎಲ್ಲ 27.
till 99.
Please. 27.
matter, it was part, that is not listed.
ಪರವಾಗಿಲ್ಲ. ಅದು ಲಿಸ್ಟ್ ಆದಾಗ ಮಾಡೋಣ. ಈಗ ಇರೋದೇ ಸಾಕು, ಸುಮ್ಮನೆ
Obliged,
ಪ್ರಪೋರ್ಷನೇಟ್ ಕೇಸಸ್ ಆಗ್ಬಿಟ್ಟಿದೆ.
deeply obliged.
ಎಲ್ಲಿ ಅವರು ಮಹೇಶ್ 2:30 ಮೂಡ್ ತಗೊಂಡ್ಬಿಡಿ. ಒಂದ್ ನಿಮಿಷ ಮಹೇಶ್, 2:30 ಮೂಡ್ ಮ್ಯಾಟ್ರ್ ಇದೆ. 2:30 ಮೂಡ್ ಮ್ಯಾಟ್ರ್ ಸರ್.
May I make a request, my lord? ನಂದು ಸೀರಿಯಲ್ ನಂಬರ್ 34 ಇತ್ತು, ಬೆಳಿಗ್ಗೆ ನಾನು ಬೆಳಗ್ಗೆ ಏನ್ ಮಾಡಿದ್ವಿ 44 ಇತ್ತು.
ಯಾರು ಇರ್ಲಿಲ್ಲ?
ಮಧ್ಯಾಹ್ನ ನಾನು ಆ ಕೋರ್ಟಿಗೆ ಹೋಗಿ ಬರೋದ್ರೊಳಗೆ ರೀಚ್ ಆಗಿ
Nobody was there, so I granted 2 weeks time to file objection.
ನಾನು ಅದಕ್ಕೆ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿ ಅದನ್ನ ಫೈಲ್
ಹಾಗಾದ್ರೆ Monday in the fresh matters list.
ಅಲ್ಲ, ಇದನ್ನ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಒಂದು
overrule ಮಾಡ್ತೀನಿ. ಯಾರು ಇದ್ದಿದ್ರೆ ಮಾಡ್ತಾ ಇದ್ದೆ.
ಇಲ್ಲ ಇನ್ನು ಫ್ರೆಶ್
ಅಲ್ಲಲ್ಲ, ಯಾರು ಇದ್ದಿದ್ರೆ ಅವಾಗಲೇ ಓವರ್ ರೂಲ್ ಮಾಡಿ ಮಂಡೇಗೆ ಹಾಕ್ತಾ ಇದ್ದೆ. List on office objections overruled, list on Monday in the fresh matter. Heard the learned senior counsel ಅಂತ ಮಾಡಿ. Yes. 44 madam. ಆ ಮೂಡ್ ಮ್ಯಾಟರ್ ಕೊಡಿ ಮೇಡಮ್. ಎಷ್ಟಿದೆ? ಕೊಡಿ ಅಷ್ಟೇನಾ?
30 more matters, fresh matters, number 1, Vijay PK.
Lord, for the petition in this case, my lord. My lord, in this case, it's the invoice discounting issue. My lord, what happened was, the
Where did you
petitioner,
move it at 2:30?
lord, ಏನಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಅಲ್ಲಿ ಚಂಡೀಗಢ ಹೋಗ್ಬಿಟ್ಟು ಅರೆಸ್ಟ್ ಮಾಡಕ್ ಹೋಗ್ತಾ ಇದ್ದಾರೆ.
Yes, so ಅರೆಸ್ಟ್ ಮಾಡಬೇಡಿ.
Pending and-
ಹೋಗಿದಾರ ಆಲ್ರೆಡಿ?
What?
ಹೋಗಿದಾರ?
ಹೋಗಿ ವಾಪಸ್ ಬಂದಿರ. ಫಾರ್ಚುನೇಟ್ಲಿ ಫಾರ್ us, we are not there in the town ಅವತ್ತು.
ಎಸ್ಕೇಪ್ ಆಗಿದೆ.
ಎಸ್ಕೇಪ್ ಆಗಿದ್ದಿಲ್ಲ. They were traveling.
A copy may be served, your lord.
I'll serve a copy, my lord.
2:30 ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ರೆ ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಡಲ್ಲ.
ಅಲ್ಲ, my lord,
ಈಗಲ್ಲ, ಮುಂಚೆ ಇಲ್ಲಿರೋ ಕೌನ್ಸಿಲ್ ಸರ್ವ್ ಮಾಡ್ಬೇಕು.
I'll give this copy only, my lord. I'll have
I think
another.
I should stop granting entry models.
ಇಲ್ಲ,
ಅವಾಗಲೇ ನೀವು ಕೇಳೋದು.
ಇಲ್ಲ, my lord, sorry. My lord, ಇದು ಏನಾಗಿದೆ?
List the matter on Thursday in the fresh matters. Learned HCJP is directed to accept notice for the respondent. Emergent notice to the
My lord,
second respondent.
stay.
ಯಾರು? ಒಂದ್ ನಿಮಿಷ ಸರ್. Emergent notice to the second respondent. Till the next date of hearing, the respondent to police shall not precipitate the matter or take any coercive steps against the petitioner. Next. Ananda.
Number 2, Anand PV.
498 ಇದೆ and 302, my lord.
498 302.
Please,
ಮೂವ್ ಮಾಡಿದ್ ಯಾಕೆ?
matter is posted for charging, framing of charges on Monday, my lord.
ಕರೆಕ್ಟ್ ಆಗಿದೆ.
ನಿನ್ನೆ ಕೂಡ ಇತ್ತು, ನಿನ್ನೆ ಇದೆ, ನಾಳೆ.
498 302 ಇಂಟರ್ಫಿಯರ್ ಆಗ್ತೀನ ಸರ್ ನಾನು?
ಪ್ಲೀಸ್, my lord. ಇದ್ರಲ್ಲಿ ಏನೋ ಅಲಿಗೇಷನ್ಸ್ ಇಲ್ಲ.
ಅಯ್ಯೋ, ಆಮೇಲೆ
ಫಾರ್ ಮೂಮೆಂಟ್ ಪೇಜ್ ನಂಬರ್ 15, my lord, ಅದ್ರಲ್ಲಿ ನೋಡ್ಬೋದು. 15 ಅಲ್ಲಿ ಸೆಕೆಂಡ್
accused number 5.
ಪ್ಲೀಸ್, my lord.
ಏನ್ who are you in relation?
I'm the cousin sister of the husband.
ನಿಮ್ಮ ಮೇಲೆ ಏನಿದೆ?
ಏನೂ ಇಲ್ಲ ಸರ್.
ಹ?
ನಾನು ದಿನಾಂಕ 20/8/2023 ನನ್ನ ಅಳಿಯನ ಮೇಲಿನ ಕೋಪದಲ್ಲಿ ನನ್ನ ಅಳಿಯನ ತಂದೆ ಹನುಮಂತರಾಯಪ್ಪ, ನನ್ನ ಅಳಿಯನ ಅಕ್ಕಂದಿರಾದ ಜಯಶ್ರೀ, ಸುಶೀಲಮ್ಮ, ದಿಸ್ ಪಿಟಿಷನರ್, ಹಾಗೂ ಅಳಿಯನ ಸಂಬಂಧಿ ಮಮತಾ ಇವರುಗಳ ಮೇಲೆ ದೂರು ನೀಡಿರುತ್ತೇನೆ. ಆದರೆ ಇವರುಗಳು ನನ್ನ ಮಗಳಿಗೆ ಯಾವುದೇ ಮಾನಸಿಕ ಮತ್ತು ದೈಹಿಕವಾಗಿ ಹಿಂಸೆ ನೀಡಿರುವುದಿಲ್ಲ. ಹಾಗೂ ನನ್ನ ಮಗಳ
Who has killed her, sir?
ಮೇಲ
Who has killed her?
ಪಿಟಿಷನರ್
Husband.
accused number 1 and 2.
1, 2 and 3.
1 and 2 only.
2 ಯಾರು?
Mother in law.
3 ಯಾರು?
3 is the sister of the husband. This
Your
petitioner is
sister-in-law
in-law,
of the husband.
husband.
ಕಾಪಿ ಕೊಟ್ಟಿದೆ. ಕಾಪಿ ಕೊಡಿ ಈಗ. ಮಂಡೇ ಇನ್ ದಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್.
ಮಂಡೆಗೆ ಇದೆ ಚಾರ್ಜಸ್ ಇದೆ.
ಇರ್ಲಿ ಬಿಡಿ ಅದಕ್ಕೆ. ಮಂಡೇ ಇನ್ ದಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್. ಎಸ್. ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆದ ತಕ್ಷಣ ಕನ್ವಿಕ್ಷನ್ ಅಲ್ವಲ್ಲ. ನೆಕ್ಸ್ಟ್.
Number 3, Murali N.
Hearing for the petitioner learned senior counsel, my lord. D.R.
I am
Ravishankar.
seeing myself very ಯಾರಿಲ್ಲ.
Lord, he is online, my lord. Senior counsel, D.R. Ravishankar.
ಏನ್ ಅರ್ಜೆನ್ಸಿ ಏನು?
Lord, the police, my lord, are at my doorsteps, my lord. Notwithstanding, my lord, I have obtained the bail order.
ಮಾಡಿದ್ಯಾ?
Entry model law.
ಮತ್ತೆ
In a previous, my lord, your lordships may kindly come to page number 39. In a similar set of facts, my lord, lordships have passed an order. Page number 39, my lords. Pursuant to this, she files, my lord, the de facto complaint, my lord, is my brother's wife.
Take this petition along with writ petition 3464 of 23. List them both on Tuesday in the fresh matters list. Till such time, the police shall not harass or take precipitative action, harass, take precipitative action or any coercive action against the petitioners
Concerning to this crime number again,
concerning the subject crime.
please.
Copy may be.
Yes, copy kudi.
Number 4, P. Ravishankar.
Proceedings under 138. Part payment of the debt is made after the check was drawn, but before it is
Petitioner to serve the counsel who represents the respondent in the trial proceedings and file an acknowledgement. Till such time further proceedings before the and acknowledgement list the matter on 4th December. till such time further proceeding shall remain stayed.
Grateful.
ನಾಳೆ judgment ಇದೆ ಅಲ್ವಾ?
Monday. Grateful.
Number 5. Sir, Basavara. Shankar Basavara.
I'm ready to repay 20% of the amount.
Deposit before the concerned court.
No, I have got a DD
ಎಲ್ಲಿಗೆ?
in favor of Karnataka High Court Registrar of General.
The learned petitioner holds in his hand a demand draft of 20% of the check amount. The same be deposited before this court, before the registry of the, before the registry by the, in the next 48 hours, the 48, but next 72 hours. In the light of the said circumstance, there shall be an interim order of stay of the order. LBW na?
FL.
There shall be an interim order of stay of a fine levy warrant that is hanging on the head of the petitioner. Yes, next. Kalyan,
Page number 20.
40?
20. My lord, the appeal filed, the criminal appeal is dismissed for non-prosecution.
ಈಗ ಏನಾಗಿದೆ?
Now, my lord, subsequently, NBW is issued, my lord, page number 30.
List the matter on Wednesday in the fresh matters list. The warrant hanging on the head of the petitioner shall remain stayed.
Please, much.
Next.
There is one
ಅದ್
more
notice
matter.
ಮಾಡದ್ ಬೇಡ. We'll close it next date.
Please.
Mayur,
7. C. Manjuna.
oh sorry, withdrawal, yes.
Memo.
Memo idea?
Memo is
Yes. Files a memo for withdrawal, withdrawn.
8. Mayur D. Bhan.
Additional months. Malad, I'm on the ground of parity, Malad. It's already quashed insofar as accused number 20.
Why did you move it at 2:30, sir?
Malad,
Why did you move it for 2:30?
Malad, the warrant was pending against all of them, Malad. 51 of the petitioners, Malad.
NDPS, sir.
Out.
ಬೇರೆ ಯಾರು
After taking cognizance, Malad.
Lordship has,
R3 ga?
last time Lordship has recalled the NBW and allowed the petition.
Plus A23 and A69 is already quashed.
Where are those orders?
Malad, I'm producing now. Malad. After taking cognizance, Malad, without issuing summons, warrant came directly issued.
Same order,
Satyendra Kumar until.
same order.
Tarsem law. Malad.
Tarsemgal, following until.
Kindly.
We'll dispose this also.
Same order.
Petitioners are co-accused in crime, in special case 741 of 2024. Where two of the accused, this court in writ petition 29510 of 2024 disposed on 4th November 2024 has held as follows. Since the petitioners are co-accused, it would inure to the benefit of the petitioners as well for the aforesaid reason, for the reasons rendered in the said writ petition. Operative portion, repeat ಮಾಡ್ಬೋದು. Following God, yes.
Oblige.
Hand delivery.
Hand delivery ಈಗೆಲ್ಲ ಮಂಡೇ ತಾನೇ ಇರೋದು.
Monday ಇರೋದು.
ಎಬೋಸ್ ಮಾಡಿಸ್ತೀನಿ.
Great.
This order may be uploaded today, Malad.
No, sir.
ನಾಳೆ ನಾಡಿದ್ದು ರಜಾ ಇದೆ ಸೋಮವಾರ.
This order cannot be uploaded. It's a final order.
Kindness.
ಏನಿದೆ documents? ಇದಾರ?
One submission. Say number 31 ಅಲ್ಲಿ. There is an interim order to not to take coercive steps.
ಯಾವ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಅದು ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿರುತ್ತೆ.
ಅದು ಹೇಳಿರಲಿಲ್ಲ ಅದಕ್ಕೆ. I did not make submission at that time.
ಇದ್ರೆ ಅದು ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿರುತ್ತೆ.
Say number 31.
Correspondency.
Previous order ಅಲ್ಲಿ there was order passed by this court that not to take any courses because the
That
police
will,
will harass.
in furtherance of the order, ಆಯ್ತಲ್ವಾ? In furtherance of the order ಅಂತ ಮಾಡಿಸಿ.
Matter pertaining to Dharwad bench, seal number 1.
Withdraw ಇಲ್ಲ.
I am for the petitioner.
2 ಏನು?
Seal number 2, Gauri Shankar Mose.
I am for the petitioner, my lord.
ಎರಡಕ್ಕೂ for petitioner ಅಂತ.
Sir, sorry, my lord, sir, only for 2 minutes. Serial number 2. Offense 3 and 7 of EC Act, my lord. Already with respect to accused number 1, 2 and 8, the case has been quashed, my lord.
Madam, page 156, same order. Yes.
Much obliged, sir.
ಇದು ಇದೆಯಾ? 15th ಹಾಕಿ.
Section 15.
So concurrent finding of the.
Wait, ಮಾಡಿ. ಅದರಲ್ಲಿ they are not, his conviction orders are not passed in a single trial. They are different trials,
3 different.
correct? If there are 3 different trials, it cannot run concurrently, it will run consecutively. That's the whole problem.
But arising out of a single transaction and ಅದ್ರಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ
Transaction ಒಂದೇ ಇರ್ಬೋದು, 3 different trials. One cell is on a different footing.
page number 18 of the judgment passed with the trial court itself, the judgment records us because of the technical issues.
Because of that, I have asked it to be posted on being spoken to on Monday. Clarify ಮಾಡಿ ಅಷ್ಟೇ. I'll give you the judgments which are to be seen by you before clarifying it. Not today, Monday ಬೆಳಗ್ಗೆ ಕೊಡ್ತೇನೆ. Monday ಸಾಯಂಕಾಲದೊಳಗೆ we'll do something. ಕಲ್ಯಾಣ್ ಇದೇನು?
Same identical man.
ಸೀರಿಯಲ್ ನಂಬರ್ ಏನದು?
Serial
ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಆ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದೆ ಅದೇ ಈ ಲಿಸ್ಟ್ ನಂಬರ್ 3 ಅಲ್ಲಿ ಒಂದ್ ಮ್ಯಾಟರ್ ಇದೆ ಈಗ ಬಂದಿರೋದು. ಸೇಮ್ ಆರ್ಡರ್. Asked over. Yes.
Chief, kindly, morning I had moved a memo for 2:30 list here. It's not been listed
Monday. It will come on Monday.
because please.
Yes.
I will not take much of your lordship's time on this.
You can take, sir. I am
Because
free.
there is no res integra, my lord, because the matter is covered.
Madam. New word.
My lord, there is a technique called as control delivery, my lord. When a parcel comes.
There's one judgment of Justice Hemant Chandan.
I have got it.
ಕೊಡಿ.
Sir. Pagination ಮಾಡಿಲ್ಲ, my apologies.
ಇರ್ಲಿ ಹೇಳಿ. ಇದೆಲ್ಲ ಕಂಟ್ರೋಲ್ ಡೆಲಿವರಿ ಇದೆನಾ?
ಅದು ಒಂದು control delivery. ಇನ್ನು ಬೇರೆ ಎಲ್ಲ 50A mandatory, which your lordships also held. And I am trying to try a parallel that 50A is also mandatory, where my learned friend the other day said that no, because it says may. That I would interpret, my lord.
Yes.
Hello. I will take your lordships to section 50A itself. Before, then I will point out as from the facts maps. Section 50A.
NDPS ಕೊಡಿ.
Hanumantu Nimda, first ಹಾಕಿರೋದು. There your lordship in this first judgment, your lordship held that 50A is mandatory. Sorry, 50 is mandatory. So drawing support from that, my lord, I would propound that 50A is also mandatory. 50A, the Director General of Narcotics Control Bureau constituted under section 3 of the 4 or any other officer authorized by him in this behalf. Pausing here for a moment, my lord, therefore authority is a must. May, notwithstanding anything in the act, undertake control delivery. So this may, my lord, is the choice of the officials, whether they take control delivery or not. So this may cannot be imported that the authorized officer should be any person. No, that is what they are trying to propound. There I want to distinct that this may is the discretion of the official to undertake control delivery or not, my lord. So the connotation may is to be
strictly considered only so far as that is concerned. Therefore, my lord, the officials, as per section 3 or 4, is a must. And section 4, my lords.
Hmm.
Four, 3.
Hmm.
The central government may, if it considers it necessary or expected so to do for the purpose of this act, by order published in the official gazette, constitute an authority or a hierarchy of authorities by such name or names as may be specified in the order for the purpose of exercising such powers and functions of the central government under this act, and for taking measures with respect to such matters referred to in subsection 2, as may be mentioned in the order, and subject to the supervision and control of the central government.
You are alleged of consumption?
No,
Huh?
I am alleged that
Hmm.
I financed at the most, even that is not also very clear. The gist is this, my lord. Parcel comes to post office and a dummy delivery is delivered to A3.
Dummy delivery.
Dummy delivery. That is control delivery in other words.
All right. Hmm.
So this dummy delivery, A3 says, no, it is not mine.
Hmm.
A2 told me to furnish the address. They go to A2, petition before your lordships. The A2 says, no, it is not mine, A1. A1 67 very clear says, no, no, it is mine only. It is not either A2 or A3. It exclusively belongs to me. So he owns the responsibility in 67 minutes. So in that way, he exonerates. Even in the moment, for the moment, if you consider, no, he cannot exonerate co-accused. If we say, hold that, my lord, then financing. That is also not very clear. And at the most, they may say it's whether it amounts to financing to procure or not. It may come within the purview of trial. That I will not pressurize your lordship's offers, that is concerned. Now, strictly, of course, Riya Chakrabarti case is very much clear that finance means there should be very clear-cut proof beyond all reasonable doubt, prima facie, that this money exclusively went for financing that. Here, sala kotte vapas dudu korta ide anta ide. A1 very clearly says. And A2 does not know for what purpose A1 has taken the money. Merits wise, it is there, my lords, which I can always submit. And coming back, my lord, 250A, control delivery. The officials, authorized control delivery has to be taken by the authorized person. Otherwise, it is it is violative of that, my lord. And it draws a parallel to section 50. Section 50, my lord. When any officer duly authorized under section 42 is about to search any person under the provisions of section 41, etc., my lord. That I will not proceed. I only stop at this. When any officer duly authorized on section 42. So officer duly authorized is a must, my lord. And today, my lord, wise I was trying to find out a Karnataka Pollution Control Board matter. In that matter, my lord, your lordships have passed one judgment saying that Karnataka Pollution Control Board official does not file a complaint in a proper manner.
Correct.
And your lordships was pleased to quash it. So drawing parallels from that, complaint from the authority, authorized person is a must. It is a must. Violation of it is fatal to the prosecution. Now, my lord, keeping this in view, my lord, I request lordship to turn to page number 48 of the petition, which is the private complaint file. Complainant is A.
Yes.
Please, ma'am. Para 3. An information was received by Shri P. Shivarao, intelligence officer, NCP.
Objections lo hota idira.
Illa, non petition.
Petition. Again, madam. What is this? Charge sheet
That's
material.
the
Charge sheet.
complete charge sheet that did not.
That I will refer to later.
What?
Only
Marrow?
2 witnesses I will refer.
Ganja, na?
It's
Blots.
Blots. LSD.
LSD blots. May, my lord?
Yes, sir.
An information was received by P. Shivarao, intelligence officer, NCP, unit on 26/23 at 10:30 hours that one speed post parcel bearing number so-and-so sent from Coimbatore destined to Marthali Colony Sub Post Office, Bangalore, Karnataka is suspect to be containing drugs concealment in the above said parcel. The said parcel is expected to reach the post office on 26/23. The information was submitted in typewritten as per 42 of NDPS, 2 students of NCP Bangalore pro forma on the same day, who in turn directed P. Shivarao, interest of to constitute a team and to operate it lawfully. A copy of the opposite information was also submitted to the Superintendent of Police NCB Seal 1 was also issued to Shri Pure of IO. As per directions, NCB teams reached Marthali sub post office on 26/23 at around 14:30 hours. Then Shri P. Sirao IO approached the postmaster Marthali post office Bangalore and introduced himself and revealed the information received by him. Further, Shri Pivara IO gave written request to postmaster requesting her to hand over the parcel to him. Srimati Pentam Aparna, postmaster informed Shri Shivara IO about the receipt of parcel at Marthali Colony Post Office. She also introduced C. Deepalakshmi, postal assistant of the same post office. Then Shivara IO revealed the information received by him to Srimati Deepalakshmi. Then the NCP team requested both of them to be independent witnesses for the entire proceedings, for which Srimati Pentam Aparna and Srimati C. Deepalakshmi agreed. And they were given a notice in this regard. Both of them received and they have acknowledged by putting their signatures of the said notices. Thereafter, the postmortem was requested to produce and hand over the speed post parcel bearing number so and so for examination by NCB team in the presence of independent witnesses. The suspected parcel number so and so was placed before the NCB team for further examination. The speed post parcel bearing number so and so was taken for examination by the NCB. It was a parcel of green colored envelope. On examination of the
All right,
parcel.
Mahesh, we'll continue on Tuesday,
Very well.
4 PM.
Tuesday. Well, very well.
Tuesday, 4 PM.
Obliged.
Heard the Learned Counsel, Mahesh is appearing for petitioner and Sridevi Bhosle to hear them further, list the matter on Tuesday at 4 PM for the hearing.
Grateful.
It's 4 PM, 4:30, yes, 15-20 minutes.
That's
Then
not
Yashwant
bad.
Beg,
Not
madam.
take-
Lords, I need more time because Lords, the charge sheet indicates incriminating material. I have to read out those materials.
All right.
No, my request is,
I need.
as I submitted, I will not go into the merits of the case. After having argued for last 30 years, I will not get into that. I know it's a matter for trial. My only request is 50A letter,
Lords,
Done.
50A, I would.
So you're only on 50A
bind of 50A and financing. That's apart from, I will not
and
argue.
financing.
That's all.
Concentrate on that.
Only too much.
My lords, may I submit this? 50A, my lords, as I have already submitted, my lords, it is not mandatory, my lords. It's a directory provision.
That I will consider,
Yes,
that's
my
all.
lords. As learned senior himself submitted that,
Mm.
if at all it is undertaken, it has to be in a proper channel, my lords. In my case, we have not undertaken control delivery because it was optional for the investigating officer whether to take it or not to take it. It was his discretion.
All right.
All the
And
better for.
insofar as it is not only financing, my lords, they had procured several parcels, they have consumed it, they have imported, they have purchased, sold, they have been selling it. I will. I'll
Merits,
not-
I will not get into it, as I submitted. To shorten the time also. I'll not get to it.
Tuesday,
Obvious.
yes, 4:15 PM on that.
In fact, the judgment of coordinate bench on 50A, my lords, is because, my lords, there was nothing else other than the voluntary statement, my lord. That is where, my lords, the coordinate bench holds, my lords. To corroborate that, there has to be 50A, that process that should have been undertaken by the respondent.
Justice Hemant.
I would.
That is
Justice Hemant.
Justice Hemant.
64 ಆಗೋಗಿದೆಯಲ್ಲ
Your lordship documents ನಾನು ನೋಡಿದ್ದೆ. I was about to argue and my brother didn't see the.
64 ಯಾವ್ದು?
2 minutes, your lordship.
ಯಾವ್ದು 64?
64, serious, list 1, 2, list 1, list 1.
In their absence, nothing doing.
Your lordship,
Don't
wait.
develop this practice. In the absence of the respondent, you want to argue?
I just wanted.
No,
date,
no,
your lordship.
nothing.
Your lordship documents ಇದೆ ತೋರ್ಸಕ್ಕೆ.
Ondsari Sirajuddin, ondsari ನೀವು, what is all this?
Your lordship, I was about to argue and he did not see the file, your lordship. 2 documents, 2 minutes, your lordship.
But no, not in the absence of somebody else,
Your
madam,
lordship, I'm
never.
Your lordship, just a date, your lordship.
Yes.
Just a date, your lordship.
Disposed of.
Your lordship, your lordship, it's a good case, your lordship, just 2
No,
minutes, your lordship.
Yes.
Your lordship, the transaction.
That's the one you have not cooperated, army officer.
Your lordship, transaction, mutual, first was mutual divorce, your lordship. Transaction ide, your
I
lordship.
am not on
we
that.
have a
I have given
document.
you liberty. Ashte, nothing else. Yes.
ಮೇಡಮ್ ಧಾರವಾಡ ಬೆಂಚ್ ಏನಾಯ್ತು? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಧಾರವಾಡ ಬೆಂಚ್ ಏನಾಯ್ತು?
ವಾಲ್ಯೂಮ್ ಕೊಡಿ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಧಾರವಾಡ ಬೆಂಚ್.
Last video conference on the memo for withdrawal.
15th.
101,771. This was it, no?
ಅಲ್ಲ ಅದು ಡೇಟ್ ಹೋಗುತ್ತೆ ಬೀಯಿಂಗ್ಸ್ ಅಂತ ಮಾಡ್ಕೊಂಬೇಡ ಮತ್ತೆ ಲಾಜಿಕ್ ಹಂಗೆ ಹೇಳಿದ್ರು.